Ms. Kippenbrook, I just got a notification that it's being live streamed. Does that mean that the YouTube is now live?
Yes, it is.
Kippenbrook, I just got a notification that it's being live streamed. Does that mean that the YouTube is now live?
Yes.
Okay. And I'm hearing an echo. Okay, not anymore. All right, Ms. Gonzalez, we are ready to go on the record.
Okay.
Good morning, everyone. The time is now 9:08 a.m. This matter before the New Mexico Public Regulation Commission will please come to order. This is a time and place set for the evidentiary hearing and potential oral argument responsive to the Commission's March 11th, 2026 order directing joint applicants to show cause. This hearing is a part of docket number 25-00060-UT, but is not the hearing on the merits of the proposed acquisition. Today's proceeding is strictly limited to factual evidence and legal argument responsive to the Commission's order directing joint applicants to show cause. My name is Jocelyn Barrett. I'm the Chief Hearing Examiner for the New Mexico Public Regulation Commission. Joining me today are co-hearing examiners Patrick Schaefer, as well as a representative from our Office of General Counsel, Erin Lecoq. This hearing will be conducted in two parts. The first, cross-examination of fact witnesses, and the second will be a brief Supreme Court-style oral argument in which the attorneys for joint applicants and Prosperity Works, as the movement and respondent to the original motion for order directing joint applicants to show cause that was filed by Prosperity Works, will participate. The purpose of this dual hearing is to allow the hearing examiners and the Commission to both ask fact questions of fact witnesses and legal questions of the attorneys, as this matter is largely focused on interpretation of a New Mexico statute, which is a legal question. The hearing today is being transcribed by our court reporter, Ms. Gonzalez, and it is also being live streamed for the public on YouTube. The attorneys will be considerate of the court reporter and not speak over each other or do anything else that could compromise her creation of a clear record. The attorneys will also remember that the YouTube continues to stream during breaks. The only time the YouTube stream will be stopped is if we have to go into closed portions of the hearing in the event that it is necessary to discuss confidential information. If that happens, the YouTube stream will be stopped only for that portion and will be started immediately after, as this is a public hearing and the public interest in and access to this hearing is paramount. The parties who will be participating in cross-examination are joint applicants, Prosperity Works, representatives from the legal division of the New Mexico PRC, New Mexico Department of Justice, New Energy Economy, and the Center for Biological Diversity. I'm going to go ahead and have the attorneys for those parties enter their appearance first, starting with joint applicants.
Madam Hearing Examiner, this is Brian Haverly, and with me today is Tom Domi of the Kelleher Law Firm in Albuquerque. Also with us is Anna Rotman and Robert Gooden of the Kirkland & Ellis Law Firm on behalf of Troy Parent Co. LLC.
Good morning.
Good morning, Your Honors. This is Ray Gifford of the law firm Wilkinson, Barker & Nauer. Also appearing with me today will be Debria Terwilliger of Wilkinson, Barker & Nauer. We're representing PNM Resources in this matter.
Good morning.
Morning.
Anyone else who needs to enter an appearance on behalf of joint applicants? Hearing none. Legal division for the New Mexico PRC, please enter your appearances.
Gideon Elliott for the legal division of the NMPRC.
Good morning.
Good morning.
New Mexico Department of Justice.
Good morning, Madam Hearing Officer. Billy Jimenez for the Mexico Department of Justice. With me this morning is Alethea Allen and Mark Hayden. Thank you.
Good morning. I accidentally skipped Prosperity Works. Please enter your appearance.
Thank you, Madam Hearing Examiner. Stephen Michael and Carol Lynch for Prosperity Works.
Good morning. New Energy Economy.
Good morning, hearing examiners and colleagues. My name is Marielle Nanasi. I represent New Energy Economy.
Good morning. And then Center for Biological Diversity.
Good morning, Madam Hearing Examiner. Jean Sue, Labrin Johnson, Howard Crystal, and Gail Evans on behalf of the Center for Biological Diversity. Thank you.
Good morning. There are other parties to the broader acquisition matter that are present today, and I would ask those representatives who wish to enter an appearance to do so in an orderly fashion. Therefore, I will read off of our service list. If there is an attorney or an attorneys here on behalf of that party, enter your appearance when prompted, please. I do want to note for the record and for the public that attendance was not required by any of the parties other than those who are actively participating. So the absence of any party in entering an appearance doesn't indicate that they've done anything wrong or they're not actively participating in the broader matter that's under advisement. So I'm going to start with Albuquerque Bernalillo County Water Utility Authority.
Good morning, hearing examiners, colleagues. Keith Herman on behalf of the Albuquerque Bernalillo County Water Utility Authority.
Good morning. Board of County Commissioners of Bernalillo County. We already did them. City of Albuquerque.
Good morning, Brian Rowland on behalf of the City of Albuquerque. Also in attendance is Charles Davis.
Good morning. Coalition for Clean Affordable Energy.
Good morning, everyone. Charles DeSalen representing Coalition for Clean Affordable Energy. Also present is Carol Lynch. Thank you.
Good morning. Coalition for Community Solar Access. The entities that have been described as the community groups, and if you'd like to state which group you're representing, that's fine.
Good morning. Rose Rushing on behalf of community groups, Dene Care, San Juan Citizens Alliance, Tonajoniane, and NEVA.
Good morning. The Energy, Minerals, and Natural Resources Department.
Good morning, hearing examiners, colleagues. This is Christopher Hall on behalf of the Energy, Minerals, and Natural Resources Department.
Good morning. Interwest Energy.
Joan Drake on behalf of Interwest Energy Alliance.
Good morning. Kroger. Laborers Union Local 16.
Morning, Mava Lore on behalf of the laborers.
Good morning. New Mexico Consumer Protection Alliance. We already did New Mexico Department of Justice. New Mexico.
Sorry.
Go ahead, please.
I did see the attorney for the Consumers Alliance.
Yes, I'm here.
Okay.
Sorry. Good
That's
morning,
okay.
hearing examiners, Barrett and Schaefer, and counsel Jane Yee on behalf of New Mexico Consumer Protection Alliance.
Good morning.
Good morning.
NM area.
Good morning, colleagues. Good morning, hearing examiners. Kelly Gould for New Mexico Affordable Reliable Energy Alliance, NM area.
Good morning. Renewable Energy Industries of New Mexico.
Good morning, all. I thought it was muted. Good morning, Stephanie Zer for REI-ANM.
Thank you. Walmart. I actually see Ms. Clark in the waiting room, but I believe she doesn't wish to. If anyone on behalf of Walmart would like to enter an appearance. And finally, Western Resource Advocates.
Yes, Your Honor. Julie Clark on behalf of Walmart.
Ms. Clark in the waiting room. I'm sorry, I'm getting an echo. I believe she doesn't wish to. If anyone on behalf of Walmart would like to enter an appearance.
Yes, this is Julie Clark on behalf of Walmart.
And finally, Western Resource Advocates.
Sydney Beatles. Yes, Your Honor. Julie Clark on behalf of Walmart.
Ms. Clark in the waiting room.
Excuse me, everybody. This is Hearing Examiner Schaefer. I believe somebody has their YouTube stream on at the same time. Could you please, anybody who's on this call,
yes, this is Julie
please turn off the YouTube stream? Thank you.
Sydney Beatles for Western Resource Advocates. Good morning.
That seems to have taken care of it. Yeah, because there are so many participants, if you're not actively speaking or one of the hearing examiners or the court reporter, please keep yourself muted because that kind of cross noise happens very easily. So thank you. And I believe we went through the entire list. I will note that there are others in attendance on the Zoom who are here to observe. So if you're seeing more squares than those who entered appearances, that's why. Moving on, there are procedural matters that need to be addressed before we begin the evidentiary portion of the proceeding. First, a motion was filed late yesterday by joint movements. The motion was titled Unopposed Joint Motion to Reconsider regarding the hearing examiner's procedural decision to limit cross-examination to the parties who filed pre-hearing briefing and testimony for this show cause hearing. The motion is denied. The parties may consider this a verbal ruling on the motion that will be followed by a written order that will be filed into the docket on this matter. In the interest of ensuring that the parties who oppose the procedure for today's hearing are heard and their objections are properly preserved, I am giving any party who did not already preserve their objection by signing onto the motion that was filed yesterday, but who wishes to object, an opportunity to state their objection for the record. Any party present who entered an appearance can lodge an objection, though as we discussed earlier, this is not the time for argument and I will not entertain speaking objections. Please raise your hand in the Zoom if you would like to state an objection for the record, and I will call on the parties one at a time to do so. Mr. Herman, I'm not sure why your hand is raised as you were given an opportunity to object through the motion that you filed yesterday, but please proceed.
Thank you, Madam Examiner. This is just how you intend to conduct this hearing. I intend to object to the admission of all testimony. That would be Don Terry, Sebastian Sherman, Sudine Kelly, Ron Binns, and Bruce Throne, because the commission rules dictate that objections need to be made at the time that evidence is admitted. 1.2.2.35L, as in Lobo. So if you don't want me to object at the admission, I would like to make a standing objection and request a variance from that provision.
Your standing objection is granted. Or your option to
my request for variance.
Your request for variance is granted. Your standing objection is noted and overruled, but has been preserved for the record. Ms. Beatles.
And thank you. Does that apply to all joint move-ins?
Would the joint movements like it to apply to all joint movements?
WRA would. Thank you.
Ms. Gould?
Yes, and Amaria has the same objection. Thank you.
Any of the other
so
joint movements?
Madam Examiner, or I'll give the Protection Alliance opportunity to speak.
Ms. Yee? Ms. Yee, you have your hand raised, but you're also muted.
Thank you, Hearing Examiner Barrett. On behalf of New Mexico Consumer Protection Alliance, I would also like to make a standing objection similar to the Water Authority and the other parties stating their objections right now.
Thank you. Mr. DeSalen?
Coalition for Clean Affordable Energy makes the same objection. Thank you, Madam Hearing Examiner.
Thank you. Is there anyone else who wishes to make this similar statement for the record? Mr. Herman, you were about to speak.
I was just going to also request or reserve the right to provide an offer of proof and briefing.
Yes, sir, that'll be fine. The objections, the standing objections are noted for the record. All objections are overruled, but have been noted for the purposes of the record. Moving on. The next order of business is joint applicants' motion to strike response testimony and exhibits of Bruce Throne on various grounds. Mr. Throne is the expert witness for New Energy Economy and Center for Biological Diversity. The joint applicant's motion to strike Mr. Throne's testimony is denied with one exception. Joint applicant's motion to exclude the deposition transcript of Joseph D. Terry, which was attached as an exhibit to Mr. Throne's testimony, is granted. Mr. Terry is available for live cross-examination today, and his deposition transcript does not fall under any recognized hearsay exception under the New Mexico law. His deposition transcript may be used for the purposes of impeachment during the examination, but shall not be cited for the truth of any matters therein. New Energy Economy and Center for Biological Diversity will file amended testimony without this exhibit by close of business tomorrow, May 1st. And similar to the last ruling, this verbal ruling will be followed up by an order filed in the docket. Moving on. The participating parties have agreed to both an order of witnesses and cross-examinations for the evidentiary portion of the proceeding. We've gone over much of that off the record, and we will proceed by those directives that have been agreed upon. The essential procedural elements of the oral argument portion of the hearing have also been discussed, but we'll explain those again this afternoon as that portion of the hearing gets closer. We will take a morning break, a longer lunch break, and at least one break this afternoon. We will also take any other breaks that are required by our court reporter. As indicated at the pre-hearing held earlier this week, joint applicants will present their fact witnesses first for cross-examination. And if there are no other procedural matters that need to be discussed, we will go ahead and start the evidentiary portion of this hearing. Hearing no one, joint applicants, you will please call your first witness.
Thank you, Your Honor. Joint applicants call Joseph D. Terry.
And who will be doing the direct examination for Mr. Terry?
I will, Your Honor, and the witness is ready to be sworn.
All right, Ms. Gonzalez, will you please swear in the witness?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Thank you. Good morning, Mr. Terry. Good morning. Do you have in front of you what has been labeled Joint Applicants Exhibit 1, entitled Direct Testimony in Response to Show Cause, Order and Exhibit of Joseph D. Terry?
I do.
And is that the pre-filed testimony that you offered in this show cause matter?
Yes, it is.
Was that testimony prepared by you or under your direction?
Yes, it was.
And do you have at this time any corrections to that exhibit?
Yes, I do. JA1, page 28, line 15. We changed per to or.
Thank you, Mr. Terry. Any other corrections?
No, sir.
And I will note for the record, Your Honors, that we have uploaded the corrected version into the Dropbox.
Thank you.
Mr. Terry, if I were to ask you the same questions in this exhibit today, would your answers be the same?
Yes, they would.
Your Honor, I offer exhibit JA1 for admission.
Aside from the standing objections that were already noted on the record, does anyone else have an objection to the admission of Exhibit 1? Hearing no further objections, the exhibit is admitted.
Thank you, Your Honor. The witness is available for cross-examination.
Thank you, sir. According to my notes, first up for cross-examination of Mr. Terry, and correct me if I'm wrong, will be Prosperity Works. And you have reserved 20 minutes for cross-examination of this witness.
Yes, thank you, Madam Hearing Examiner. Good morning, Mr. Terry.
Good morning. How are you doing today?
I'm good. Could you turn to page 3 of your testimony, please?
I am there, sir.
Okay. And at line 4, you used the phrase financing transaction in your testimony to refer to the Topco stock purchase, right?
Yes, I do.
Okay. And is it correct that you and the other joint applicants only started using the phrase financing transaction to refer to the stock purchase after the show cause motion was filed?
I'm not aware of that, no.
Okay. Do you recall using that phrase in any of the filings with the commission? to refer to the stock purchase prior to the show cause motion?
I don't know.
Okay. Would you accept, subject to check, that in your entire 721-page application, the phrase financing transaction or financing transactions appears only once and not in reference to the stock purchase?
Subject to check, sure.
And would you also accept, subject to check, that the phrase stock purchase or stock purchase agreement appears over 70 times?
Subject to check, I'm subject to check, sure.
Okay. Now, could you turn to page 18, please?
I'm there, sir.
No, I'm not, so give me a second. Okay. At lines 15 through 18, you seem to accept that an acquisition of 10% or more of the common stock of a company represents a presumptive finding of control. Do you agree with that?
I do.
Okay. And it's true, isn't it? Is it not that the Zimmer and Topco stock purchases together represent 11% of the common stock of TXNM, give or take maybe a couple tenths of a percent?
I think the Topco transaction was about 7.5%, and the Zimmer transaction, which is a separate transaction, was 3.4. So I think if you do the math, it's around approximately 11%.
Okay, thank you. And in both those purchases, the TXNM Board of Directors was able to direct, I'm sorry, in both those purchase agreements, there's a provision that provides for the TXNM Board of Directors to be able to direct how those shares, 11% of the common stock, would vote. Do you agree with that?
For each one of those separate transactions between Topco and Zimmer, there was a voting restriction put in that allowed the board to do that. And there's reasons why you do that.
Okay, so collectively between those two agreements, the board obtained the right to direct the votes of 11% of TXNM's common stock. Is that right?
The board had the authority to do that. The board, as it sat before and as it sits today, has control of TXNM altogether anyway.
Subject to being removed or changed by the shareholders, right?
Yeah, there's a election each year, but they represent under their fiduciary interest the shareholders on record.
The ultimate authority resides with the shareholders. Would you agree with that? In how the company is managed and directed?
The shareholders have 2 or 3 things that they have to vote on. And then the board has a fiduciary, and one of those is the election of the board. And then the board has the right to exercise that authority throughout its decisions.
Okay, I understand. Thank you. At page 10, you could go there. You discuss section 62-612.
Well, just a second, I'm not there yet. Okay, I'm there, sir.
Okay. Now, subsection B says that a transaction in contravention of 62-612 without prior authorization shall be void and of no effect. Would you accept that?
That's what it looks like it says, yes.
Okay. Turning to page 23. And looking at lines 14 and 15, you discussed that PNM primarily, I believe use the $400 million to reduce or pay down debt. Is that correct?
It says specifically, among other things, the funding was used to pay down TXNM debt, to provide equity contributions, which would be to PNM and TNMP, and to fund term loans. So it was a mix of three different elements.
Okay, and what portion of the 400 million was used to pay down debt?
I don't know off the top of my head.
Do any of the witnesses that the joint applicants are presenting have that information?
No, I doubt Mr. Sherman would have that, since he represents.
Okay. Now, you go on to say that if the purchase is void, TXNM would need to borrow or add 400 million in debt to pay back Blackstone, a swing of $800 million in your capital structure, I think you say. Is that right?
Yes, sir.
Okay. Now, let's just assume, to make things simple, and I understand this number may not be right, but let's just assume that you use the entirety of the $400 million to pay down debt. If you then, as a result of the transaction being void, had to borrow 400 million to pay off Topco, you're right back where you started from in terms of your capital structure, right? You paid down debt and then you borrowed the same amount. And I understand you're not sure the entire 400 million was used to pay down debt. But if that was the case, you would be right back where you started from, right?
Except that you've spent the capital, so you've spent the dollars in paying down debt, as well as making equity infusions to both TNMP and PNM. And a big part of this equity and that we needed to raise was driven by our capital budget. So if you go back to my testimony, where we specifically addressed the reason why, or the purpose of the equity raise that we needed, it related to the 2025 AOP that was completed in 2024, in the fourth quarter of 2024. So the need to raise the equity was driven by the capital and the plan associated. So the purpose of that equity raise was to meet those needs.
Okay, but my question was simply, if the entirety of the 400 million was used to pay down debt, and then as a result of the stock acquisition or being void was to cause you to borrow $400 million, your debt level would be the same as it was before the stock purchase, right?
Except that it's been a year since that period of time, and you've made equity contributions, you've spent the capital, you spent the dollars that you had. So now that you would remove it out of equity, so the way that the transaction, if it was avoided, you would remove it out of your equity and you would add to debt. So if you think about the composition of a balance sheet, you've already spent the capital or cash on capital to meet the needs of our customers at PNM and TNMP. I'm taking something out of equity, which is one side, and I'm moving it over to the debt side, because now I'm having to go borrow 400 million to pay back Topco.
Right, but I keep asking you to assume the entirety of the 400 million was used to pay down debt and not to infuse additional equity and things like that into your capital structure.
Well, I'm not infusing equity into my capital structure. I'm trying to maintain my capital structure to fund the capital that is being spent to meet the customer's needs at PNM and TNMP.
Could you turn to page 24, please?
Yes, sir.
And you discuss how the public interest and TXNM's, I wish you'd kept the name at PNM Resources. It would have been easier to. But anyway, that aside, TXNM's need for capital let me start over. You discuss how the public interest and the company's need for capital could provide a basis for the commission to approve the purchase non-pro-tunc. Do you see that?
Yeah, what line, or can you point me to the line that you're referring to on page 24?
I may have the wrong page number, Mr. Terry. Is what I said consistent with your testimony, though?
I'm scanning through. If I had a page number, I would just like to reference that.
Okay. It looks like you discussed that at pages 25 and 26. And particularly 26.
Okay, and your question was, Mr. Michaels?
Yeah, you discussed how the public interest and the company's need for capital could provide a basis for the commission to approve the stock purchase after the fact or non-pro-tunc.
Yeah, I do. Again, the purpose of the equity, irrespective of the merger, came out of that annual operating plan, which was important for PNM and TNMP capital budgets.
Okay. Now, suppose instead of selling a new stock issuance, you raised customer rates without PRC approval to procure the needed capital. Do you think the PRC could approve that rate increase without commission approval after the fact?
I believe all rate increases, would have to go through the commission, so.
They would need prior approval, right? Before you can increase your rates, okay. Now, the other remedy you discussed is at page 27, line 2, an exchange and option agreement. Could you please turn to the exchange agreement? It's an exhibit to your testimony, right?
Yes, sir.
And it's exhibit, I believe, JDT 3.
I am there on JDT3. What page would you like me to look at, Mr. Michaels?
So for purposes of these questions, I'd like you to assume that the Topco purchase is void and of no effect, okay? And I want to explore whether the exchange agreement is consistent with the purchase being void and of no effect. Now, first, the exchange agreement, as I understand it, has Topco transfer to TXNM the 8 million shares of stock in exchange for the option to buy those shares back at 1/100th of a cent per share. Is that right?
Yes, it would be to exchange the shares that were issued back in June back to TXNM Energy and replace it with an option agreement.
Okay. And at 1/100th of a cent per share, that would amount to $800. Is that right?
Correct.
For 8 million shares. And those shares would be transferred for something of value in return, right? In other words, the Topco shares would be transferred for something of value, which is the option to purchase 8 million shares. Is that right?
The option agreement would allow the potential purchase of 8 million shares, correct?
Right.
So that were returned from Topco back to TXNM Energy under the exchange agreement.
And part of the consideration for that option was transferring the Topco shares back to TXNM, right?
Part of what compensation?
Part of the consideration for the ability to obtain this option opportunity.
It would transfer them back. The 400 million would stay with TXNM Energy.
Mhm.
And then there would be the option premium that was paid was the 800 that you talked about. And then there would be mechanisms as talked about in the option agreement where things would have to happen to be able to exercise exercise that option agreement back into a stock certificate.
And one of those would be the merger does not proceed or is terminated, right?
One is the merger would not proceed or is terminated. Then they would exercise the shares.
Okay. Now in section 2 of that agreement, alternatively, the agreement anticipates that the stock purchase would be void. I think the term is ab initio. And what it strives to do is predate the agreement back to before the stock purchase occurred and have the $400 million paid for the stock instead of pay for the option. Is that right?
I don't know. I mean, off the top of my head.
Okay. Well,
Mr. Michael, just for your awareness, you have about 3 minutes left of the time you reserved.
Thank you, Madam Hearing Examiner. On page 2, paragraph 2, under item C, under this exchange agreement, Topco gets to keep all the dividends paid to it while it possessed the voided stock. Is that right?
That is correct.
Okay. And dividends would not get paid if there was no stock ownership to entitle the holder to those dividends, right?
That's correct, but I think the alternative way to look at that is we've had 400 million of equity that we actually used, or 400 million instead of having to borrow 400 million, and so there's a cost of capital associated with that. And I will tell you, just looking at our cost of borrowing and what our dividend yield would be, there's benefits to that. So about 200 basis points lower.
I understand all that, but what this agreement calls for is dividends that have been paid to be kept by Topco, regardless of the status of that stock and whether it's void or not. Right?
That's correct. But
Okay,
also
thank you.
Laid out it's cheaper than having to borrow that debt. So there are actually benefits or lower cost of capital.
But that provision is not consistent with the stock purchase being of no effect, right? There is an effect of that stock purchase by virtue of this exchange agreement, right?
Well, like I said, I mean, I think there was $400 million of use that the company had, and there was actually benefits when you look at the difference between what it would have cost and the debt cost that we have.
Those are all the questions I have, Mr. Terry. I do want to point out that I believe on page 22 of your testimony, you may have a typo there, and maybe not, but you refer on line 21 to the FCC. Did you mean the Federal Trade Commission there, as opposed to the Federal Communications Commission?
No, I think that we do have permits that we have to, I'll take a look at it. So thanks for pointing it out, but I'm fairly sure.
Thank you
we
very
have
much.
some FCC licenses as well too.
I understand. Okay. Thank you, Mr. Terry. Appreciate your time.
Thank you, Mr. Michaels.
Thank you, Mr. Michael. Next up in the order of cross-examination, New Mexico Department of Justice, you've reserved 7 minutes with Mr. Terry. Please proceed.
And actually, Madam Hearing Officer, is there an ability to reserve time if we don't use the full 7 minutes? Can the parties reserve
Uh,
time?
you're bound by the total amount of time, which for DOJ across the three witnesses is 20 minutes, but you are welcome to shift that time between the witnesses as you see fit. So if you'd like more time from Mr. Terry, you just would need to take less time with Sherman or Kelly.
Okay, thank you, Madam Hearing Officer. Good morning, Mr. Terry.
Good morning, Mr. Jimenez.
Just going to ask you some questions about specifically about section New Mexico statutes annotated section 62-6-12 subsection A. You've had an opportunity to review this statute related to acquisitions, consolidations, and consent of the commission, right?
I have, yes, sir.
And you're familiar with the general principles and the requirements of that statute, correct?
I've read it in layman's terms, not legal terms. So.
Certainly. Moving on to talk specifically about this stock purchase between TXNM and Topco. Did TXNM, it definitely had the opportunity to review the legal ramifications of the pipe transaction, is that correct, prior to the execution?
We look, our regulatory group as well as our internal and external counsel reviewed prior to us entering into the contract. Yes.
Were there discussions specifically about section 62-6-12 prior to the pipe transaction execution?
I'm not aware of any specifically that I had. Everything that I was focused on from our regulatory group and both inside and outside counsel was the effective control.
And TXNM had the ability to consult with the PRC about the legal ramifications about this potential transaction, correct?
Like I said, you know, the belief was, and you can see it throughout our testimony, the belief was the mechanism, and what we believe today even is the mechanism is control.
Can you move to page 15 of your testimony?
Yes.
Talking specifically about the Zimmer Partners LP transaction. This is a transaction that occurred in 2025, correct?
It occurred in June of 2025. Yes, sir.
And at the time of this transaction, was it known to TXNM that Zimmer Partners was a utility company or utility holding company?
I am not aware that Zimmer Partners is a utility holding company.
Can you describe the methods that TXNM undertakes when trying to vet a potential investor to ensure it's not a public utility or public utility holding company?
You know, I think, and that's, you know, when you reference the statute, I think that's where the struggle really exists if you don't apply control to that structure. And this is coming from a business, a person that raises capital on an ongoing basis to supply PNM and TNMP. And as I read and as I read, and like I said, in layman's terms, and when you read that statute, you know, the focus of this hearing has been on 3C. But when you look at actually 3A and you look at open markets and purchases and shares of open markets on an ongoing basis, as well as even when we run our ATM is just floating shares out into the market and letting people buy them. If there's not a control element to this section, I have no idea as a CEO how you would be able to monitor who is a holding company. Because the statute actually says who is a utility holding company in any jurisdiction, both on the just buys and sells on the open market and as well as just rolling on issuing our ATM, which then, you know, from, again, layman's terms and somebody that's raised capital, that puts us at a disadvantage of raising capital and really hurts, from a public interest perspective, us being able to raise that capital. So I know that's a long-winded answer, but as I read the statute again from somebody that raises capital, if there is no control element, that's the risk that I see in these elements. There's some way to measure that. I don't know how you'd measure it.
Mr. Jimenez, I'm going to pause your time. I'd like to ask Mr. Terry a question.
Sure.
And when you go back on, you're going to have about 3 minutes left. Mr. Terry, you just described your own understanding or your own interpretation of the statute in question. Can you describe to me any kind of consultation that you did with legal, any memos, any further explanation of the possible interpretations of this statute that you were privy to in your role?
In my role, we have our briefing that was filed. So
I mean before the show cause.
Before the show cause, no. The focus was control, Madam Hearing Examiner.
Okay. Thank you, Mr. Jimenez. You can proceed.
So, Mr. Terry, it would be possible for TXM to prepare due diligence guidelines governing future investor transactions.
I like I described, and I'm trying to conceptually think about how you would even do that. Could you do it in a large public offering block sale? Would be more complicated. I would tell you, you have to put yourself in the position of the buyer as well too. There's lots of options for them to purchase stock, and if they have to jump through a lot of hoops of pre-approval or other things, that's going to be complex, and it's going to lower the interest of us being able to raise capital to supply our utilities in Texas and New Mexico. And so, again, I don't know how, sitting in my position, I could vet every sales transaction as it relates to, are they a utility holding company or not? I'll tell you, our two largest companies today that own TXNM Energy are both utility holding companies.
Thank you, Mr. Terry. If you can move to page 8.
Yes, sir.
And it states that in your testimony, I can say with absolute certainty that TXNM was not attempting to game the process or violate any law, nor was there an intent to hide the financing transaction from anyone. Is that correct?
100% accurate.
Can you move to page 6? And in the first answer paragraph, it states that with respect to issuing and trading of public securities, while in possession of material non-public information with respect to those securities, if TXNM had sought the financing elsewhere before the announcement of the merger, TXNM would have been required to inform any potential investors of the proposed acquisition and its terms before it was finalized and announced. Is that correct?
You're reading lines 7 through 12, correct?
Yes.
Okay. Yes, that is correct.
And is it true that if there was a disclosure of the Topco transaction to the PRC pursuant to section 62-6-12, that there would have been a potential disclosure to investors? Is that correct?
That would potentially be a concern. Any type of information that goes out, and anytime you're in a transaction, you have to keep it very tight on who you communicate to.
And that was part of the contemplation of why the PIPE transaction was structured in the way it was?
The PIPE transaction was structured in the way that it was as an opportunity. And we knew that we needed the 900, we needed 900 million of capital. And so it was structured in, as we kind of went through alternatives of how to best meet the needs of our customers. But the purpose of it was always to meet the needs of our PNM and TNP.
Mr. Jimenez, you've used your 7 minutes. Did you want to borrow time from your other witnesses?
No, Madam Hearing Officer. Thank you, Mr. Terry.
Thank you, Mr. Jimenez.
Mr. Jimenez? Next in order of cross-examination is the attorney who's going to be cross-examining on behalf of New Energy Economy and Center for Biological Diversity. Who's that going to be?
That would be me, Marianne Lanassi, on behalf of New Energy Economy and CBD. Madam Hearings Officer, I would like to use 20 minutes of my total, which I believe is 30 minutes.
Go ahead.
Mr. Terry, could you please have your deposition ready, and also New Energy Economy CBD Exhibit 3, please.
All right. And good morning. How are you doing?
Good morning. Do you have those two things? Tell me when you're there.
I have the deposition ready. So if you are you going to go there first, or do you need me to have everything ready?
I just want you to have it ready so that those, in case we need the deposition, but we'll definitely need New Energy Economy CBD Exhibit 3.
And Ms. Nanasi, I just want to remind you of our earlier ruling that Mr. Terry's deposition transcript can be used for impeachment purposes only, yes?
Yes, thank you, sir.
Thank you.
Okay. It's a set of emails. Is that correct?
Yes, it is, sir. So you were the president and chief executive officer for PNM and the president and chief executive officer for TXNM Energy, correct?
As of today?
Yes.
Okay. Yes, ma'am.
And you spoke before about the $900 or $925 million equity raise that you and the TXNM board deemed necessary in December of 2024. Is that correct?
I spoke of the 900 million, 50 million of that was an ATM that, we had already entered into, but we could pull down in 2025. And then there was 850 million more we needed to be able to fund the capital program as well as support our credit metrics.
Okay, that's what I want to talk to you about this morning, primarily. The AOP stands for Annual Operating Plan. Is that correct, sir?
Yes, ma'am, the annual operating plan.
Okay, on May 18th, May 18th, 2025, TXNM Board of Directors passed a board resolution approving the merger agreement with Troy Topco, correct?
May 18th would have been it. Are you pointing to some document, or?
It's both in your board minutes at 37 and the proxy statement, but you know that you're a member of the TXNM board, right?
I know we approved the transaction on May 18th, as well as approved the merger on May 18th.
Also, in connection with the merger agreement, TXNM entered into a stock purchase agreement with Troy Topco, whereby TXNM was going to issue to Troy Topco 8 million shares of TXNM common stock at a price of $50 per share for $400 million, correct?
Yes.
You considered the Zimmer equity issuance of $200 million as part of the same $800 million capital raise. Is that also true?
It was, excuse me, it was part of the 800 million capital raise.
Okay. Before I ask you more about the $200 million Zimmer private placement equity issuance, I have some background questions to ask. So if you could look at New Energy Economy CBD Exhibit 3. Let me just ask you some background questions first. Sabrina Grinnell is a vice president and treasurer for PNM and TXNM, correct?
Yes, ma'am.
Brian Iverson is general counsel for PNM and TXNM, correct?
Yes, ma'am.
Henry Monroy is senior vice president, chief financial officer for TXNM, correct?
Yes, ma'am.
Lisa Goodman is a vice president, investor, and community relations for TXNM, correct?
I believe that's her title. Yes, ma'am.
those persons I've just mentioned collectively all work directly for and answer to you. Is that also correct?
Let's see. Sabrina works for Mike. Indirectly or directly, they all work for me. I'm the CEO. But when you use the word directly, Sabrina works directly for Henry. Henry works directly for me. Brian works for me, and Lisa Goodman works for another SVP.
Another what?
Another senior vice president.
Okay. But ultimately to you, correct?
Yes, everybody eventually works for me.
Okay. Could you look at you sponsored this document that is NE CBD Exhibit 3. Is that correct?
I did, through Discovery.
Yes. And you swore that this information was true and correct to the best of your knowledge and belief. Is that also right?
Yes.
Could you please turn to PDF page 1 of that document?
Ms. Namasi, for clarity of the record, could you say what NE CBD Exhibit 3 is?
Yes, this is a series of emails and was provided by you, Mr. Terry, and it was in response to New Energy Economy interrogatory that read, please provide any and all communication between any Zimmer representatives and the TXNM contact persons with respect to the acquisition of $200 million worth of TXNM stock. Is that correct, sir?
I believe that's the question you asked in your subject to check. That's the question you asked in your.
Thank you, and thank you for that clarification, Madam Hearing Examiner. Could you turn to page PDF 1 of that document?
I think I'm on PDF 1 if you want to.
Okay. The person sending this email is Sabrina Grinnell from TXNM. The date of this email is May 27th, 2025. The person this email was sent to was Stuart Zimmer of Zimmer Partners, and the subject of this email is, quote, TXNM term sheet. Is that all correct?
Yeah, TXNM term sheet. That is correct.
Ms. Grinnell wrote to Stuart of Zimmer Partners asking him to consider a proposed term sheet for $400 million of common equity of TXNM stock. Is that also correct?
That is correct. I will tell you, and I believe it's in my testimony, Mr. Zimmer had reached out directly, which then led to this email. So after we announced the transaction and indicated that we were going to issue an additional 400 million, he's a investor that's invested in us many times. He's in and out of our stock over the last.
Mr. Terry, I really appreciate that background, but I have so few minutes with you. I really need to focus. I apologize. Could you please turn to PDF page 18 of that document?
And are the pages at the bottom? Is that what I'm looking at? Like there's 150.
No, they are not. I hope that you are looking at New Energy Economy CBD Exhibit 3, not the entire document.
I'm looking at whatever was downloaded last night, I'm assuming, correct? I can count out 18 pages, they're front and back. I just don't know where to look for the page.
Madam Hearing Examiner, could I have a pause on the time because he's looking at the wrong document? It's clear. Thank you so much. I'm so sorry, but could you please ask your counsel to provide you with NEECBD Exhibit 3, which was excerpted and redacted per agreement between New Energy Economy and CBD and joint applicants?
Is this,
For-
if you can show me where the numbers are?
Yeah, there are, Ms. Nanashi, are there, there's footers on the page. And are we talking about page 18 of 157 at the foot of this exhibit?
On that exhibit, yes, but when we get into other pages, it won't be that page. I could ask this question, but
Let me intervene here, just for traffic control purposes. I'm looking at NEE CBD Exhibit 3. There are a total of 55 pages to that PDF. Is that correct, Mr. Nasi?
yes, it is, sir.
So for
Yes,
all
there are.
parties, yes, we will refer, and I ask NEE to refer to the page of the PDF, not any internal markings on the page number or on the page. Thank you.
Yes, sir. Thank you. May I ask if counsel for Mr. Terry could please provide NE CBD Exhibit 3 as opposed to the original full 156 pages, 157 pages that was provided that is not NE CBD Exhibit 3?
Well, Ms. Nanasi, what we have, which is downloaded from the Dropbox, is NE CBD Exhibit 3. On that exhibit, there is a footer that has a April 17, 2026 supplement and page 1 of 157 and so forth. And I think we can index off of that as to which email you want to go to.
I think
No,
that where the correct me if I'm wrong, Mr. Terry is looking at a printed out version of this, which makes it
Correct.
harder to refer to PDF pages, so which are only visible if you're looking on a screen. Is that the problem? So if there's, for just this purposes, if there's an indicator at the bottom of the page that will get Mr. Terry to the correct page, since he doesn't have access to the online PDF, Hearing Examiner Schaefer, would that be okay just in this instance?
yes, absolutely. I was unaware that Mr. Terry did not have that this was printed. So that's of course, yes, that works.
Okay, yeah, so however, the easiest way to find it, just go ahead and do that and tell us again where we're at, Ms. Nanasi, in this exhibit.
Thank you so much. For this question, it is PDF page 18 as well as on the bottom page 18 of 157 for this question.
Okay,
Okay, are you there,
does that
Ms.?
help, Mr. Terry? I'm seeing it on my screen and it does indeed say page 18 of 157.
Okay, I can find page 18 of 157. Thank you. Sorry about that.
The first word is Janella in the body.
Yes.
Yes, thank you. And now we can, of course, resume my time. Thank you for
No
that. I'm
problem.
sorry for that interruption. The person sending this email is Brian Iverson from TXNM. The date of this email is June 3rd, 2025. The person this email was sent to was different persons at Zimmer Partners, a different person at Zimmer Partners, Jelena Napolitano, Napolitano, for the record, at Zimmer Partners. And the subject of this email is still TXNM term sheet. Is that all correct?
It is correct.
Here on PDF page 18, Mr. Brian Iverson's email states, Jelena, we are still working on getting input from Blackstone, but should have a draft in the morning. Is that correct?
That is correct.
Now, could you please turn to 2 pages later? And this
And that would,
is
and that would be page 20, right? The document. Just tell me
that,
if you tell me what it says at the top, I can follow it that way.
yes. It's got a big orange box on it.
Okay.
And it's PDF page 21, but on the bottom of this page, it's page 40 of 157. Do you see that?
Yes, ma'am.
Thank you, sir. The person sending this email, just in the bottom of that page, is Sabrina Grinnell from TXNM. The date of this email is June 5th, 2025, and it is to Jelena Napolitano at Zimmer Partners. And the last full sentence of that email reads, quote, "Please propose an end date for the lockup when you send the draft back later today, and we will vet with Blackstone and our internal team," unquote. Is that a correct reading of that email?
That is a correct reading.
Thank you. Now I'd like you to turn to page 30 of that PDF, which I'll tell you what it's page 48 of 157 in the bottom corner. And the bulk of this page starts with, "Hi, Jelena."
I got that.
Thank you. And this email is the person sending this email is Sabrina Grinnell to Jelena. Is that correct? And this is on June 11th. No, excuse me, I made a mistake. It's actually, strike that. It's actually page 30, PDF page 30 is, and on the bottom is page 49 of 157. Do you see that?
I do see that.
Okay, and the first email on this page is from Jelena Napolitano at Zimmer Partners to Sabrina Grinnell, with Mr. Iverson and Mr. Monroy CC'd from TXNM. The date of this email is June 10th, 2025, and its subject is follow up on SPA. The email reads in part, "Please find attached our markup of the draft SPA. As I note therein, we haven't had a chance to track through the definitions in the merger agreement, but can do so once you have feedback from Blackstone." That was a quote. Did I read that correctly?
Yes.
And sir, SPA stands for stock purchase agreement. Is that right?
Yes, ma'am.
Okay. And now if you go to PDF page 40 and on to 41.
And that's in my document, that's 40 and 41, or is it a different number?
On the bottom, it says page 59 of 157. There's only one line on page 40 that I want to reference, and that is that it's an email from Sabrina Grinnell of TXNM. The date of this email is June 11th, 2025, and it's to Jelena Napolitano at Zimmer Partners. And a high level of this email is that, quote, "After discussion with Blackstone, certain changes were made to the SPA."
I'm sorry, I'm struggling. So you said what page of, you said 59 of the 157 document?
Yes, 59 at the very bottom, but the heart of the email is on page 60 of 157.
Do you see it on your side? I can't see on 59. I can't see that statement.
I think it runs over to 60.
No, yes, it runs over to 60. That it just started on 59, sir.
Please see that.
Do you see that, like that, where it's got a paragraph that's number 1, and the second sentence says, after discussion with Blackstone, and then there's some changes that have been made to the SPA, including we revised the covenants in
Ms.
5.
Nanasi, excuse me, let's make sure we ask questions on cross. So it's, you can direct the witness to the document, but let's just make sure we form our statements as a question.
Thank you, sir.
So I see 1. Is it something in 1 that you want me to read?
Do you see the second sentence that starts with after discussion with Blackstone?
After discussion with Blackstone, we believe this amount of time will be required to ensure there is enough time to account for the potential SEC review and the proxy statement.
Yes, and then it goes on, and on 2, it says, we revised the covenants in 5.4, 5.5, and 5.8, so that they are appropriately binding on all of the Zimmer partners and not just parties and not just Zimmer partners.
Yes, I see that.
Okay. And
Question?
just that's what this says, that this was after discussion with Blackstone, there were some changes made to the SPA. Is that right? It says that in the very first line, there's an updated draft of the SPA with red lines. Do you see that?
Are we on the same email?
Yes.
And what was the statement again?
That the SPA had been updated, the draft had been updated by TXNM after discussions with Blackstone, and some of those changes included revised covenants to 5.4, 5.5, and 5.8. That's what this email says occurred. Is that correct?
It's labeled 1 and 2, and I'll read what it says. After discussion with Blackstone, we believe the amount of time that will be required to ensure there is enough time to account for a potential SEC review of the proxy statement. That will give us and Blackstone a lot more comfort that the shares will be voted per our agreement. While only being slightly delayed beyond the September 1st date proposed. So that's question 1. And then question 2 says we revised the covenants of 5.4, 5.5, and 5.8 so that they are appropriately binding on all Zimmer parties and not just Zimmer partners.
Correct. And now if you could turn to PDF page 48, which is at the bottom, it says page 96 of 157.
Ms. Nanasi, you're just about 3 minutes.
Thank you.
I'm there.
If you look at both of these emails that appear on this page, is it your understanding, if you look specifically at the line that says subject, that there were a number of versions of, after discussions with Blackstone, of the stock purchase agreement that TXNM had with Zimmer?
I don't know. I see the versions. I don't know if your statement is accurate about, and because I wasn't involved specifically in this, if those are versions between Zimmer and TXNM. I would assume, and again, I wasn't privy to and didn't work on this transaction, but I wouldn't assume that the versions were versions between Blackstone and TXNM. Probably more likely versions between Zimmer and TXNM.
Yes, and if you look at the middle of this page, it says attached are the drafts we sent to Blackstone. Is that correct?
It says, Jolene, thanks. Attached are the drafts we sent to Blackstone. We plan to file these with the New York Stock Exchange 9 a.m. tomorrow morning.
Okay. So in the initial discussions with Zimmer, TXNM wanted to issue $400 million worth of stock to Zimmer. Is that correct?
I'm not sure. I know they talked about 400 million. I know they talked about, and they landed on 200 million. My guess is that was negotiations back and forth between Zimmer and TXNM Energy of what they finally decided to do.
Mr. Terry, I wish I had much more time with you. That always happens with me. Thank you very much.
Thank you.
Ms. Nanasi, did you wish to move for admission of this exhibit?
Yes, I do. Thanks for bringing that up. I was going to do that after at the end, but I'd like to do that now.
Okay, so moving for
New
admission.
Energy Economy and Center for Biological Diversity move Exhibit 3 into the record.
Are there any objections, aside from any objections that have already been stated, to the admission of NEE CBD Exhibit 3?
Objection, PDCWA. We were not provided the Dropbox link to upload or download exhibits until after the start of hearing. Well, after some of the other parties, Mr. Terry just indicated that they were downloaded last night. That exclusion further prejudiced parties and continued determination to restrict the rights of interveners to participate in the public hearing.
Thank you, Mr. Herman. You made a standing objection at the beginning, and it's been noted for the record. You don't need to object every time, but your objection is noted and overruled.
This
Anybody
is
else?
with respect to the Dropbox link that wasn't previously incorporated.
Thank you. Is there anyone else?
No objection, Your Honor.
Okay. The NEE CBD Exhibit 3 is admitted to the record.
Thank you, Your Honor. I pass the witness.
All right. Next up in the order of cross-examination is staff of the NMPRC.
Good morning, Madam Hearing Examiner. Mr. Terry.
Good morning, Mr. Elliott.
Mr. Terry, at the outset, Madam Hearing Examiner, we've reserved 10 minutes for Mr. Terry, and I believe for 10 for the other witnesses as well.
I have 7 minutes for Mr. Terry, 6 for Sherman, and 7 for Kelly, for a total of 20 minutes.
Okay, I am going to move all of my time to Mr. Terry, I think.
That's great. Go for it.
Good morning, Mr. Terry. If you would please turn to page 25 of your testimony. And here you discuss alternatives to voiding the transaction if the commission finds the pipe required prior approval. Specifically, you say that the commission could retroactively approve the financing transaction if it finds it's in the public interest. You recall that testimony?
I think it's on 26, right? Is that where you want me to?
Sure, but do you recall the testimony, not the page number?
Okay, yes, I do remember the testimony.
And when did TXNM filed the joint application on August 25th? That was 2 months after the pipe, correct?
Yes.
And did TXNM include the petition for retroactive authorization in that application?
There was no petition included in that application.
You then talk about the second option, the option agreement. Do you recall that? It's on page 20. I think it starts on page 26 of your testimony.
I do.
And you actually attached a draft of the option agreement. That's JA Exhibit JDT3, right?
Yes, sir. Yes, sir.
And that option agreement, it's drafted, it's ready to execute. Is that right?
That is correct.
And when was that document prepared? Is that before or after the Prosperity Works motion for show cause?
It was prepared after.
And the option agreement under the terms, it says Topco may only exercise this option after either the commission approves the purchase of the stock option under 62.612 A3 or determines that approval is not required. Is that correct?
I believe so. What paragraph or what paragraph were you looking at?
I wrote it down. I didn't cite to the paragraph.
Okay.
But in general terms, is that your understanding of it?
My understanding is for them to be able to exercise the option. And exercise the option means to be able to, move the stock back to Topco. They would need to have commission approval on that, or the commission would say they don't need to have approval on that, or the termination of the merger.
So in both instances, it's really contemplating commission authorization one way or the other. Is that right?
I think that it is contemplating that we would like the commission to approve it.
So
that's for the, let me clarify. That's for them to exercise the option. Those statements are them. Options, you could move forward and put the option in place and move the shares back to TXNM Energy and put the option in place. But that paragraph specifically talks about them exercising the option. And remember, the exercising the option would be now moving back the stock to Topco.
Well, let me ask you this. You've presented the commission with two options, retroactive approval or the option agreement. In this proceeding, has TXNM formally moved the commission to do either of those?
If the commission finds that we did not follow and control is not an element of, the statute, we would like to move to one of those options.
But to be clear, TXNM has not filed a request or made any filing seeking the commission's approval for either of those.
Objection asked and answered.
I think we would see that.
Sorry, who objected? I'm sorry, could I get who?
This is Ray Gifford. I object that asked and answered.
And please allow Mr. Elliott to respond to the objection.
Quite honestly, I didn't hear an answer to that. Have either of those things been filed? I heard a desire, but I didn't hear a yes or no.
I'm going to overrule the objection, and Mr. Terry, just go ahead and clarify and answer Mr. Elliott.
I think as part of this proceeding, if we find, or if the commission finds that we did not follow the statute, we would be asking for that alternative in this process.
Mr. Terry, on page 24 of your testimony, you expressed concern that investors might view the uncertainty created by this show cause proceeding as an indication of a challenging environment in New Mexico. Do you recall that testimony?
Just a second, let me look through. I do. I have it in front of me.
Do you accept that TXNM's own actions and decision-making here have created that very uncertainty that you're now asking the commission to resolve?
I think that there's a couple of different factors. And I think one of them, and I had started to have some of this discussion, when you look at the statute itself, and you look at, and I know the focus has been on 3C, but 3A, when you think about environment and ability to raise capital and how it will be viewed, if public utility holding companies, there is no bar for control or other elements, it's any share of any sort, it's going to complicate and put us at a disadvantage of raising capital. I think that's one element of that statement and the negative outcome that I'm concerned about as the CEO of PNM. I think the other one is just how rating agencies view, and rating agencies, when they look at it, they look at both the metrics as well as overall business environment. And I think when you consolidate those two things is where the concern I have is being able to raise the capital.
Mr. Elliott, can I interject just for 1 second? I'll pause your time.
Absolutely. Thank you.
So then, Mr. Terry, by that logic, would you agree that if the commission does find a threshold or a bar, as you've been referring to it, even if it's not the one that's being advocated by joint advocates, that would negate your worries if there is an indication, even if it is not the indication that you are requesting?
I think it will be determined on, what 3A as well as 3C looks like. So 3C, we've proposed some alternatives. I don't know what the commission and what the recommendation will be. I think somewhere along the way, whether it's this process or forward, we've got to think of, depending on what the decision is, how 3A fits into the mix of things.
Thank you. Thank you, Mr. Elliott. Go ahead, please.
Mr. Terry, given everything in this record, the voluminous briefing, the extent to which this has delayed the application, the simultaneous signing, the joint price negotiation, the termination rights, what staff has argued are the 5 missed opportunities. Do you accept that the better course of action here would have been to simply ask this commission whether the pipe required prior authorization?
In hindsight, based on the concern, not the concern we knew when we signed it, but based on the concern that staff and the AG and others have, I think that looking at it today, it would have been beneficial. We would have to have requested on an expedited process, but it would have been beneficial in your testimony when you laid the initial filing after we announced to be able to do that. So to both eliminate the delay and the amount of work that would have been done there. Again, our view and of this statute was control was, so we went through steps that we were focused on, or our legal teams were focused on, and our regulatory group was focused on. But I always want to be transparent and open and eliminate time and energy spent by other folks.
Staff's reply brief concluded that if the joint applicants were to positively and contritely acquiesce to the commission's findings, a hearing on the merits of the underlying application might still be possible. Are the joint applicants prepared to accept a finding of a violation along with financial penalties and governance conditions, if that's what the commission determines, in order to proceed to a hearing on the merits?
I'm not going to get in front of a commission order and so forth. So I mean, we would have to look to see what, if the commission went that way, what the order would look like, Mr. Elliott.
If I actually have no further questions. Let me ask you this. In the understanding of the regulatory compact, is it your understanding that adherence to the letter of law is the minimum requirement? That there's more that's expected of the utility?
My expectation is, clearly to follow all the rules, if that's your question, Mr. Gideon.
Well, it wasn't really. I mean, my question was intended to elicit more than that. Do you understand how this issue has caused or goes to the question of confidence, the public's confidence in TXNM and the potential acquirer in this proceeding?
I would say that, my expectation is we are always open and transparent. We work with parties. We have had multiple meetings. I agree. You heard my hindsight view, because I'm about building relationships and working to results that benefit our customers. And that is the focus. That's why we looked at the equity need altogether, and our board was heavily focused on it, independent of the merger, is we're trying to meet our customers' needs and provide the service that they deserve. And so, absolutely look to work with parties and resolve issues. And if anywhere along the way, concerns would have been raised, we would have dealt with them as we went around the path. So for sure.
Madam Hearing Examiner, do I have any time left?
You do. You have about 8 minutes and 30 seconds. So if you'd like to reallocate that to the other witnesses as you see fit, you can just let me know at the time that it's your turn for cross-examination comes up.
I'll do that. I'll just, we'll end here. Thank you, Mr. Terry. I appreciate the opportunity.
Thank you, Mr. Elliott.
All right. I think what we'll do, it's 10:39. Why don't we, I'm gonna ask Hearing Examiner Schaefer if he has any questions for Mr. Terry. And then if I have questions, I will ask them, allow for a redirect. And then we'll take a brief morning break, if that sounds right.
I was prepared to do that after our break, Madam Hearing Examiner.
Would it be preferable to take a break now?
Yeah, I think we've been going for about an hour, 40 minutes, so it might be good for Ms. Gonsalves and everybody just to stretch for a minute.
That's probably a good idea. Let's go ahead and make this a 10-minute break. So we will go off the record and we will be back on the record at 10:50 a.m. Remember, the YouTube continues to stream when we're on break.
Madam Hearing Officer, can I ask you a question about your ruling beforehand? Right before we get back on the record? Just to clarify what I'm supposed to do to correct the filing, do I just eliminate Exhibit 3, but everything else stays the same, like the list of exhibits and the ordering, or do I have to go back into the testimony and change all the numbers, reorder it or something like that? Can I just eliminate Exhibit 3 and leave it blank so that, or tell me how you would like me to proceed. You are on mute.
I am on mute. That's a good question. I'm not entirely sure right now. I'll confer with Hearing Examiner Schaefer on the lunch recess, and we'll let you know when we come back exactly how we'd like you to handle that.
Thank you. Please advise.
Your
All right.
camera's also still off, Ms. Nanasi, just for your awareness.
All right, the time is 10:51. Ms. Gonzalez, are you ready to go back on the record?
Yes, Your Honor.
Okay, thank you very much. Time's 10:51, we're back on the record. PNM's witness, Mr. Terry, is still on the stand and he is still under oath. And the next step would be to see if Hearing Examiner Schaefer has any questions for Mr. Terry.
Yes, thank you, Hearing Examiner Barrett. Mr. Terry, thank you again for taking the time to be with us here today. Just to begin, could you just describe your role and responsibilities presently?
Yes, sir. I'm president and CEO of TXNM Energy and responsible for all actions within the holding company. I'm also president and CEO of PNM and also CEO of TNMP, the utility in Texas.
And earlier in your testimony today, you stated something to the effect of that one of your primary roles, if not the primary role, is to raise capital for these companies. Is that correct?
Yes, over the last 5 or 6 years, I was the CFO before, and so raising capital is one of the important things at hand that I do.
So you're familiar with market developments in the financial markets, including the emergence of PIPE transactions. Is that correct?
I am familiar with PIPE transactions and the different type of transactions in the market. Yes, sir.
And I'm asking some questions also for the awareness of everybody who's participating in this hearing, including the public. And can you describe to us what is a PIPE transaction?
A PIPE transaction is a private investment in public equity. So it is where you don't have a public marketing of the specific equity that you're selling, but there is a sophisticated investor that is willing to purchase the equity. And then after that, it becomes registered when you register it and go from there.
And by you, when you said you just now, you mean the publicly traded company, is that correct?
Yes, sir. Sorry, TXNM Energy.
Yes. Also earlier in your testimony, you said something to the effect of that TXNM as a holding company is in turn owned by holding companies. Is that correct?
Shareholders, certain shareholders, if they have a portfolio. So you take Vanguard, who invests in lots of different companies. They will register themselves, and they're registered with the as a public utility holding company.
And who are the largest shareholders of TXNM?
They are BlackRock and Vanguard, and both of them are public utility holding companies.
BlackRock, you're saying in turn is a public utility holding company.
It's registered as a public utility holding company.
And in the acquisition, does either of those largest shareholders own more than 10% of TXNM shares?
I believe one of them owns 11%. I think they both own over 10%.
And did, to your knowledge, either of those entities or TXNM file for approval of those transactions with the New Mexico Public Regulation Commission that amounted to the greater than 10%?
I am not. I will tell you, several years ago, it's been a extended period of time. When they bumped up over, we let them know. And my understanding, and it's a limited understanding, that and again, this was several years ago. They visited with staff. They came down. We weren't included in the meeting, and there was discussion. And my understanding is it got resolved. Again, I don't have the details because we weren't part of that meeting.
And with respect to the 8 million shares, that was a amount of shares that was calculated in order to meet the equity needs pursuant to the PIPE transaction. Is that correct?
It was a portion of what we needed. So the fundamental issue is we needed to raise capital for our company. We needed approximately 850 million. 50 million had already been obtained through an ATM. And so as we looked at the amount, part of it was we did look at what we considered control, which was the 10%. But it was also, there was a view of how much do we think we could sell once we came out of the blackout period. And so when you're in a, normally, just to level set, normally we're in a blackout period without an acquisition approximately 5 months out of the year. So we can't sell stock 5 months out of the year, usually January, February, April, July, and October. And then you apply the acquisition on top of that, it kind of pushes you to the August timeframe to be able to raise equity that last part of the year. So it was those balancing.
So it was those balancing, I'm sorry, I didn't hear that. It was those balancing
Factors. Sorry about that.
Thank you, Ms. Gonçalves. Mr. Terry, then, if I understand correctly, your testimony is today that TXNM, at least on that part of the transaction, did take into account a 10% threshold control element when issuing these 8 million shares. Is that correct?
Yes, sir.
So the PIPE was purposefully structured to yield less than 10% of shares that would constitute a controlling stake in TXNM. Is that correct?
It was that is correct, along with restricting voting rights and other elements that they could exhibit control, because it's 10% is one element. You know, there's elements of you can't have board seats, you instruct management, you can't control the board. So, I mean, that's one of the reasons why we restricted for Blackstone. We restricted, and it was TXNM that made that request in the deal to restrict voting rights.
Thank you. Just a few more quick questions, Mr. Terry. What is the name of the company is Troy Topco LP? Is that correct?
That is correct.
Purchased, yes. And what does LP stand for?
I'm assuming limited partner, but to defer that to Sebastian Sherman, Mr. Sherman, the LP.
In your experience with raising capital and with financial markets, what is a limited partnership?
A limited partnership is limited it's limited in liability for protection and operates as such. So,
and how does it function? If you're aware.
You know, a lot of times it's member ran, but I'm not aware in full detail.
When was Troy Topco created? Troy Topco LP created?
Troy Topco LP, better asked of Mr. Sherman. I'm assuming it was part of the acquisition itself. So, but he would be able to answer that question.
So your testimony is that Troy Topco LP was created essentially at the same time that the underlying transaction, proposed transaction for TXNM to be acquired by Blackstone and the downstream entities. Is that correct?
That's my understanding, but again, Mr. Sherman would be the best to ask.
Okay, thank you, Mr. Terry. I have no further questions.
Thank you, Mr. Hearing Examiner.
Thank you.
Thank you, Hearing Examiner Schaefer. Mr. Terry, let me just check my notes, but I don't think I have any additional questions for you. I think I was able to ask mine. And the rest were covered by Hearing Examiner Schaefer. Yes, I don't have any additional questions for you. Any redirect for this witness?
Yeah, very brief, Your Honor. Just a couple of questions. Mr. Terry, do you recall the discussion you had with Ms. Nanasi about the emails contained in Exhibit NEE-3?
Yes, sir, I do.
To your knowledge, on the emails between Zimmer and PNM personnel, are any Blackstone personnel copied on those?
No, they're not.
And those emails discussed consulting with Blackstone with regard to the Zimmer transaction. Why were you consulting with Blackstone about the Zimmer transaction?
You know, under the merger agreement, one of the things when you're in a merger transaction, is you don't want to be held a breach of contract. And there are specific terms in the merger agreement, and I think they're in 5.1 conduct of the business pending the merger. And there's a section in there, 5.1C, that kind of walks through these type of elements and questions once you're into a merger. So they were included and consulted with for that reason.
Thank you, Mr. Terry. No further questions.
Thank you.
Right, does anyone have any follow-up questions specifically tied to the questions that were asked by Hearing Examiner Schaefer or the redirect?
No, ma'am.
Madam Hearing Examiner, I have maybe 2 or 3 questions.
Okay, keep it brief and on point, please.
Thank you. Mr. Terry, I took your deposition on February 12th, 2026. Is that correct?
I do. Yes, ma'am.
On page 36, you were asked by me this question. Are you familiar with the New Mexico statute annotated 62-612 requiring prior express commission authorization for acquisitions of utility stock made in connection with a merger? And your answer was no.
Your Honor, I'm going to
Is that
object.
correct?
This is beyond the scope of redirect.
Can you just get to your question, Ms. Nanasi, please?
Yes, my question is, did I ask you that question and did you provide that answer?
Now, Your Honor, I'll object. This is beyond the scope of redirect.
I'm going to sustain that objection. I think it is beyond the scope of redirect.
If I may just respond, Madam Hearing Officer, I believe that he's testified that he many times in this pursuit of questions, not only from Hearing Examiner Schaefer, but others, that he was very familiar and how complicated it would be to be able to issue stock under 62-612, an A versus C, and all this other stuff. And I asked him that question, are you familiar with 62-612? And he said, no, he wasn't.
How does that
believe it's
exactly tie
impeachment.
to the redirect, though? That's a general question.
Okay, if that doesn't persuade you, then I will move on.
Ms. Nanasi, you muted yourself. I don't know if that means you don't have anything further.
If I could have just 1 second, please. No further questions. Thank you.
Thank you very much. Mr. Terry, thank you for being here today. We appreciate your time, as Hearing Examiner Schaefer said, and you may be excused.
Thank you, Madam Hearing Examiner.
And Your Honor, we'll just need.
Well, you cut out. But I think I understand what you're saying. To be, you'll just need a moment to change witnesses. Okay, go ahead. Mr. Jimenez, do you have a question?
Yeah, yes, Hearing Examiner Barrett. This pertains to exactly what Ms. Nanasi was just articulating, but is it permissible to offer rebuttal or redirect on somebody else's cross-examination in this matter? Or if that makes sense, are we permitted to redirect or offer,
No, the presenting attorney is allowed to redirect. We don't really allow recross, but we allow limited follow-up questions if they're tied directly to the redirect.
Are those limited questions, do they have to be in association with our prior cross or everybody's prior cross?
Your prior cross.
Okay, understood. Thank you.
Is the witness ready? I believe you're still on mute, sir.
Good morning. Let me try that again. Let me. Is that better?
Is it possible that there's someone else in the room with you that has not muted their computer that may be listening to either the Zoom or YouTube? That's what usually causes that.
Yes, but unfortunately, no. Hold on.
Now, can you hear me?
Yes, I
Okay,
can.
great. Thank you for
All
the
right,
clarification.
No problem. Is our joint applicants prepared to offer their next
She hasn't said anything yet. Okay. So at this point, we would like to call Sebastian Sherman
Okay.
to testify.
Thank you. Ms. Gonzalez.
Oh,
will you
actually,
please
now,
go?
I'm sorry, Madam Hearing Examiner, we cannot hear you.
You cannot hear me. Can everyone else hear me?
Yes.
Yes.
So joint applicants, it sounds like it might be an issue on your end. Go ahead and.
Okay, we're actually fine now.
Okay, good.
Good. Thank you.
No problem.
Okay.
There's always glitches.
And
Ms.
can I
Gonzalez.
ask, yes, before we start, can I ask the attorney's name? I'm not sure if I have it.
Yes, thank you. My name is Anna Rotman with Kirkland and Ellis on behalf of Troy, one of the joint applicants.
Okay, I just didn't know who you were. Thank you.
Of
Raise your
course.
right hand, sir. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Sherman, would you please state your full name for the record?
Sebastian Sherman.
Who are you employed by and what is your position?
I'm employed by Blackstone Inc. My position is Senior Managing Director.
You have in front of you what's been marked as Joint Applicant Exhibit 2. Do you recognize this document?
I do.
What is it?
It's my direct testimony.
Was this testimony and the attached exhibit prepared by you or at your direction?
Yes.
Are there any changes or corrections you would like to make to your testimony?
No.
If I asked you these same questions today, would you provide these same answers?
Yes.
Are the answers in your testimony true and correct to your knowledge and belief?
Yes.
Madam Hearing Examiner, I move admission of Joint Applicants Exhibit 2 into evidence.
Thank you. Aside from standing objections that have already been noted for the record, does any other party have an objection to the admission of this exhibit? The exhibit is admitted.
Thank you. I now tender the witness for cross-examination.
Thank you. First up, we have Prosperity Works, who has reserved 20 minutes with Mr. Sherman.
Thank you, Madam Hearing Examiner. I doubt I'll use the entire 20 minutes. Good morning, Mr. Sherman. My name is Steve Michael. I'm an attorney for Prosperity Works. I can't remember if we've met or not. There are a lot of things I can't remember anymore. But regardless, first question I have relates to some of the questioning Mr. Schaefer had of Mr. Terry that seemed to get referred to you. Does Troy Topco have any role within the Blackstone conglomerate other than to facilitate the stock purchase agreement that's the subject of this hearing?
I'm not aware of any role other than in relation to the purchases of the shares of common stock.
Okay, thank you. Could you turn to page 18 of your testimony?
Yes.
And on that page, you say that declaring the purchase agreement void would have no effect on the merger, or that's the gist of your testimony. And one of the reasons you give is that 99.6% of the shares voted to approve the acquisition. Do you see that testimony?
I see that statement, yes.
Okay. And shareholders vote based on information they have available to them in anticipation of that vote. Is that right?
Correct.
Okay. And part of that information available to them is contained in the proxy statement that they have and that is provided to them, right?
Correct.
Okay. And the proxy statement is Exhibit D to the joint application, and you can accept that subject to check if you like. Is that right?
Yeah, I'm happy to accept it subject to check, but if we're going to get into the specifics, I'd like to have the document in front of me.
Okay. It has been uploaded as Prosperity Works Exhibit 1 RJB 3, I believe.
Okay.
And let me know when you have that.
Yeah, I have a document exhibit RGB 3, and it says it's a 214-page document. Is that the one you're referencing?
It should be 721 pages, I believe. The exhibit within that exhibit, the proxy statement is 214 pages. Is that what you're looking at?
I'm looking at exhibit RGB 3.
Yes.
Yes, and that document, I have a paper copy, but perhaps if you just direct me to the relevant page and we'll go from there.
Sure. And your document has 214 pages, is that what you said?
Yes, there's there's a number of documents within that tab, but yes, the tab says page is X of 214.
Okay. Anyway, one of the reasons, we'll go ahead and turn to page 124 of 214, which should be page 124 of that exhibit. Let me know when you're there.
Yes.
Okay. And let me get there, make sure we're at the same place.
Just to be clear, across the top, it says agreement and plan of merger.
It should say future shareholder proposals.
Mr. Michael, let's just see if we can work through this together. The document that we're looking at is Exhibit RJ3.
Yes.
And we have gone to what at the top of the page on the right says application D, page 124 of 214.
Yes.
I take it not it. Okay. And so on that page, it says agreement and plan of merger.
Yes, you're correct. I was looking at the wrong page.
Okay, great.
Okay, are we all on the same page? Okay, great.
Yes.
And if you look at that page, one of the reasons the merger was being recommended was the $400 million stock purchase agreement. Is that correct?
I don't know. The recommendation for the merger is really a recommendation that would come from the board of the company, I believe. I don't believe it's for the purchaser to make a recommendation.
Well, do you see this second to last whereas clause?
Whereas the company parent merger sub desire to make certain representations, warranties, covenants, etc.
Yeah.
Yeah.
No, whereas the company and Troy Topco, a Delaware limited partnership that directly or indirectly wholly owns parent, simultaneously with the execution of this agreement, are entering into a stock purchase agreement pursuant to which, and I'll paraphrase, the company will issue and sell and purchaser will buy 8 million shares for $400 million. Do you see that?
Yeah, I see that. Yes.
Okay. And that merger agreement is included in the proxy statement that's available to shareholders, right?
Correct.
Okay. And this merger agreement, one of the premises is that for entering into this merger agreement is that Troy Topco is agreeing to purchase 8 million shares from
So much of
TXM.
the premise. I think they're two separate agreements. So I guess I disagree with the word the premise. There was an agreement to purchase 8 million shares of common stock, and then there was a separate agreement that the joint applicants entered into in relation to the merger.
And the stock purchase agreement is referenced in the merger agreement, isn't that right?
Yes.
And it's referenced as one of the premises for why that agreement isn't being entered into. Isn't that what a whereas clause does?
I would object. The basis for the objection is that Mr. Sherman is not a lawyer. And so questions concerning what the basis of a whereas clause are would be better directed to counsel, not to a fact witness.
Any response to that, Mr. Michael?
Yes, I would like him to be able to answer to the best of his ability with based on his familiarity with these agreements.
Yeah, I'm going to overrule that objection. I think that it's within the scope of his knowledge as a fact witness, a question like that. So you can go ahead and answer, sir.
Thank you.
Yeah, look, well, again, my interpretation of the word whereas in this context is it's describing the agreement involving the purchase of the shares of common stock. That's, I think, what that paragraph is doing.
And is it your recollection that shareholders were also told in the proxy statement that the TXNM board discussed the importance to the overall transaction for the bidders to provide interim financing through the pipe transaction?
Yeah, I mean, look, I don't remember precisely what was written regarding the deliberations of the TXM board. I wasn't in those meetings, but if it's in the proxy, then I believe it to be true.
Okay. And so isn't it possible that a shareholder that voted for the merger agreement might wonder if it is still the best deal available to them if a key component of that agreement is considered void?
Again, my understanding of the agreements is that if either agreement is voided, it does not have any bearing on the other agreement, and that the other agreement.
I'm asking you, that's not my question. My question is whether a shareholder that voted for the merger agreement and was provided all this information about the importance of the stock purchase agreement, having that agreement voided, might that not give a shareholder cause to question whether the merger is still in their best interest?
Look, that's really, I think, a question better directed, in my opinion, to a securities attorney who understands sort of securities law and whether votes need to be retaken. But again, my knowledge, I've consulted with counsel and I've reviewed the agreements. My understanding is there is no need for another vote of the shareholders.
Well, I'm asking you not from a legal perspective, I'm asking you from an investor perspective, and whether a shareholder of TXNM might not think, well, now that the stock purchase agreement is no longer part of all these transactions, maybe there's another bidder out there that might beat the 61.25, and we should consider that. Isn't that a possibility?
Well, look, my recollection is that the company ran an extensive process with many bidders. It contacted many parties. All of that is described in the merger agreement. Again, I didn't run the process. I was just one of many bidders. And so I guess you're implying that there would be a different bidder who might emerge with a superior proposal. Like, I don't have a perspective on that. What I do know is they went out broadly with the bank and contacted many parties and asked parties to submit the best bids they could.
I understand that, and maybe I'm not, being clear enough. I guess the gist of my question is from the shareholder perspective, and whether, given that the information in the proxy that they were provided and they were told was important, if that information turned out to be misinformation because the stock purchase agreement is void and of no effect, that could indeed impact how they view this transaction and whether or not their vote to approve the merger might need to be reconsidered. Isn't that true?
Well, look, at the time the merger agreement and the proxy were filed, again, the joint applicants believed all the information in the agreement to be accurate. And so at that time, it was accurate.
But if the transaction turns out to be void and of no effect, and by that I mean the stock purchase transaction, the information shareholders provided would be wrong. Correct.
Well, it would be different. I don't know if it would be wrong. It would be different, and now the parties would have to determine what the consequences are of those differences.
Okay. I think we've exhausted this discussion for now anyway. Thank you.
Actually, Mr. Michael, can I pause your time and just add one more question to that?
Of course. Yes, of course.
If the scenario that Mr. Michael is explaining happens and the transaction is voided, is it automatic? Will the shareholders who voted in favor of the merger automatically have an opportunity to reconsider or change their vote, or is that something that would have to be granted to them?
I'm not aware of any need for another vote of the shareholders in the circumstances where the commission determines that the shares need to be voided.
That wasn't my question. I wasn't asking about whether or not there would be a need for another vote. It's a technical question. Is there a provision that provides that if a material element, as Mr. Michael is arguing this is, changes significantly, that the shareholders who voted in favor would be able to reconsider their vote or change it?
I don't know.
An option?
I don't know the answer to that question.
Is there another witness that might? If you don't know, it's okay to say so.
Yeah, I don't know.
Okay, that's fine. Mr. Michael, I paused your time. Thank you for allowing me to ask that question.
Thank you, Madam Hearing Examiner. Could you turn to page 10 and lines 7 through 9
Of
your testimony? I'm sorry.
You said page 10, lines 7 through 9?
Yes. And if you could also open to page 107 of 214 of the proxy statement that you were looking at just a moment ago. Are you there?
I have both pages in front of me.
Great, thank you. And on page 10 of your testimony, you quote TXNM 8K filing saying, quote, "The stock purchase agreement and the merger agreement are separate transactions and neither transaction is conditioned upon the consummation of the other," unquote. Do you see that?
I do.
Okay. But it's true, is it not, that TXNM could have terminated the merger agreement if the stock purchase did not close. And I think you acknowledge that further down at lines 19 through 21 of that same page of your testimony. Is that right?
That is right.
Okay. And now to just add some flesh to that acknowledgement, in the proxy statement, does it not say at that page, quote, "Pursuant to the merger agreement, TXNM could also have terminated the merger agreement as a result of TXNM terminating the Blackstone stock purchase due to the purchaser under the Blackstone stock purchase agreement failing to consummate the closing of the Blackstone stock purchase agreement"?
I see that sentence in paragraph. Yes, I do.
And that is what it says. And I assume the Blackstone stock purchase agreement is the Topco purchase.
Correct.
Okay. Those are all the questions I have. Thank you very much, Mr. Sherman. Madam Hearing Examiner, I intend to introduce the joint application and which includes the proxy statement as part of Mr. Binz's testimony when that arises. But if you would like me to move the admission of it now, since we were discussing it, I can do that as well.
Yeah, we did discuss this previously. Why don't you go ahead and do that now?
Okay. I would move the admission of the joint application that the applicants filed, I believe, on August 25th, 2025?
Right, and is Prosperity Works offering it? Does it have an exhibit number?
It is an exhibit to Mr. Binz's testimony, so it would be Prosperity Works Exhibit 1, Exhibit RJB 3.
Okay, I'm sorry, sir, I misunderstood. I thought it was a separate exhibit. If it is an attachment or an exhibit to Mr. Binz's testimony, we'll go ahead and just enter it at the time that he is presented for cross.
That's fine. Okay, thank you.
Thank
And
you.
Thank you again, Mr. Sherman.
And sir, oh, I'm so sorry. And sir, you have, you didn't use 5 minutes of your time, so I'll go ahead and reserve those if you choose to use them for Ms. Kelly.
Thank you.
All right, thank you. Next in the order of cross-examination for Mr. Sherman is New Mexico Department of Justice. And I believe you've reserved 6 minutes.
Thank you, Hearing Examiner Barrett. Good morning, Mr. Sherman. Can you please state once again your position at Blackstone?
I'm a senior managing director at Blackstone.
Okay. And just so we're on the same page in terms of defined terms that we're
Excuse
talking
me.
about.
Excuse me, Mr. Jimenez, let me interrupt just for one point on clarity. Mr. Sherman, you said you're a senior managing director at Blackstone. Are there multiple entities with the name Blackstone?
Yes, there are multiple entities with the name Blackstone.
Can you please provide the specific name of your employer?
Yes, my legal employer is Blackstone Inc. My duties are to Blackstone Infrastructure and the clients of Blackstone Infrastructure, and in that role, to be more specific, so my business card would say senior managing directors, but as a practical matter, day to day, my responsibilities are leading our efforts on investments in the utility industry and in the transportation industry.
And Blackstone Infrastructure, is that also a corporation, or what kind of business entity is that?
It's an investment manager, and so Blackstone Infrastructure manages funds for approximately 400 limited partners, and so these are pension funds, et cetera. And so those are the investors that provide the capital that we draw upon when we make investments in companies such as TXNM.
So is Blackstone Infrastructure a general partner or an LLC?
I'd have to come back to you on the specifics.
Okay, no problem. I just wanted to clarify your precise employer.
Great. So,
and Mr. Jimenez, I actually hadn't started your time before Hearing Examiner Schaefer spoke, so you've got 6 minutes.
Okay, thank you. Mr. Sherman, so you, just so we're on the same page in terms of the terms that we're talking about, you refer to the Troy Topco purchase of TXNM, the stock purchase, you refer to as the financing transaction. Is that correct in your testimony?
Yes.
And similar to the questions I had for Mr. Terry, Blackstone performs due diligence activities before entering into mergers and acquisitions. Is that correct?
Correct. As well as it performs due diligence when entering into financing transactions that do not involve mergers and acquisitions.
And you yourself are not an attorney, but you do regularly consult legal counsel in advance of some of these transactions. Is that correct?
Absolutely.
Blackstone also, I would assume, regularly takes steps to understand the state and federal regulatory requirements when governing some of these transactions before you enter into them?
Yes.
Can you explain what steps normally Blackstone would take to understand a state regulatory compliance structure prior to maybe purchasing utility in New Mexico?
Yes, I'd say a few things. One, so in this case, we actually had 3 legal counsel. We had legal counsel here in New Mexico, JKW. We had Kirkland and Ellis providing legal advice on the overall transaction. They're not specialists in New Mexico. And then we had an equivalent law firm in Texas called Winstead that advised us on matters related to Texas. K&E would have advised us on regulatory matters related to the FERC, and as well as matters related to the Nuclear Regulatory Commission approval. So essentially those 3 law firms would have provided the substance of the legal advice provided to Blackstone.
And you're familiar with Section 62-6-12 of the Public Utility Act in New Mexico?
Yes, I am familiar with it.
Were there discussions by Blackstone prior to May 18th, 2025 about Section 62-6-12?
Yes, I'd say, look, in the first instance, there were discussions with the company, and so the company approached Blackstone and ran a process that we've now described, and in those discussions with the company, the company affirmed firmly that no regulatory approvals were needed in New Mexico or with other regulators, including the other state, for Nuclear Regulatory Commission, et cetera. So that would be one aspect of the diligence, but there were many others.
If we can move to page 6 of your testimony. You state that Blackstone Infrastructure always considered and intended the financing transaction to be separate from the acquisition, correct?
Correct.
You would agree that the financing transaction was stated in the recitals of the merger agreement, is that correct?
Yes.
Were there discussions within Blackstone about the effect of the financing transaction on TXNM shareholders, share value?
Can you repeat the question?
So when Blackstone was in the process of structuring this merger and acquisition, were there discussions about how this financing transaction, the purchase of stock, of TXNM stock, might affect TXNM and its shareholders or stock or share value?
No discussions in relation to how it would affect the stock or share value, but there was an evaluation of both investment decisions, yes.
And clearly Blackstone would have been aware that the stock purchase would result in a 7.53% ownership interest in TXNM.
Absolutely.
Would you characterize the financing transaction that's stated in the recitals of the merger agreement? Would you state it or describe it as consideration in the merger agreement for Blackstone to enter into this agreement?
Absolutely not.
Why is that?
Well, I'd say a number of things. One, the $400 million sale of common stock from the company to Blackstone, that was capital that was going to the company, not to the shareholders of the company. The merger transaction was a different transaction involving consideration going to the shareholders directly. So the issuance of the shares was Blackstone providing capital to the company so that the company could fund its investment plan. The merger transaction, separate transaction, was the purchase of shares from persons of the public.
And I don't know, Madam Hearing Officer, do I have at least one more minute?
You got
Okay.
one more minute, yeah.
So, Mr. Sherman, both yourself and Mr. Terry have described this process where if the PRC determines that the financing transaction violates 62-6-12, that there are potential options to cure. Is that correct?
That is correct.
And one of those options is to recharacterize or configure the stock purchase as an option contract. Is that correct?
I describe it as an exchange. So there would be an exchange of the shares that Blackstone purchased. And in exchange for the shares, it would receive the option agreement.
And can you explain, will that require a new merger agreement or an amendment to the merger agreement?
It is my belief that it does not.
Do you have an opinion about why it will not affect the merger agreement?
Unfortunately, I don't.
Okay. Thank you. Thank you, Madam Hearing Examiner.
Thank you, Mr. Jimenez. Before I move on to any CBD, I just want to ask a clarifying question. You indicated that there were no less than 3 legal counsels available to Blackstone. Did I hear that correctly?
Yes, those are the 3 that I spent substantive time with. If there were others, I honestly don't recall, but those were the 3.
Okay. And did I hear correctly that there was no independent legal analysis sought by Blackstone from any of these entities, and that Blackstone relied on the representations by TXNM for their legal analysis of the New Mexico statutes?
I'd go further than that, if that's okay, Madam Hearing Examiner. So there were discussions with the 3 law firms across really all regulatory approvals. So Blackstone had discussions with legal advisors. It obviously had the representations from the company. Beyond that, we looked at sort of the existing shareholder composition of TXNM. And we were well aware that there were two other funds, one that owned approximately 11% and another that owned approximately 12%, that both of those funds had full control over their votes. And we were not aware that either one of those funds, from the diligence that we had done, had received or sought approval from the commission. So we looked at that, and that was a factor. But we also looked at shares of common stock by other utilities. And so there are a number of utility holding companies in the United States and in Canada that have operations in New Mexico. And a number of those companies have issued shares of common stock previously. I won't name them all, but I think that I referenced them in my testimony. And we could find no evidence that when publicly traded holding companies not dissimilar to TXNM issue shares of common stock to investors, we could find no evidence that that those other utilities themselves had sought approval from the commission to issue shares of common stock.
Okay. And that was as you said, was somewhat beyond the scope of my question. And that's fine. My specific question is much more simple than that. Was there anyone who provided a memo or a discussion purely dedicated to the examination of New Mexico law and statutes and regulations and an analysis of those to you?
No.
Okay, thank you. Okay, moving on. Next on our order of cross-examination is New Energy Economy, Center for Biological Diversity. And Ms. Nanasi, you had used 20 minutes of your 30. How many of your remaining would you like for Mr. Sherman?
I would like to use 1 minute of my 10 minutes left for Mr. Sherman. May I proceed? Thank you. Mr. Sherman, good morning. If the commission declares that joint applicants violated 62-612 and determine that the stock acquisition shall be void and of no effect, and that has been interpreted as meaning that void is quote, as if it never happened, unquote, what would be left to exchange in your proposed exchange agreement?
Well, the company, TXNM, has received a $400 million investment from funds managed by Blackstone for the LPs that I described earlier. And so the company has an obligation, because it's void, to return the funds to Blackstone. And so that's what's being exchanged. Again, this is a draft agreement. It's not been entered into. It's been submitted, from my perspective, for consideration by the hearing examiners and the commission. So what we're proposing is the exchange of those shares for an option agreement.
Thank you, Madam Hearing Officer.
Okay. So you have 9 minutes remaining for Ms. Kelly. And Mr. Elliott, on behalf of staff, is next. And you have reserved 6 minutes.
And I believe I had 8 minutes in total remaining. Is that correct?
Yes.
Okay. Good morning, Mr. Sherman.
Morning, Mr. Elliott.
Staff's brief ended with the statement that that if the joint applicants were to positively and contritely acquiesce to the commission's findings, a hearing on the merits of the underlying application was still possible. Are the joint applicants, as Blackstone is one of them, prepared to accept a finding of a violation along with meaningful financial penalties and governance conditions if that's what the commission determines is necessary?
We're prepared to accept the decision of the commission, yes.
I asked Mr. Terry if, based on all the evidence that's been presented in briefing, if he agreed that a better course of action now would have been to ask the commission for prior approval of the pipe. Do you agree?
I agree. Look, given the context that we're in today, I do agree that that would have been a better course of action.
And Blackstone is acquiring a franchise public utility. And you understand that a large share of its value comes from its exclusive right to serve. Is that correct?
We accept that and we agree with the statement.
In exchange for that franchise, the utility submits to the commission's jurisdiction. You understand that?
We do.
So I just want to understand, is it Blackstone's position that no violation occurred and no conditions are warranted and the commission should simply move on?
It is Blackstone's position that no violation occurred. Yes, that is Blackstone's position.
But Blackstone, just to be clear, is willing to accept financial penalties if the commission determines that's necessary.
Yes.
I have no further questions. Thank you, Madam Hearing Examiner, Mr. Sherman.
All right. Thank you, Mr. Elliott. Moving on. Hearing Examiner Schaefer, do you have questions for Mr. Sherman?
Yes, I do. Thank you, Madam Hearing Examiner. Mr. Sherman, thank you again for taking your time to be with us. I have a few questions. Was Troy Topco LP a public utility at the time of the transaction, the stock purchase?
Regrettably, I don't know the answer to that question.
Was Troy Topco LP associated or affiliated with a public utility at the time of the stock transaction?
It was affiliated with a company registered as a public utility holding company, yes.
And what was that company?
That would be a company further up within the Blackstone infrastructure group. I don't know the full name of that company, but Troy Topco would be affiliated with that company, yes.
And that company that you don't remember the name of is a regulated public utility or a public utility holding company?
It's registered as a public utility holding company.
Okay, so that I think takes care of my next question. Now, what is an LP?
An LP is a limited partner. So that's an investor who commits funds into funds that are managed by Blackstone.
Well, an LP could also mean limited partnership. Is that correct?
Yes, it could.
And what is a limited partnership?
A limited partnership is an entity that can own partnership interests in businesses or enterprises.
And Troy Topco LP was created when?
I don't remember the precise date, but my recollection is it would have been created several months prior. Again, I don't know how many days prior, but it would have been created sometime prior to Troy Topco entering into the agreement to purchase the shares.
And what was the purpose behind the creation of Troy Topco LP?
Its purpose was to acquire the 8 million shares of common stock.
And does Troy Topco LP have any role in the proposed acquisition, the underlying acquisition of PNM?
No, PNM entered into an agreement with Troy Parent Co., which again, through the chain of companies would be a subsidiary entity. So there's a relationship, but they are different entities. And they exist for different purposes, tax planning being one of them. And that's one of the reasons why in the purchase of the shares of common stock, there's one entity versus in the merger agreement, there's a different entity. There's also a scenario in the merger agreement where the merger agreement doesn't close, and so we need different entities.
So is Troy Parent Co. a subsidiary of Troy Topco LP?
That's my understanding.
What is a PIPE transaction?
It's a public investment. It's a private investment in public equity. And so it's an investment when a company enters into essentially a negotiation for the sale of its shares to raise equity with one or more investors. And the reason it's private is the investors who purchase those shares do not have an ability to sell those shares until they're registered with both the stock exchange and the SEC at a later date.
How long have PIPE transactions been permissible?
I don't know the answer to that question.
What is the role of PIPE transactions generally in financial markets with respect to mergers and acquisitions?
Well, there's two questions there. The first one is what is their role in financial markets, and then the second question is what is their role in mergers and acquisitions. So can I answer it's two? Is it?
Yeah, the question was really the latter. Just based on your knowledge of financial markets and your expertise and sophistication, what is the role of PIPE transactions in mergers and acquisitions?
Yeah, so if you're limiting the question only to mergers and acquisitions, they're very common is just a means for companies to raise equity. But your question was quite specific around mergers and acquisitions. They are done, and so I'm aware of at least 3 instances where publicly traded utility holding companies in the United States have entered into PIPE transactions with private investment funds or investment funds such as Blackstone to raise between 5 to 10% of their shares of common stock in a separate transaction, but as part of a process that would have run concurrent.
Whose idea was the PIPE transaction?
The PIPE transaction was proposed to Blackstone by the company, and I believe it was proposed to all investors, not just Blackstone.
And when it was proposed, did TXNM also propose to be acquired by Blackstone?
Yes.
So it was simultaneous.
It was communicated to Blackstone is part of the process in submitting a bid for the whole company.
Have any limited partnerships within the Blackstone infrastructure group that you described earlier engaged in other mergers and acquisitions?
Of publicly traded companies, yes.
And have they also engaged in PIPE transactions with respect to those mergers and acquisitions?
I'm not aware of that having taken place.
You testified earlier that you did a due diligence review and looked for evidence of prior approval for issuance of common stock. Is that correct?
Correct.
And you said you found no evidence that issuance of shares of common stock required commission approval. Is that correct?
For the ones that we saw that had taken place in New Mexico, yes, we couldn't find any evidence of that.
And did you determine whether any of the cases that you discovered or reviewed resulted in control of the company or were for purposes of acquiring that company?
None of the issuances of shares of common stock that we were aware of had been entered into contemporaneously or on or around the time of a merger transaction.
I guess my question is more specific to the cases that you testified that you and or your colleagues had reviewed with respect to the issuance of shares of common stock not requiring commission approval. And the question is, did that research or that review determine that the issuance of those shares in those cases were for purposes of acquisition or just for purposes of acquiring shares?
The issuances of those shares would have been for purposes of funding the business, and so there was no connection or no acquisition contemplated.
Um, what is the significance of 10%? Mr. Terry referred to the pipe transaction as being structured such that it would result in less than 10% of outstanding TXNM shares. Are you aware of that architecture or design?
I'm aware of it generally. I'm not an attorney, but I'm aware of it both here and in other jurisdictions.
So you were in discussions with TXNM to limit any equity infusion that would result in greater than 10%, in acquiring greater than 10% of the company's shares. Is that correct?
Look, the proposal was an investment of 400 million, and so it wasn't. There really wasn't a negotiation on the ownership percentage. The company was looking. My understanding was to raise 900 million, and it proposed that Blackstone fund 400 million of the 900 that it needed to fund its operations, and so there was really no contemplation as part of the process for more than that.
And you testified earlier that Troy Topco LP is one of the limited partnerships underneath or within the Blackstone Infrastructure Group. Is that correct?
Correct.
Are there any other entities within the Blackstone Infrastructure Group, including subsidiary entities, that have engaged in pipe transactions not connected with a merger and acquisition?
Yes.
Which are they?
Well, with respect to a pipe transaction, there was the First Energy transaction that I worked on where we acquired approximately 5.1% of a publicly traded holding company that had electric utility operations in 5 or 6 states, is my recollection.
So just that one company?
Well, that's as a pipe transaction, but the word you're using is a very specific legal term. In other instances, Blackstone has acquired shares in one other instance that I worked on. And in the last sort of 5 or 6 years, we acquired shares in a publicly traded utility holding company. It wasn't a pipe transaction. We just acquired shares in the public market, which would leave us in a position very similar to holding the shares here were the merger not to close and we were left holding a $400 million interest. That investment would be very similar to this other investment that I led at Blackstone Infrastructure. There's a third investment that we made that was a minority stake, neither a pipe nor a public investment, but had no contemplation of control. And so it was a minority investment in a utility in the state of Indiana. So those are the 3 investments, all in the last 6 years in the utility sector in the United States that I've worked on that have been completed. There's others that we've looked at that we've contemplated pipes, where ultimately we were outbid on the pipe by, say, another bidder who had a more competitive price or better terms.
And how many entities are contained within the Blackstone Infrastructure Group?
I don't know the specific number. I'd have to come back to you.
Is it more than 50 or less than 50?
I tend to think of it as companies that we invest in. And so there's approximately, somewhere between 20 to 25 operating companies that we've invested in.
Well, thank you very much, Mr. Sherman. I have no further questions.
Thank you for your time, Mr. Hearing Examiner.
Thank you.
Thank you, Hearing Examiner Schaefer. Mr. Sherman, I have a couple of questions for you. The first refers to your direct testimony, which has been entered as an exhibit on page, this would be PDF page 9, but on the bottom of the page, if you're looking at a written document, it's page 7.
Okay, thank you.
Let me know when you're there.
There, thank you.
At the bottom of page 7, you testified, while the financing transaction made sense to me from a business perspective, I also believed that the 400 million investment would demonstrate to the Commission and people of New Mexico that Blackstone Infrastructure was dedicated to investing in New Mexico and helping ensure long-term access to capital for PNM. What purpose other than this acquisition would Blackstone have for demonstrating to the commission or the people of New Mexico that they were dedicated in investing in New Mexico and helping to ensure long-term access to capital for PNM?
Well, look, we always strive when we make investments for the investments to be productive and to help the businesses grow and help the local communities. And so elsewhere in my testimony, we were quite proud of the fact that in the pipe investment we made with First Energy, we believe that our investment ultimately resulted in a credit rating upgrade of that investment. So it wasn't just looking at really the dollars and cents of the investment, but we think that the investment itself actually benefited the company and indirectly the communities. And so that statement is made in that context, which is as it states.
But if it's not for the purposes of the acquisition, why was PNM chosen as a company that you wanted to demonstrate a commitment to and ensure access to long-term capital?
I want to make sure I understand your question here, Madam Hearing Examiner. The question is specifically in relation to why we wanted to demonstrate the access to the capital.
According to your testimony, the purpose of the pipe was not just that it was a good idea from a business perspective, but to demonstrate these things that I already said. What was the thought process behind choosing PNM and by extension New Mexico as the company that you wanted to demonstrate this kind of commitment to, if not the acquisition?
Well, look, so the thought process behind the investment again was that the shares we thought were reasonably priced. So the shares of TXNM, not of PNM, but of TXNM, that's what we were acquiring in the financing transaction, were reasonably priced. They were priced at a slight discount to the broader electric utility index in the United States, with growth about 50% higher. So we thought it was a compelling investment in the shares of the common stock of the company. And we felt that providing that $400 million of capital would be beneficial to the business. You know, the business had convinced us that it had needs for that $900 million of capital, smart metering and other productive investments in the state of New Mexico. And it's important to us that our investments, you know, fund productive enterprises and that, you know, are reputationally beneficial. Our investors don't just look for us to make investments; they also expect the investments to be productive and to have, you know, a greater purpose and benefit the communities.
Is it common for Blackstone to make this scale of investment into a company that they have no further interest in?
A $400 million investment in a company in which, yes. Yeah, so the examples that Hearing Examiner Schaefer asked me earlier, there was the First Energy example I cited where we invested approximately $1 billion. There's another example I cited, I won't mention the name of the company, but it's well known to a number of the intervener groups. We invested approximately more than $300 million in a company where we had no further interest. So yes, we've done this before.
So the purpose for those investments wasn't to demonstrate to the regulatory commissions in those areas or the people of those states that you were dedicated to investing in them?
Well, no, like in the First Energy case, they were taking our capital, not dissimilar to here, to pay down debt and to essentially transfer the equity from the holding company into the subsidiaries to invest in their businesses. So I think that the First Energy example is actually very comparable to this example.
Yeah. And moving on to my second question, in your knowledge and experience, it's possible and somewhat common to use separate instruments, meaning separate contracts, separate agreements, all in the furtherance of the same transaction?
Is it possible to have separate agreements on the furtherance of the same transaction? I don't know the answer to that question.
And you would agree with me, would you not, that separate instruments or separate transactions can be separate but still related to one another?
Absolutely.
Okay, that's all my questions. Thank you. Hearing Examiner Schaefer, did that prompt any more questions on your behalf?
No, thank you.
Okay, is there any redirect for Mr. Sherman?
No, thank you.
Okay. And does any cross-examining party have any limited and in scope questions based on the redirect? Oh wait, there was no redirect. I'm sorry. So we'll move on. My apologies. It's getting close to lunch.
Ma-
So thank you, Mr. Sherman, for your testimony.
Madam Hearing Examiner?
Mr. Michael?
Yes, I believe if I read your pre-hearing order correctly, that we would be permitted to follow up on some of the questions that the hearing examiners had of the witness. And I have two follow-up questions in that regard, if I may.
I think you're right, Mr. Michael. Go ahead and same applies to anyone else.
Thank you. The first question has to do with your response to hearing examiner Barrett's question to you. And you said that your understanding was the capital you provided, the 400 million, was used to pay down debt. What's your specific understanding of how that capital was used and how much of it was used to pay down debt?
Unfortunately, I don't know the specific amounts. I do know that some of it was used to pay down debt because we were told that that would be some of the uses, but we were also told that some of that capital would be used to maintain the equity ratios of the two utility subsidiaries.
And you don't know the proportion?
Do
Okay.
not.
The second question has to do with your response, I think, to both hearing examiner Barrett earlier and examiner Schaefer as well. And you had indicated that you were aware of a number of instances where holding companies issued stock and did not have to get commission approval. Do you recall that?
I don't know how many instances, but yes, I was aware of some issuances.
Okay. And do you understand that there is a distinction in New Mexico between approval for issuing stock and purchasing stock? And by that, I mean issuing stock is governed by 6266, and it relates to public utilities only, not necessarily holding companies. Whereas 62612 deals with purchasing stock and relates to any person, given the parameters and the rest of that statute. Do you understand that issuance of stock is not the question here? We're talking about the purchase of stock and whether or not that violated 62612.
I understand. Yes.
Do you understand that? Okay. Thank you. That's all the questions I have.
Thank you, sir. Okay. Thank you again,
Madam-
Mr. Sherman.
Madam Hearing Examiner, can I follow up on a couple of questions?
Yeah, make it brief, please.
Thank you. Sir, Mr. Sherman, isn't it true that originally Blackstone / Topco offered more than $400 million in a stock acquisition to TXNM?
I don't recall that.
And is it true with First Energy that Blackstone purchased a 19.9% share of NIPSCO?
Yeah, the NIPSCO transaction and the First Energy transaction are two different transactions. One, I don't remember the precise years. I think First Energy was in 2021, Ms. Nanasi, and I think NIPSCO, racking my memory here, I think was summer of 2023. But those two transactions are unrelated. They're two separate investments.
Yes, I conflated them. I apologize. And in the NIPSCO one, that was a 19.9% share. Is that right?
Correct.
And in that instance, you were put on the board of NIPSCO. Is that also true?
I'm going to object to the question as outside the scope of the examination by the hearing examiners, which didn't touch in any way on NIPSCO.
Well, if I may answer, I believe that it did, because Mr. Sherman talked about how the investment in the 400 million here was similar to the investment in NIPSCO there, where they made an investment. And I believe that was in response to Mr. Schaefer's question. And one of the things that Mr. Sherman said was that they didn't have a controlling interest. And I don't believe that that's factually correct. And I think that this is important for this commission to know that, and also hearing Examiner Barrett, you asked a bunch of questions about, like, well, what was the purpose of the 400 million? Was it to have was it about the acquisition? And I think this goes exactly to that. And I think that there's been a perception left.
Thank you. Thank you.
Okay, Ms.
Thank you, Ms.
Nasi,
Nasi.
you're
Thank you.
testifying at this point. What is your specific question? Did the transaction at issue result in a board seat? Is that your question?
Yes.
Okay, you may answer yes or no to that question, and then we're going to move on.
Yes, it did.
Okay, move on, please.
I do have other questions about NIPSCO, but if that's your ruling, I won't ask anything further.
Yes, thank you. All right, thank you. Hearing nothing else, thank you very much, Mr. Sherman, for your testimony, and you're excused. We are going to go ahead and take our lunch break. We will do, let's do 45 minutes. And let's plan to be back here at about 5 minutes until 1. And we'll be off the record until then. And everyone, please remember the YouTube streams even over our lunch break. Thank you.
Thank you.
Thank you.
Madam Hearing Examiner, just making a sound check. Do you hear on the witnesses screen? Is there audio coming from us?
There's audio and it sounds good. No echo or anything.
Thank you.
You're welcome.
Madam Hearing Examiner, this is Melissa, the court reporter. I want to make sure that whoever is for the joint applicants, when they do their direct, that they let me know who they are, because it just says attorney and I don't know everybody, so.
No problem at all. That's okay, right, Mr. Heverly? Okay.
Okay, thank you.
I will take care of that. Not to worry.
Thank you.
Great. I also just want to note that throughout the morning, there were certain people that were popping up as having come into the waiting room on the Zoom. And if I recognize that person, I would let them in because, you know, we get kicked out, things happen. If I didn't recognize their name, I did not let them in. So if someone who is associated with one of the parties needs to be let back in, feel free to interrupt and let me know. So I'm not leaving anybody else out who's supposed to be here. All right, it's 12:57. Ms. Gonzalez, whenever you're ready, we'll go back on the record.
I'm ready.
All right. The time is 12:57. We're back on the record. Next in the order of witnesses is PNM's last witness. So PNM, if you're prepared, you may call your witness.
You're on mute.
I apologize. I thought I had seen the light go off. Thank you, everybody. This is Brian Haverly on behalf of the joint applicants. The joint applicants call Sudeen Kelly as their next and last witness.
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I proceed, Madam Hearing Examiner?
Go ahead.
Thank you. Ms. Kelly, would you please state your full name for the record?
My full name is Sudeen, middle initial G, Kelly.
Ms. Kelly, who are you employed by and what is your position?
I'm employed by the law firm of Jenner and Block, and I'm a partner in the law firm.
Ms. Kelly, you have in front of you what has been marked Joint Applicant Exhibit Number 3. Do you recognize this document?
Yes, I do.
What is it?
It is my testimony and attached exhibits.
Was this testimony prepared by you or at your direction?
The testimony was prepared by me, and the first exhibit, my resume, was also prepared by me. My second exhibit was I directed the paralegal to attach the newspaper articles that comprise the second exhibit.
And Ms. Kelly, do you have any changes or corrections to your testimony at this time?
Yes, I do.
What are those corrections or changes?
On page number 9 of my direct testimony, at line 7, I refer to a case number, and that case number needs to be corrected. Specifically, in my filed testimony, I referred to case number 11-00095, and I would like to correct that to be case number 11-00085.
Are there any other corrections to your testimony?
No.
For the record, Madam Hearing Examiner, I will represent that the joint applicants have uploaded the corrected version of that paper with the interlineation of that correction.
Okay, thank you.
Ms. Kelly?
Go ahead.
No, go ahead. Sorry.
Oh, no, I'm sorry. I was jumping ahead. Please continue.
Okay. Sure. Ms. Kelly, if I asked you the same questions contained in your testimony exhibit number 3 today, would you provide the same answers as corrected?
Yes, I would.
And those answers as corrected would be true and correct as to the best of your knowledge. Is that correct?
That's correct.
Madam Hearing Examiner, I move for the admission of joint applicant exhibit number 3.
Thank you. Aside from the standing objection that's already been noted for the record, is there any objection to the admission of joint applicants exhibit number 3 corrected as indicated by the witness? Hearing no objection, the exhibit is admitted.
Thank you, Madam Hearing Examiner. With that, I tender the witness for cross-examination.
Thank you, Mr. Haverly. So for Ms. Kelly, we have Prosperity Works up for cross-examination first, and they've reserved 20 minutes.
Thank you.
And Madam Hearing Examiner, I don't think I'll need it, but I think I do have a few extra minutes, residual minutes from other cross. Good afternoon, Ms. Kelly.
Good afternoon, Mr. Michael.
Could you have your deposition available to you while I'm cross-examining you? I'm hoping I won't need to introduce it as an exhibit, but referring to it may help speed things up. It's marked as...
I do have it.
Okay, and it's been marked as PW Exhibit 2. And as I'm asking you questions, they'll mostly, perhaps entirely, be related to questions I've already asked you in your deposition. So if you need a reference or would like to look at a reference, I'm happy to provide that as I ask you these questions. So my understanding is you're not aware of any time in New Mexico when a pending but not yet approved utility acquisition was preceded by a stock purchase by an acquiring investor. Is that right?
Mr. Michael, can you refer me to the?
Sure.
Line
Yeah, if you look at the bottom of page 29, top of page 30.
Yes, my answer in the deposition was I am not aware, although I seem to recall that either witness Terry or Sherman has testified about instances, although not in New Mexico.
Okay. Thank you. And if a merger proposal to the commission or to the PRC is inconsistent with the public interest, it should be denied. Is that right?
Let me just refer to the statute.
Okay. And you can also, if you like, refer to page 33 of the deposition.
The relevant provision of New Mexico law, section 62.613 says, unless the commission shall find that the proposed transaction is unlawful or is inconsistent with the public interest, it shall give its consent and approval in writing.
Okay. So my question was, if a merger proposal to the PRC is inconsistent with the public interest, it should be denied. Is that correct? Is that your opinion?
Well, I would say the commission should not give its consent and approval in writing. On occasion, the commission imposes conditions and does not deny the merger or acquisition, but rather imposes conditions.
And those conditions would presumably cure the inconsistent with the public interest outcome?
I believe so.
Okay. And would you also agree that a merger proposal that's unlawful should be denied by the commission?
It should be, the statute says that the commission shall not give its consent and approval in writing if it is unlawful. Again, unless the commission does have the power to condition its approval.
Okay. Now, prior to filing your testimony, you were not familiar with the images of the original 1989 Senate Bill 157 amendments and final version that were attached to Mr. Binns's testimony as Exhibit RJB2. Is that right?
That's correct.
Okay. And my understanding is that even after looking at that exhibit and those images, that not a single opinion in your testimony has changed. Is that right?
That's right. It's not changed my opinion in my testimony.
It has not changed any of your opinions.
No.
Okay. And by no, you mean no, it has not changed your.
No, it has not changed any of my opinion.
Thank you. And you do not, and you may want to refer to the deposition here at 48 and 49. You do not disagree that the phrase void and no of, well, I'll wait till you get there.
I'm there.
Okay. You do not disagree that the phrase void and of no effect refers to an instrument, contract, or provision that is invalid from its inception, holds no legal force, and cannot be enforced by any party, and is treated as if it never existed, right? You do not disagree with that statement?
Objection, Brian Haverly.
What's your objection?
Calls for legal conclusion.
Mr. Michael?
Ms. Kelly has testified extensively as to her background and expertise in public utility law and policy. This is in part a mix of both. I believe it's, given all the testimony Ms. Kelly has provided and given her background and expertise, I think she can answer it to the best of her ability.
Yeah, I agree. I'm going to overrule that objection and allow her to answer.
I'm going to read that question again from the deposition.
Okay.
Given all the caveats that I do not know where this statement came from, if it's a statement of law, or where it came from, I think you're asking me whether I think I'm unclear what you're asking me to say. You're saying, does void and of no effect refer to an instrument, contract, or provision that is invalid from its inception?
Holds no legal force and cannot be enforced by any party and is treated as if it never existed. And I believe your answer was that you have no reason to disagree with that. Is that correct?
I have no reason to disagree with that. It was my answer. Of course, what void and no effect, the application of it to an existing contract, it's unclear from your question what the application is.
Okay. You agree that if a person holds voting rights to 10% or more of the voting securities of a company, you're holding a beneficial interest in those securities that would satisfy the control definition of 62-3-3, subsection 2.
I'll refer to that statute.
Okay, and this also came up in your deposition at page 57.
In New Mexico, in the Public Utility Act, section 62-3-3, you are correct that control includes instances when a person has a beneficial interest, owns or has a beneficial interest in 10% or more of voting securities of a public utility.
Okay. And your opinion was that holding the voting rights to 10% or more of the securities was holding a beneficial interest in those securities. Is that right?
I do believe that voting rights to shares of stock constitute a beneficial interest.
Okay, thank you.
If they don't hold title to the stock.
I'm sorry, please repeat.
If they don't hold, I should clarify that it is a beneficial interest if title to the stock is not held by that person.
Okay. Ms. Kelly, that's all the questions I have. Thank you very much for your time.
Thank you.
Thank you, Mr. Michael. Department of Justice. I believe you have 7 minutes reserved for Ms. Kelly.
Thank you, Hearing Examiner Barrett. Good afternoon, Ms. Kelly.
Good afternoon.
You served as a New Mexico Public Regulation Commissioner for 4 years, correct?
Correct, although it was called the New Mexico Public Service Commission at the time.
Okay, thank you for the clarification. During that time, you were called to approve and disapprove utility acquisitions and mergers, is that correct?
That's correct.
In your testimony, we've talked a lot about the Public Utility Act, but particularly your testimony discusses interpretations of Section 62-6-12. Is that correct?
I do not testify as to interpretations of the statute. I am here to provide context surrounding the amendment of 62-6-12.
Certainly. And talking about that amendment, your testimony discusses the change of control that's sort of governed by this particular section of the statute. And in particular, would you agree that your testimony states that one of the purposes of Section 62-6-12, subsection A, is to regulate stock purchases that represent a change of control? Is that correct?
Could you cite me to the provision of my testimony that you're referring to?
Certainly. So peripherally, when we look at page 11 of your testimony, lines 10 through 21.
Yes.
You indicate that this particular section of the Public Utility Act, the underpinning of it relates to transfers of control. Is that fair to say?
If you let me read the answer, the question that I posed is whether the 62-6-12A3 aligns with policy considerations that underpin the Commission's interest in regulating utility acquisitions and transfers of control. Okay, I've read the answer, and could you repeat your question again?
Certainly. So I stated a different way. One of the points that you're making in your testimony is that the types of stock purchases that should be regulated under 62-6-12 are those stock purchases that result in a change of control. Is that correct?
I am seeing that Prosperity Works interpretation that stock purchases resulting in less than change of control should not be seen as coming under this provision of the statute.
And you cited I think Mr. Michael also mentioned it's this article from 1989 that was in relation to Senate Bill 157 from 1989. Do you recall that?
Yes, I cited 2 articles.
In talking about Senate Bill 157 specifically, what would you say was your conclusion about, you mentioned it a little bit ago, but this idea of what was the purpose of that particular provision of the Public Utility Act with regard to changes of control in the 10%? What did those articles mention, if you recall?
Well, what I testified to was that the problem perceived by the legislature in 1989, when it proposed to amend the statute, was that the New Mexico Public Service Commission might not have the authority to approve acquisitions, consolidations, and transfers of control by a utility or public utility holding company outside of New Mexico.
And that 10% requirement that they discuss in the articles when they were in the drafting or the debate about the bill, did that 10% requirement make it into the final bill governing 62-6-12?
No, it didn't. Although the final bill still contained changes in control.
On page 7, if you can go to page 7 of your testimony.
Yes.
At the bottom on line 22, it states, practically speaking, the acquisition of shares of stock in an amount less than a controlling interest is unlikely to be contrary to the public interest. Do you see that?
I do.
Would you say that there could be other good reasons why the state of New Mexico would want to regulate stock purchases less than 10%?
I have no reason to think that the legislature would think that was a good idea.
Would there be an interest by the legislature to regulate vertical market competition or horizontal market competition?
My understanding is that we do not have vertical or horizontal, that we do not have competition in our public utilities in New Mexico.
Is it possible for a utility, a regulated utility or a public utility holding company in a different state or different region to basically make creeping acquisitions of a utility like PNM over time?
Could you repeat your question? Sorry, I just didn't understand.
So talking specifically about a public utility or a public utility holding company in a different state or region in the country, without gaining a controlling interest with a purchase of stock, is it possible for some entity in another state that's regulated to make a purchase in New Mexico over time, or a sequence of purchases that could result in a controlling interest? Is that something that the legislature might be concerned about, if you could say?
I'd like to look at the statutory provision because I think that covers what you're talking about.
Sure.
62-612.
And Mr. Jimenez, you've actually run through your time, but you can go ahead and finish this question.
I think I have your, let me just repeat the hypothetical, Mr. Jimenez, to make sure I got it correct. I think what you are seeing is if a public utility holding company in another state makes a stock purchase, let's say 8% of a utility, a New Mexico Utilities common stock, and then a year later purchases another 2%, such that it is 10%, would that be covered by this statutory provision? I believe the answer is yes. They would need pre-approval for the 2% if it's going to jump their total investment in New Mexico to 10% or greater.
Thank you, Ms. Kelly. Thanks, Hearing Examiner Barrett.
Thank you.
Great. Next is New Energy Economy, Center for Biological Diversity. Ms. Nanasi, am I correct that you have 9 minutes left to your total time?
Yes, ma'am.
Okay, go ahead, please.
Thank you. Good afternoon, Ms. Kelly. We met before when we had your deposition 3 days ago, and my name is Mariel Nanasi. I represent New Energy Economy, and for the purpose of this questioning, I'll be asking questions on behalf of New Energy Economy and Center for Biological Diversity. Could you please keep the deposition open? I have a question. Mr. Haverly, when he was introducing you and your testimony, you just answered that a paralegal pulled those exhibits that appear as SK2 for your testimony. Do you remember that question and answer from Mr. Haverly just a few minutes ago?
Objection, Brian Haverly misstates the witness's prior testimony.
No, I actually think that was her that was her testimony.
I apologize. My recollection was that she said that she had it.
Objection to Mr. Haverly's.
Ms. Nanasi, let him. We're talking for just a second.
I apologize if that was the case. I thought I had heard her say that she had asked a paralegal to put it into her testimony. So if I am wrong, I apologize.
Okay.
That is correct. That the paralegal attached it to the document that I was preparing. The paralegal did not do the research to find the newspaper article. I think that was your question, Ms. Namasi.
Yes, and is it true, Ms. Kelly, that a partner of yours pulled that, retrieved those documents for you, and you included them in your testimony?
A partner of mine, I asked a partner of mine to see if she could find any newspaper articles referring to SB 157. And she provided with 2 newspaper articles, which I had the paralegal attached to my testimony.
And Ms. Kelly, yesterday, at about 2 p.m., the joint applicants filed supplemental testimony for you on New Energy Economy exhibits to the 10th set of interrogatories. Is that correct?
Yes.
And I don't have the exact number in front of me, but subsequently, the 10th set of interrogatories that you answered regarding other newspaper articles contained about 10 other articles from the Albuquerque Journal and maybe other, I think it was AP or Reuters. Is that also correct?
Excuse me, I don't mean to interrupt, Ms. Kelly, and I'm so sorry to do so, and I'll pause your time. I'm noticing that emojis, thumbs up, things like that are being utilized by the other parties. It's not allowed in hearings. It's considered, it's inappropriate. So I don't know who's been doing it, but please take note of that and don't do it anymore. And Ms. Nanasi, I'm so sorry to interrupt the flow of your questioning.
Thank you. Do you need me to repeat that, Ms. Kelly, or do you know what I asked you?
No, the question you just asked me before, you asked me about supplemental testimony, and I pulled the document that I believe you are referring to, and it's not supplemental testimony. The joint applicant's first supplemental objections and responses to New Energy Economy's 10th set of interrogatories and requests for production of documents. So I just wanted to clarify that.
Okay, and when you supplemented the answers to interrogatories, but you did testify to that, right? You gave a sworn statement that these are other documents that were found that were about SB 157 from 1989. Isn't that right? And you swore to that.
I did not swear to testimony. What I did was, after you shared with me during the deposition that you had found additional articles, I asked my partner to do more research to see if she could find additional articles, and she found them. And I attached them to, or asked joint applicants to attach them as a supplement to the previous answer to your interrogatory request for production of documents, so that you would know that I had found them. And that's what I swore to.
Ms. Kelly, could you open NE CBD Exhibit 5 and also 6 at the same time, if you would? Are you with me?
I believe so. Is it the Exhibit 5, the Senate Journal pages having to do with Senate Bill 157?
Yes, actually, new NEECBD Exhibit 6 is the Senate version, and NEECBD Exhibit 5 is the House version. Do you see that? Do you recognize that?
I do recognize them. They are not labeled as House or Senate Journal. So I don't know which. I do recognize them.
And actually, you provided them to New Energy Economy in response to New Energy Economy Exhibit 10-4A and 10-4B, respectively. Isn't that right?
I believe that is correct. I know we provided them. I don't know if that was an answer to 4A and 4B.
When you received those documents from the Jennings law firm in mid-March of this year, did those documents, NEECBD 5 and 6, were they included or incorporated into your testimony at all?
And by incorporated, could I ask you what you mean?
Did you use them in your testimony?
I did not use them in my testimony, no.
And didn't you at your deposition say that you did not find anything useful in those documents and you did not incorporate them into your testimony?
Can you cite me to the page in my deposition that you're referring to?
82, 91, and 97.
Ms. Nanasi, your time's just about up, so this will be your last question, but Ms. Kelly can of course answer.
You said, and this was before you in preparation of your testimony, and my answer was, I wanted that, the House and Senate journals, to enable the preparation to assist for my purposes in preparing my testimony. And you asked follow-on question, okay, and in those journals, did you find anything useful to the preparation of your testimony? Or did you use anything from those journals in the preparation of your testimony? And my answer was, no, I do not believe that I did.
Madam Hearing Examiner, I have just about 5 more questions, and I apologize, this has taken way longer than I anticipated. These were straightforward questions. They were just asked 3 days ago. I didn't expect
understand,
this.
Ms. Nanasi, I'll give you 2 more minutes.
Thank you so much. Is it correct that at your deposition, you admitted that you don't know what the term, quote, acting in concert, unquote, means relative to 62-612, and that you weren't asked to be an expert witness or form an independent opinion about what the statute means when it includes the phrase acting in concert?
Could you refer me to the page, my deposition, that you're referring to?
Yes, ma'am. Deposition, page 59 and 61.
On page 59 of my deposition, you asked me, how would you define acting in concert? And I answered, it depends on the context.
And on page 61, does it not say that you were not asked to provide an independent expert testimony about what acting in concert means in 62-612, and so therefore you couldn't respond to the question?
Well, you asked me,
Just for the record, this was Mr. Michael asking you this, but anyway. On the bottom of page 60 and the top of page 61.
well, I'm happy to read the colloquy. I said I deferred to Mr. Terry and Mr. Sherman, who talked about acting in concert. And the question was, do I have an opinion as to what the statute means when it says acting in concert? And my response was, my recollection is that reading Mr. Terry's and Mr. Sherman's testimony, I agreed with it.
That's not on the page that I was referring to, but that is also correct. But how about on page, the top of 61, where Mr. Michael asked, or acting in concert, right? And your answer was, I'd have to do some research on that. And the question was, so you don't know what acting in concert means? Mr. Haverly objected, form. And then the question continues, in this statute, and your answer was, I don't know how it's been defined by the commission. I think they're the deciders of what acting in concert means.
Right. But what I said was, before that, when I was asked over an objection to interpret that provision, I said, it makes sense to me that it would apply when persons are acting to avoid the commission's oversight or otherwise conceal the nature of the acquisition. In other words, for example, if 2 parties are acting in concert with each other to each acquire less than a controlling interest but have a side agreement to vote together for the same purpose of control, then it would be acting in concert to avoid the commission's oversight of acquiring a controlling interest.
Last question on this
No,
topic.
that has to be your last question, Ms. Nanasi, out of respect for everybody else. You've gone well
thank
over
you.
your time.
Thank you so much. And Madam Hearing Examiner, I would move to enter into evidence New Energy Economy CBD Exhibit 7, which is the deposition of Ms. Sudine Kelly. Clearly, she has referred to it multiple times in her testimony. I would also ask to enter into evidence NE CBD Exhibit 5 and 6.
Let's
We
do one
object.
at a time. Okay, let's do one at a time.
All right.
Let's
So
start with NE CBD Exhibit 5. Aside from the standing objections that have already been noted for the record, are there any objections to NEE CBD 5? Hearing no further objection, that exhibit is admitted. Moving on to NEE CBD Exhibit 6. Aside from the standing objections that have already been noted, are there any objections to the admission of this exhibit? Hearing none, that exhibit is admitted. And Ms. Nanasi, this last one was Exhibit 7?
Yes, ma'am.
The deposition transcript in question. Are there objections to the admission, aside from the standing objections, to the admission of that exhibit?
yes, joint applicants object to the admission of the proffered exhibit number 7. It is far more than what was just asked about, and what was asked about is already on the record through the exchange and the testimony. There is absolutely no reason to have an entire deposition put into the record inappropriately when it has already been asked about under oath and has been transcribed.
Okay, I am going to sustain that objection and deny the admission of Exhibit 7 while allowing the admission of Exhibits 5 and 6.
Thank you, Madam Hearing Examiner. If I could, just for the record, respond to their objection.
Ms. Nanasi, there's no need to respond to their objection. I've already ruled. I'm sorry to interrupt you, but we are cutting into everyone else's time.
Thank you.
Thank you, ma'am. Next up in the order of cross-examination, Mr. Elliott on behalf of Commission staff.
Thank you, Madam Hearing Examiner. And just to confirm, I have about 5 minutes remaining. Is that?
Yes, but well, let's call it 6. I think you were in between, so we'll round up to 6.
Okay, thank you. Good afternoon, Ms. Kelly.
Good afternoon, Mr. Elliott.
Ms. Kelly, you testified that the commission's oversight of section 62.612 is focused on, quote, ensuring that any change in control of a New Mexico utility is in the public interest, and that section is designed to capture transactions that change the control of the utility that would otherwise not be known to the commission. Is that your testimony?
Can you refer me to the page?
Page 11 of your testimony, specifically lines starting at 17 through 20. You state specifically, my understanding is that the current section 62.612A3C was designed to capture transactions that change the control of the utility that would not otherwise be known to the commission. Do you see that? I can share my screen if you're having trouble finding it.
I'm sorry,
Okay.
I do see that.
Would you agree that the core purpose of that statute's to ensure the commission's not blindsided by transactions that effectively advance a change of control without its knowledge?
No, I would say that the purpose of that statute is to give the commission the authority to have oversight of transactions that change control in a public utility.
How would they have oversight if they don't have sight of the transaction and prior approval?
I don't understand your question, Mr. Elliott.
Well, you stated that you don't think the intent of this provision is to ensure the commission's not blindsided by transactions that effectively advance a change of control without its knowledge.
The intent is to give the commission the authority to approve them.
And if the transactions already occur, then do they have the ability to approve them once they're presented to the commission?
I think what you're talking about is the provision of 62.612 that says they're void. Is that what you're referring to?
Well, no, I'm referring to the fact that it says with the commission's approval, but not otherwise, right? Prior approval. You'd agree it requires prior approval?
I would agree that it requires prior approval.
So in order for there to be prior approval, they need to be presented to the commission before they're ratified or executed. Is that right?
If they involved a change of control, yes.
But what about those that advance a change of control?
That's not what the statute says, in my opinion.
Okay. In this instance, you'd agree that the commission was the last to know about this transaction, correct?
I don't have any knowledge about that.
Well, let me ask it this way. Under your standard, ensuring the commission has oversight of transactions that would not otherwise be known to the commission, doesn't the execution of the pipe without prior commission engagement, isn't that precisely what we're talking about?
I think the premise of your question is inconsistent with my testimony. I am not testifying. I am testifying that the commission has pre-approval authority over transactions that result in change of control.
And you'd agree that there is no actual, you're inferring that into the statute, correct? Based on your argument of the legislative history, the change of control.
It's in 62.612B.
It refers, okay. Well, I've addressed that in briefing, so I'm just going to move on and ask you this. Is there any provision that you know of in the commission's rules or securities law that would have prevented TXNM from filing a petition for a declaratory order with the commission between February and June, asking whether the pipe required authorization?
I am not aware of anything in the commission's rule that would have prevented that. As far as securities law, I am not an expert in securities law.
Would you agree that when a utility is genuinely uncertain whether a transaction requires commission approval, that the responsible course is to ask the commission?
I think it depends on the situation. If you are prohibited from asking the commission by some other law, then it would be imprudent to do so.
And if there isn't another law?
Oftentimes, a request for a declaratory order is filed.
So is it your expert opinion as a former commissioner that TXNM acted appropriately by never asking the commission for prior approval?
I do not have any problem with the fact that they didn't ask the commission for prior approval. My understanding is that they assessed whether or not the law applied and determined that it did not.
And Mr. Gideon, your time is up, so you'll have to wrap up your questioning.
I'm done right there. Thank you very much, Madam Hearing Examiner, Ms. Kelly.
Thank you, Mr. Elliott.
Thank you, Mr. Elliott. All right. Moving on. Hearing Examiner Schaefer, do you have any questions for Ms. Kelly?
Yes, I do. Just a few questions. Thank you, Hearing Examiner Barrett. Good afternoon, Ms. Kelly. Thank you so much for taking your time to be with us here today. I'm wondering, in your experience with utility law and corporate transactions, if you've ever been party to a transaction that involved a pipe or have awareness of how pipes work.
No, I've never been involved in a transaction involving a pipe. The only awareness that I have of them is from reading this case. The filings.
Sure, thank you. And you're familiar with the proposed structure of the transaction, the underlying proposed acquisition of PNM, is that correct?
I am generally familiar with it.
And based on your familiarity, what is the role of Troy Topco LP?
My understanding is that Troy Topco LP is the entity that entered into the financing transaction with TXNM.
For the purchases of the 8 million shares, is that correct?
That's my understanding, yes.
And based on your understanding, does Troy Topco LP have any role within the proposed acquisition of PNM?
It is in the chain of ownership, but I would have to refer to that diagram to make sure that I appropriately recall.
So based on your understanding, Troy Topco LP would be an upstream owner of PNM, is that correct?
Subject to check, that's my understanding.
And if I understand your testimony here today, you're trying to say that because Troy Topco LP did not purchase a controlling interest in TXNM, that the commission has no jurisdiction over approving that transaction. Is that correct?
Well, the purpose of my testimony here is to provide the context and the circumstances surrounding the amendment of section 62.612. I'm not here to testify to the statutory interpretation per se of that statute or to make legal arguments.
And what is your just for benefit of the commission and the public here, what is your understanding of that amendment? How does that function, and how do you see that changing the understanding of this transaction?
I'm afraid I don't understand your question.
I guess what I'm asking is if you can share with us in layman's terms what the amendments mean to you.
62.612 as amended provides the commission with authority to pre-approve mergers, acquisitions, consolidations, and other transactions resulting in control of a New Mexico jurisdictional utility.
That's all my questions, Ms. Kelly. Thank you so much again for taking your time.
Thank you, Mr. Hearing Examiner.
Thank you, Hearing Examiner Schaefer. I'm going to continue on Hearing Examiner Schaefer's line of questioning just briefly. you keep using the term resulting in control. Can you give me your definition of what resulting in control means to you?
Yes, it means control as set out in section 62.3.3 of the Public Utility Act. And in that section, subsection A, it's the legislature has spelled out what control means, and has said it includes instances when a person is an officer, director, partner, trustee, or person of similar status or function, and a person owns directly or indirectly or has a beneficial interest in 10% or more of the voting securities of a person, and person has a level of ownership of securities other than voting securities that the commission establishes as creating a presumption of control, and 4, the possession of the power to direct or cause the direction of the management and policies of a person that exists in fact, notwithstanding the lack of ownership of 10% or more of the person's voting securities. So in other words, you could own less than 10% combined with something else, like in the Raton natural gas case, a seat on the board or a high management position that would result in control.
I don't have any more questions for you, Ms. Kelly. Is there any redirect for Ms. Kelly?
No, ma'am, no redirect. Thank you.
Are there any questions directly tied to the questions that were asked by hearing examiner Schaefer or myself? Okay, Ms. Kelly, thank you very much for your time today.
Thank you, Madam Hearing Examiner.
Excused. And I believe that is the end of the joint applicants' witnesses. Next, is that correct, Mr. Heatherly?
Sorry, I apologize. I didn't mean to speak over you, Madam Hearing Examiner. I was just going to confirm you are correct. Your understanding is that is correct. We have no other witnesses. That is the close of our case.
All right, thank you, sir. So therefore, next on our list, 153. Why don't we have Mr. Binns take the stand and be sworn in, and then we'll take our brief afternoon break, maybe between questioning, between the cross-examinations of him from the different parties.
Raise your right hand, please.
Oh, I'm so sorry. I thought you were asking a question. I don't, oh, he's already there. My apologies. I'm so sorry.
Oh, he was there.
Madam.
I was just gonna swear him in.
Madam Hearing Examiner, do you want me to have his testimony admitted before we go to break?
No, so you'll present your witness and you'll do your direct examination of him, and then after you do your direct examination of him, you'll move for admission of his testimony and the attachments thereto into the record.
After the break. Got it.
No, we're not, we won't take a break in between. I was just saying the timing of bringing him to the stand is a bit too early to take our afternoon break, but I was assuring everyone we won't go all the way through him before we take a break. So they were unrelated. Apologies if that was confusing. So Prosperity Works, you've called your first witness, Mr. Binns?
I call Ronald J. Binns.
Okay, thank you. And Ms. Gonzalez, will you please swear Mr. Binns in?
Yes. Raise your right hand, sir. Oh, you did. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Mr. Binns.
Good afternoon, Mr. Michael.
Could you state your full name for the record?
It's Ronald initial J. Binns, B-I-N-Z.
Okay, and did you pre-file testimony in this proceeding on April 20th, 2026?
Yes, I did.
And is what's been marked as Exhibit PW or Prosperity Works 1 a true copy of that testimony?
Yes, it is.
Okay, and included with that testimony are 4 witness exhibits. RJB1, which is your curriculum vitae, RJB2, which are images of Senate Bill 157 at various stages of passage, RJB3, which is the joint application in this docket, filed on August 25th and consisting of 721 pages, and RJB4, which is Securities Exchange Commission Form 13D filed by Blackstone on May 18th related to the Topco stock purchase. Is that right?
That's correct.
Okay. And now in your testimony on page 29 at lines 19 and 20, consistent with an errata that was filed, the words, quote, between May of 2025 and the final commission order on the proposed merger, unquote, are stricken. Is that correct?
That's correct.
Okay. Do you have any other changes or corrections to make to this testimony?
I think there's one small nit on a cover page to an exhibit. You
Okay.
listed the date as August 2026, and that's not possible. I think it's 2025.
Okay, and that was in exhibit RJB3?
That's right.
Okay. And Madam Hearing Examiner, when I looked at the uploaded document, it looked like the label for RJB3 got cut off and the 3 did not appear. And so I just want to clarify that RJB3 is that exhibit, the joint application.
Let me take a quick look.
Okay.
It looks to me like it's properly labeled, but give me 1 second. Let me check it more thoroughly. Unless Hearing Examiner Schaefer, you've got it in front of you.
Yes, I believe it's correct, Madam
correct.
Hearing Examiner.
Okay, great.
Okay, thank you.
Thank you. Never mind then. Mr. Binns, with the changes and corrections we've just discussed, if I asked you the same questions today as are shown in Exhibit PW1, would your answers also be shown as shown in that exhibit?
Yes, same
Okay.
answers.
Okay. And are those answers true and correct to the best of your knowledge and belief?
Yes, they are.
Okay. I would move the admission of Prosperity Works Exhibit PW1 along with the 4 included witness exhibits, RJB 1, 2, 3, and 4.
Okay. And Mr. Binns, was the testimony and the exhibits prepared either by you or under your supervision?
Yes, they were.
Okay. With the changes that have been indicated and notwithstanding the standing objections that are already noted on the record, are there any further objections to the admission of this exhibit?
No objection.
Thank you. Hearing no objection, the exhibit is admitted.
Thank you. I'll pass the witness.
Thank you, sir. Because of the commission's prohibition on friendly cross-examination of Mr. Binns and Mr. Throne is limited to the joint applicants and will be split between counsel for TXNM and Troy Parent Co. It looks like TXNM has reserved 30 minutes with Mr. Binns.
Yes, I think actually, Your Honor, Mr. Haverly is going first on behalf of Blackstone Topco.
Either way is fine with me. Please proceed.
Madam Hearing Examiner, thank you for the ease of the court reporter, because I see that I now switched over to witness. My name is Brian Haverly, and I will be performing the cross on behalf of Troy Topco. Mr. Binns, good afternoon. How are you doing?
Good afternoon. Pretty good.
Excellent. Mr. Binns, you're a Colorado resident, is that correct?
That's right.
How long have you lived in the state of Colorado, sir?
Since 1973. So I think that's 53 years.
Excellent. Mr. Binns, you were the chairman of the Colorado Public Utilities Commission from 2007 to 2011. Did I get that correct?
That's right.
And have you served as a regulator in any other jurisdiction other than Colorado?
No.
Okay. When you were a commissioner in Colorado, I believe I saw your testimony that you said that you had to interpret statutes. Is that correct?
That's correct.
And those statutes were Colorado statutes. Is that correct?
I wouldn't want to say that exclusively. We had interest in federal legislation. We
I
had,
am walking down the hall. I went for a little walk.
Someone is not
Just
muted.
walking up to
Please
my room.
mute. Everyone who is not actively speaking right now needs to remain muted, please. And apologies for the interruption, Mr. Benz. Please proceed.
thank you. I would have had occasion to read and interpret federal rules, statutes, FCC and FERC. And I would have had, while commissioner, the occasion serving in my role with the National Association of Regulatory Utility Commissioners to look at other state statutes. So not exclusively Colorado.
On page 7, sir, would you please turn to your testimony? I believe it's marked Prosperity Works Exhibit 1. Let me know when you get there.
Well, you don't want to hear this, but it might take a while. For some reason, Adobe Acrobat has left me and I've not been able to open the testimony on the last 2 attempts. So I know it pretty well, and perhaps we can proceed. And if I can't, I will let you know.
We can try, Mr. Benz. I'm willing to be game with this. Okay. So
I think short of rebooting my computer, I'm not sure what else I can do.
Sure. Mr. Benz, I'm just going to read you what I have in front of me, and you tell me whether I read it correctly to the best of your recollection, sir. Is that okay?
That'd be great.
All right. On page 7, line 1, you testify, as a commissioner, I was often called upon to rule on the meaning of statutory language. While not an attorney, I was assisted by capable staff of attorneys and hearing examiners in making those determinations. Their first counsel was always to look at the plain language of the statute. Does that sound familiar like your testimony, sir?
Yes, sir.
Okay. When you reference this group of capable staff attorneys, those are Colorado attorneys. Is that correct?
Yes.
Licensed to practice in Colorado?
Yes.
And they had experience in Colorado law?
Yes.
And they were advising you generally on Colorado law when they provided you their counsel?
Well, I wouldn't say it that way. The principles of statutory interpretation apply lots of places across lots of jurisdictions. And as far as I know, there was nothing special to the implementation of those canons and principles in Colorado.
Did you ask them if there was anything special about them in Colorado?
I'm sure this was 19 years ago. I don't have specific recollections, but that's the kind of thing I would have asked. Yes.
And the hearing examiners that you reference in your testimony, those were also lawyers licensed in Colorado. Is that correct?
That's correct.
Given your prior statement just now, Mr. Benz, did you contact any of those prior staff attorneys and the hearing examiners that you referenced to confirm your recollection, since it was approximately 20 years ago, that their counsel that their counsel that you reflect in your testimony, that your reflection is correct and was complete?
No, I did not.
On page 12 of your testimony, I'm going to read something to you, Mr. Benz. I'm just going to reference for the record. This is page 12 of the Prosperity Works number 1. There is a question on line 4. question is, Ms. Kelly appeals to the history of the electric industry in the West and to the legislative history of the statute to form her opinion of what the purpose of 62.612 was and how to interpret the language. Do you agree with her approach? Question mark. Answer line 7. There are principles of statutory interpretation that have wide acceptance among regulators and probably the entire legal profession. For a concise and readable statement of those, I have and do rely on the Congressional Research Service of the Library of Congress in an article entitled Statutory Interpretation Theories, Tools, and Trends. And then you provide a URL link. Then you say, the first and foremost principle is, quote, first, judges often begin by looking at the ordinary meaning of the statutory text, asking how a word is understood in common parlance, end of quote. Does that sound familiar to you, sir?
Yes, it does.
Okay. Do you have access, Mr. Binns, to what I have marked as joint applicant exhibit number 15?
I'm checking. I could have just a moment.
Madam Hearing Examiner, would this be a good time to take a break so that Mr. Binns can maybe reboot his computer and see if he can access the exhibits and get those available so that I can ask him questions?
I think that's a reasonable idea. So why don't we take a 10-minute break right now? And we'll be back on the record around about 2:17. And Mr. Binns will check back in with you at that time to see if your technology is recovered somewhat. So
Thank you very
we're off the
much.
record until 2:17. Mr. Binns, were you able to try to adjust your technology?
You're on mute, Mr. Binns.
We're good to go.
All right.
Apologize for the delay.
All right, it certainly happens. Ms. Gonzalez, are you prepared to go back on the record?
Yes, ma'am.
All right, the time is 2:17. We're back on the record, and Mr. Haverly can continue his examination of Mr. Binns.
Thank you. Mr. Binns, were you able to locate what's been marked as joint applicants exhibit number 15?
I will have that shortly.
Just let me know when you get there.
I got to go to the Dropbox and get it. Tell me the exhibit number again, please.
That would be joint applicants exhibit number 15.
Mr. Haverly, I'm going to pause your time while he's looking.
Thank you, Madam Hearing Examiner.
I have it.
Proceed.
So, Mr. Binns, before we took our break, I had read a sentence to you in your testimony where you're quoting out of this document. Is this the document, or let me ask you this, is this the document that you referenced and that you quoted out of?
Yes, it is.
Okay. And would you go to the second page of this document? And there's a title page, and then there's a second page that the very top says statutory interpretation, theories, tools, and trends. Do you see that?
Yes.
And would you go to the third paragraph down that starts with first?
I have it.
Okay. Is that the sentence that you quote in your testimony, sir? That first judges often begin by looking into the ordinary meaning of the statutory text, asking how a word is understood in common parlance. Is that the same verbiage you cited in your testimony, sir?
I'm checking. Yes, it is.
Okay. The last sentence of that same paragraph states, nonetheless, judges may disagree about what a word's ordinary meaning is or whether a particular statutory term may instead be a term of art. That is a word with a specialized meaning in a particular context or field. It says that, correct?
That's correct.
And then the next paragraph, second, judges interpret specific provisions by looking to their broader statutory context, including the surrounding phrases and overall structure of the law. Is that correct?
Yes.
So that would also be one of the broadly accepted canons of statutory interpretation that regulatory bodies use, according to your testimony. Is that correct?
Yes.
Thank you, sir. Do you have your testimony up, Mr. Binns, now?
I do.
Okay, would you please go to page 14 of your testimony?
Okay, I've got it.
Line 19, do you see that?
Yes.
You pose a question. Does Ms. Kelly's position that PRC oversight be limited to situations involving a change in control provide a workable standard? And you answer on line 21, no, it is not a workable standard. Is that correct?
That's my testimony, yes.
Are you aware that there is a control standard that the PRC uses when determining a public utility holding company status?
Could you be more specific? I'm not sure what you're referring to.
When the PRC is called upon to determine if an entity is a public utility holding company, are you aware that it uses a control determination?
I'm not aware of that, no.
Are you aware that when the Public Utility Commission, the Public Regulation Commission in New Mexico is called upon to determine if there are affiliates that a utility is interacting with, there is also a control determination that is used?
Well, I know that 63.3 basically discusses those kinds of connections. And I assume the commission's rules and practice are consonant with that. If that's not what we're talking about in this section of the statute, the word control doesn't appear.
Mr. Benz, 62612B uses the word control, does it not?
Well, yes, it does.
Thank you, sir. Can you provide me with any reference to a commission proceeding or determination where the commission was unable or found a control determination to be unworkable?
Well, in your question, you're mischaracterizing my testimony. Her proposition was that change control would be the trigger that would require commission oversight of a transaction. And I'm answering that to say that that's not a workable standard at that point, because if the commission doesn't even know about it, it's impossible we'll be in the position we're in right now, where a major transaction occurred, commission wasn't apprised of it, was not asked for permission. So the question of if she overlays control as the trigger for C3, that won't work. It really renders the prior approval meaningless because it's going to be up to the applicant or the regulated entity to decide whether it needs to move forward on that.
My question was much simpler, Mr. Benz. I just asked you if you could reference any commission decision that indicated they had a hard time making a control determination.
And that's not my testimony is not that the commission would have a difficult time making a control decision. They do. So I'm not going to argue with that. The question is, what is the entry point of C3? And if it is to be that only in control situations, the question then becomes, well, who decides that and at what point? And if control is not otherwise, there's no bright line in this section of the statute, there could be a lot of debate about whether something adds up to control. I'm not saying the commission's incapable of deciding, as it apparently does in other situations, whether control is being exercised.
Please go to page 24 of your testimony, sir.
Would you repeat that? I'm sorry.
Yes, would you please go to page 24 of your testimony?
Okay. Okay.
Actually, I apologize. It's really what I want is the question starts on the bottom of page 23, Mr. Benz.
23, I've got it.
Yeah. So you ask, or somebody poses a question that says, as another alternative, Misters Terry and Sherman suggest an option agreement that gives Topco the right to purchase the 8,000 shares for $0.001 per share in lieu of Topco actually holding the stock. Is that the appropriate resolution of the situation? You answer on the next page, the top of the next page, line 1. No, it is a creative proposal, but it does not serve the purpose of the law or the regulatory framework in New Mexico. Mr. Sherman asserts that since 62612 addresses only stocks, this alternative arrangement involving only options would run afoul of statutory provisions. But this workaround is sophistry. Purchasing a permanent call option for $50.0001 per share is not materially different from purchasing a stock for $50 per share and will be seen as such. Did I quote your testimony correctly, sir?
You actually mispronounced.
What did I miss?
You said on line 3, it says would not run afoul of statutory provision. I think you said it. You left the not out, but otherwise. That's And Madam Hearing Examiner, just not really an objection. I believe, Mr. Haverly, you said 8,000 shares instead of 8 million shares.
8 million. I apologize. That was not intentional. I do apologize.
I understand.
That's fine. I think the testimony is clear, so please proceed.
Yeah. So, on page 10 of your testimony, let's go there.
I'm sorry, you had me read a section of testimony. Were you going to ask me questions about that?
I will in a moment, but if you'd please go to page 10, I
Sure.
appreciate it.
Okay. I'm there.
Oh, I'm sorry. I'm sorry. I missed the page. I flipped too many pages when I flipped the page. I need you to go page 8. I apologize for that, sir.
Okay, I'm there.
Okay, on line 5 of page 8, do you see that?
Yes.
You testify, I will testify that purchasing a permanent call option for $50.0001 per share is effectively the same thing as purchasing a stock share for $50 per share and should be seen as such and rejected. Is that your testimony, sir?
Yes, it is.
The 62612A3 use the word option, Mr. Benz?
No.
So you would agree with me as a plain meaning advocate that an option is not the same thing as stock, wouldn't you?
It's a contract to purchase stock at a certain price. Yes, that's what it is. And
Okay.
that's all it is.
So as a plain meaning advocate, you would agree that an option does not offend 62612A3. Is that correct?
I may be a plain language advocate in this circumstance, but I also have an allergy to sophistry, which is what I think this is. The $400 million is with the company. They're exchanging the shares they now allegedly hold for an option and concluding that that could not breach the meaning of those parts of the statute because it doesn't even involve stock. I think I'm not sure what to call it. Workaround is one thing, but I think it's wordplay.
So if something doesn't make sense, the commission should look beyond just the plain meaning, right, Mr. Benz?
If it's a statement like this one, yes, I do.
Thank you, Mr. Benz. Would you please go to page 7 of your testimony?
Okay, got it.
You say on line 17, even if the commission accepts her analysis, and I'll break here and say her analysis being Ms. Kelly's analysis, however, the combination of the pre-merger Topco and Zimmer stock purchases resulted in a controlling interest being conveyed to TXNM's board of directors with a similar prior approval requirement that was not met. Is that your testimony?
Yes.
So you're concerned that Topco and Zimmer worked in concert with TXNM to provide TXNM's board of directors control over the company. Is that a fair statement?
I'm saying that using Commissioner Kelly's analysis of the controlling interest, and she elsewhere says 10% qualifies as that those two stock transactions executed nearly simultaneously and each of which contains a provision that the shares purchased will be voted upon the advice of the board and the directions the board asks. So the board, not an election of the stockholders, but the board would have control of around 11% of the voting interests. And that's what I said, that is effectively the same as having obtained the stock.
Mr. Binns, you're not an expert in New Mexico corporate law, are you?
I'm not.
And you're not here to provide opinions on the powers that New Mexico law provides to the board of directors of a company versus the shareholders of a company, are you?
I don't have specific knowledge in New Mexico of that, no. I don't think I said anything that's wrong either, factually incorrect.
But you have no expertise in any of this area in New Mexico law, do you, Mr. Binns?
Except for having been involved in the utility industry for nearly 40 years, 13 as a consumer advocate, 4 as a commissioner, and 20 some odd as a consultant in 20 or 22 states. That's all I've got to offer.
Is it your testimony that gives you some insight into New Mexico corporate law, sir?
No, I didn't say that.
Just clarifying, sir. Thank you. Okay. Page 7 of your testimony, sir. That same lines that we we're talking about, there's a Zimmer stock purchase. You see that?
Yes.
And on page 10 of your testimony, let me know when you get there.
I'm there.
Okay. Line 7, you say, on the other hand, TXNM was able to obtain $200 million in financing from Zimmer Biomet after the merger was announced. Is that correct?
What line are you referring to?
I would start on line 7 and going on to 8, sir. On the other hand,
yes, I have it. Thank you.
Right. On the other hand, TXM was able to obtain $200 million in financing from Zimmer Biomet after the merger was announced. Is that correct?
That's what my testimony is, yes.
Okay. Let's go to page 28, please, sir.
Okay.
You have a chart at the top of that page.
Yes.
And on that chart, you also reference Zimmer Biomet. You see that, sir?
Yes, I do.
Are you aware, Mr. Binns, that Zimmer Biomet has nothing to do with the pipe transactions at issue in this case?
I understand that. Yes, that's not the purpose of this exhibit, but yes, I understand that.
If you understand that, why are you talking about Zimmer Biomet, sir?
In my testimony, this table in part supports my observation that public utility commissions are often on the short end of the stick when it comes to information in a case or about the players in a case. I put this in here to illustrate the links between the 5 players listed there and their various shareholders, including each other in times. So it had nothing to do with whether Zimmer Biomet was a party to the pipe or not. That's not the point of this. I accept that they were not. But Zimmer did provide $200 million in capital, and their existence is of interest to the commission, I believe, because of the interconnections of all of these companies, which is illustrated in the chart.
Sir, are you aware that Zimmer Partners LP is a different entity than Zimmer Biomet?
I'm not aware of that, no.
Are you aware that Zimmer Biomet is a publicly traded company specializing in medical device manufacturing and marketing, sir?
Yes.
You are aware of that?
I know that's one of their lines of business.
Okay, and you're aware that the $200 million transaction that you just referenced is with Zimmer Partners LP. Is that correct?
I'll take your word for that, yes.
It's in the proxy on page 22. If you'd like to check on that, we can do that.
No, I accept it.
Okay, so if you understand that Zimmer Biomet LP, I mean Zimmer Partners LP is the entity that is buying the stock from TXNM, why are you referencing the publicly traded entity Zimmer Biomet in your testimony?
Well, it's clearly an error and it should be ignored. If the implication of what you're saying is true, that these are different entities, and I've simply looked up the top 4 international investors in the wrong company, I accept that.
Okay, so then the rest of your statement on page 28, also notable is that until 2016, Blackstone owned a large share of Zimmer Biomet. You don't need to be a conspiracy theorist to imagine the possible self-dealing opportunities among these companies that could be contrary to the public interest. None of that is really applicable anymore because Blackstone has no interest in the Zimmer that purchased the shares from TXNM. Isn't that correct?
You're correct.
Thank you. I have no further.
Can I just clarify something for the record, please?
Absolutely.
A bit of a confusing back and forth. Am I understanding correctly, Mr. Binns, if a mistake has been made, is it that you looked up the wrong company or you included the wrong name in your testimony and you meant to say Zimmer Partners? I'm sorry, I can't remember their full name. Or is the information in your testimony accurately reflective of the status of Zimmer Biomet? Like, what was the mistake, if you can explain it to me clearly?
I did locate the publicly traded company, Zimmer Bionet, and that's what I quoted the numbers from. And anytime Zimmer appears in testimony, that's the company I'm referring to.
Okay, so it's not, okay. Thank you for clarifying.
Sure, thank you.
And to clarify, when you did that, you did that by accident because Zimmer Biomet does not have an ownership interest in that $200 million TXNM share issuance in 2025, correct?
I understand that, yes. I was using a resource, Morningstar, to ascertain the top shareholders in these companies, and I mistook Biomet for LLP partners.
Okay, so you just made a mistake between Zimmer Partners and Zimmer Biomet, sir. Is that correct?
That's right.
No further questions.
Thank you. And Mr. Heverly, you didn't use all of your time, so you have 15 minutes, give or take a few seconds left if you need to use it for Mr. Throne.
Thank you, Madam Hearing Examiner. I appreciate that.
No problem.
I pass to the next person.
All right. Attorney for TXNM is up next in the order of cross-examination.
Thank you, Your Honor. Ray Gifford on behalf of TXNM. Good afternoon, Mr. Binns.
Good afternoon, Mr. Gifford.
The mustache is as spectacular as ever, Mr. Binns.
And your impression of Colonel Sanders is pretty good too.
We're doing our best. Just a few questions, Mr. Binns. Mr. Binns, what is your understanding of the mission of Prosperity Works?
I know very little about the entity. I'm working on behalf of, I'm working for Mr. Michael, and his client is Prosperity Works. I understand that their broad mission is empowerment of people, and the focus is on low-income people.
So you would understand part of their mission to be advocating on behalf of low-income utility customers. Would that be a fair characterization?
Yes.
And in your experience as a consumer advocate, as a regulator, do you think low-income utility consumers benefit from utilities, all other things being equal, with a higher cost of capital or a lower cost of capital?
Lower cost of capital is to be desired, so yes.
And When, Mr. Binns, did the pipe become public?
I don't have the exact date. There was an announcement, I think, but I don't know it offhand. I'll take your date if subject to check.
If it's roughly late May of 2025, would you accept that?
Okay.
When, Mr. Binns, did Prosperity Works complain about the pipe?
I only know what's been filed in this docket.
Would it be approximately?
That would have been February of this year, I believe.
And how many months is that?
I'm sure you know.
I'm just asking you. It's not a short amount of time, is it, Mr. Binns?
It's 6 or 7 months, I suspect.
Thank you. Now you, in this case, are urging this commission that they construe the statute according to a plain language understanding of the law. Is that correct?
That's correct.
And if we're going to be reading section 62612A3C by the plain language, would you also agree you should read the other parts of that statute according to the plain language?
What's at issue, what has been put at issue in the petition by Prosperity Works is this paragraph C3. And that's, as far as I'm concerned, the only argument here. But as a general proposition, yes, I think common sense meaning, unless it fails, and if it fails, you go to other tools. But so I'm not going to argue with you about whether other sections should be read that way. It's just that they're not at issue as far as I'm concerned in this docket.
Understood. So, but you would agree with me that if you read subsection 3C according to the plain language, you should read subsections, for instance, 3A according to the language.
Yes.
And if subsection 3A says that if a entity classified as a public utility or public utility holding company needs to get pre-approval for stock, would you agree with that plain language reading of subsection 3A?
Yes.
And are you aware whether or not any public utility holding companies in any jurisdiction own stock in New Mexico utilities?
I think it's been established early in the proceeding that these large investment firms are registered as holding companies, yes.
So
and we just saw their percentage of ownership.
So in your understanding of the plain language understanding of subsection 3A, there are public utility holding companies owning stock in New Mexico utilities in violation of this statute?
I suppose that's to be determined. While the language is pretty clear, statutory construction also prescribes that you don't reach absurd results. And it seems to me that if this commission decides it's got jurisdiction under that first section over Fidelity and Vanguard, that seems to me a pretty straight ahead violation of what the another section of that same part of the statute is, that this amendment does not increase or decrease the authority of the commission. So the plain language gets you so far. And as you and your colleague lectured me earlier, you need to look at the context in some cases, and I agree with that. It's just that I don't think there's a controversy in 3A. Excuse me, A3. I keep saying that. A3. C3. Let's try it again. I don't think there's controversy about the provision in C3.
Yeah.
As to whether C1 should be enforced, interpreted in the exact same way, I'm not at all sure of that. I don't think the commission would be bound to.
So there are instances where the commission might depart from the plain language of the statute.
If following it would lead to absurd results, I think that's one indicator that you're on the wrong track.
And if the commission were to show cause all public utility holding companies owning stock in New Mexico utilities, do you believe that would be an absurd result?
Well, if you're are we under paragraph 1 now? Is that what you're using?
We're under, let me give you the full statutory site, Mr. Vin, 62-6-12A3A.
Okay.
So let me repeat my question. Would you recommend that this commission show cause or investigate stock ownership by public utility holding companies in New Mexico under the plain language of this statute?
Objection.
I don't think they have jurisdiction.
Objection, Mr. Benz.
Sorry.
I'm sorry, who is speaking right now?
I am.
Okay, and Mr. Michael, you're the one who just lodged the objection?
Yes.
Okay, what's the grounds of your objection?
I understand that there is some value in looking at different sections of this statute, but the issue of whether Vanguard or various other companies that own stock in PNM have violated 62-612 is not the issue in this proceeding, and this is going beyond the scope of this proceeding.
Mr. Gifford?
I asked Mr. Binns how he would interpret the statute consistent with his construction of Section 3C. Your Honor, maybe I can make this.
Wait,
Your Honor, I can make this
one at a time. Mr.
Your Honor,
Gifford, please.
let me make this very easy for all of us. I'll withdraw the question and move on.
Thank you, sir.
Let's go somewhere where we might be a little more comfortable together, Mr. Binns, and talk a little bit about Colorado law, if you would mind. Is that okay?
Sure.
So in your testimony, you talk about the Colorado statute that requires, and I'm going to construe it a little bit colloquially, but tell me if you agree with me, that requires pre-approval of debt issuance. You're familiar with that testimony?
Yes, I am.
And that statute has a similar statute in New Mexico that requires pre-approval of debt issuance. Is that right?
Yes.
Now, during your time,
securities generally.
Secure.
Yes. Would be one of them. Yes.
Fair enough. And I said I was going to use a colloquial term, and securities is the more precise term. I agree with you, sir. And you approved those debt issuances. Is that right?
Yes.
Did you ever approve debt issuances at the holding company level of Colorado Utilities or at the operating level company of Colorado Utilities?
I was working mostly from memory of my service in the commission. And what I recall is that the commission did not have jurisdiction over the issuance of stock by the holding company, but that the holding company posited the debt in the operating companies, at least in some cases. And so when the commission was asked to approve a debt issuance for, say, a public service company of Colorado, they were doing it for the operating company and not necessarily for Xcel Energy located in Minnesota.
So your recollection of Colorado's jurisdiction was your jurisdiction was over the securities issuance at the operating company level, not the holding company level?
That's my belief, yes.
Let me ask you a question some questions about your time as chairman of the commission. When you were chairman of the commission, Mr. Binns, did you always construe statutes according to their plain language meaning?
I thought I said pretty clearly that's where you start. And if there's ambiguity or uncertainty about that interpretation of plain language, you move on to other considerations. So I'm confident that my counsel at the commission and myself and my lawyer colleagues on the bench would have started with plain language. And if that were insufficient, move on to the other considerations that were listed in that Congressional Research Service article.
And in fact, you may or may not recall this. Do you remember signing on to an order mentioning that Colorado courts have departed from the plain meaning of the statute to promote the spirit over the letter of the law, when doing so carries out the intent of the General Assembly?
What is your representation about that document?
Would you remember signing on to an order of the Colorado Commission that cited that?
Not specifically. You could give me more context. You might awaken my memory, but I don't have one right now.
Well, I probably don't want to remind you of all your greatest hits. This one, Mr. Binns, is in the matter of the application of Mill Creek water sales and distribution. Do you remember at another point of your career signing on to an order that said you would construe laws to, quote, effectuate the General Assembly's intent and the beneficial purpose of the legislative measure?
I don't argue with that.
So I think
again, I don't know where you got it, but as a matter of principle, I think that's correct.
Thank you, Mr. Binns. No further questions. Great to see you again.
It's been a pleasure. I'm also under oath.
Thank you, gentlemen. I don't believe that there is anyone else who's eligible for cross-examination of Mr. Binns. So I will pass to hearing examiner Schaefer to see if he has any questions for Mr. Binns.
Mr. Binns, thank you for taking your time. I have no questions. Thank you. Hearing examiner.
Thank you, hearing examiner Schaefer.
And Mr. Binns, I actually don't have any follow-on questions for you either. Mr. Michael, do you have any redirect for your witness?
Thank you. Just a couple of questions, Examiner Barrett. Mr. Binns, you were asked about issues about control and some reference to the board of directors having potentially gained a controlling interest in TXNM. Could you do you have statutes available to you, New Mexico statutes, 6233?
I can pull it up very quickly, I'm sure. What's the section number?
Well, perhaps I can just ask you to accept something subject to check.
That's easy, yes.
Would you accept that the definition of control within that statute, 6233, is triggered off the either actual or beneficial ownership of voting securities?
Yes, that's how it reads. I think I read it last night.
So control does vest in the shares or the ability to vote those shares under this particular New Mexico statute?
Yes.
Okay. And you were asked about by Mr. Haverly about Zimmer Biomet. Are you aware of all the different Zimmer companies that are in the marketplace right now and their relationships to each other?
I won't lie to you, I don't.
Okay. Do you know whether Zimmer Biomet actually is the parent company of Zimmer Holdings, which is the parent company of many other Zimmer companies?
I am unaware of the corporate structure.
Okay, so, and in the stock, do you have the stock purchase agreement? The Zimmer stock purchase agreement handy? I believe it's attached to Mr. Terry's testimony.
You hold just a second, please.
Sure.
Too many documents open.
Well, maybe I can just shorten this. Would you accept that Zimmer Partners includes a number of other companies with the name Zimmer in them? And that they were all part of this stock purchase agreement?
I'd accept that,
Okay,
subject to check.
that's all the questions I have. Thank you, Mr. Benz.
Right. Okay, do either attorney have any limited additional questions just on Mr. Michael's redirect, since we did not have follow-up questions as the hearing examiners?
One question.
Mr. Haverly, was that you? Because it. Okay.
Yeah, I think there was an accidental unmuting that occurred, Madam Hearing Examiner, and I think there was a weird echo that occurred at that point, so I apologize. I have one question.
Please proceed.
Mr. Benz, you have no evidence sitting here today that you can show to the commission that Zimmer Bionet has any affiliation with Zimmer Partners LP that you can point to. Isn't that correct?
That's correct.
Thank you, sir. No questions.
All right. Thank you very much, Mr. Benz. Thank you for your testimony.
Thank you, Examiner Barrett.
You are excused, sir.
Thank you.
Let's take a quick 5-minute break, actually, while we change witnesses. I believe the last fact witness of the day is Mr. Throne, if I'm correct. But let's go off the record for just 5 minutes to allow that change to happen. So we'll be back. Let's just come back at 3:05. 3:05. I think we may be waiting for Ms. Nanasi. And having a hard time locating her witness on the screen. Just a moment.
Yeah.
Right. Ms. Gonzalez, are you ready to go back on the record?
Yes, ma'am.
Okay. Thank you. We're back on the record. The time is 3:06. Moving on, new energy economy. Will you please present your witness?
Thank you, Madam Hearing Examiner. New Energy Economy and Center for Biological Diversity called Mr. Bruce Throne to the stand.
Thank you. Ms. Gonzalez, will you please swear in Mr. Throne?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Mr. Throne, did you write and prepare the testimony that has been submitted as New Energy Economy, Center for Biological Diversity, Exhibit 1, the final redacted response testimony and exhibits of Bruce Throne?
Yes.
And sir, is it true that you have not only a redacted version pursuant to the protective order, you signed a protective order, correct? A confidentiality agreement in this case?
Yes.
And so not only do you have a final redacted response testimony and exhibits, but you also have a confidential final response testimony and exhibits. Is that also correct?
Yes.
And the final confidential testimony and exhibits is not part of the public record. Is that right?
That's my understanding, pursuant to the protective order.
But it is made part of a record separate from the public record, correct?
Yes, I understand how that operates at the commission.
And sir, this morning there was a ruling that that said that one of your exhibits, Exhibit 3, which is the deposition testimony of Don Terry, other than that, which it will be removed pursuant to the hearing examiner's order and refiled, other than that, is your testimony true and accurate to the best of your ability and knowledge?
Yes.
Do you have any errata that you would like to inform this commission about regarding your testimony?
Yes. Mostly typos, and there's one grammar. I wouldn't want my sixth grade grammar teacher to get me on this. So I have a few.
I don't mean to interrupt you, but any non-substantive changes don't need to be made here. Only changes that change the nature of your testimony. You please proceed, but I just want to make sure you understand.
I understand. Yes, I do. The first one would be on page 29, line 13. Before the word clippings, the year is wrong. It should strike 1999. That should read 1989. That was just a typo, but it is significant because it's relevant to the legislative history that's addressed there. The second one would be on page 31, line 5. It's the same type of change. Before the word clippings, again, strike 1999 and insert 1989 in lieu thereof. The third, and I think that to avoid any confusion, there's on page 32, line 16, there should be a delete the comma after SK-2. Otherwise, it might confuse people what that means.
On page 47, line 2, delete the comma after the word application and insert closing of the parentheses in lieu thereof before the word describes, to make sure that's an accurate quote. On page 59, line 16, after merger agreement, change are to is. On page 70, line 17, please insert a closing quotation mark after option agreement. And lastly, on page 72, line 18, strike the word particular and insert, instead of that, particularly. That's just a typo. And that's all I have.
With those changes and the deletion of Exhibit 3, the testimony, the deposition testimony of Mr. Don Terry, is your redacted testimony and exhibits true and accurate to the best of your knowledge?
Yes.
And if you were asked those questions, would you give those answers today?
Yes.
With that, Madam Hearing Examiner, I proffer the witness.
You
For
want to move for
cross-examination.
admission? You want to move for his testimony?
Yes, please. I would like to move the admission of New Energy Economy Center for Biological Diversity, Exhibit 1, the redacted response testimony and exhibits of Mr. Bruce Throne.
Okay. And will you, the testimony that's being submitted to the record right now will also reflect the changes that he indicated here today, along with the removal of the exhibit that we discussed earlier?
If that's how you want me to do it, I will do that.
Yes, ma'am.
Thank you. That will be done by close of business tomorrow, as you've instructed.
No problem. Aside from the standing objection that's already been noted, is there any objection to the admission of Exhibit 1? Hearing no objection, the exhibit is admitted.
Ms. Danasi, just before we proceed, are you also moving to admit the unredacted testimony?
Yes, I am, Hearing Examiner Schaefer. Thank you so much for raising that.
Okay, so just for organizing our record here, Ms. Gonsalves, let's title that NEE CBD Exhibit 1A, unredacted response testimony, et cetera, Bruce Throne.
And just so I'm clear, I will make those errata changes and remove the deposition in the confidential version as well, correct?
That's correct.
Thank you. That will be labeled 1A.
And just for clarity of the record, aside from the standing objection that has been noted, is there any objection to the admission of Exhibit 1A as a confidential version of Exhibit 1? Hearing no objection, that exhibit is also admitted.
Thank you so much. I tender the witness.
Okay. And are we going to go in the same order as we did last time? Troy Parent Company first? Okay, Ms. Rotman, you may proceed. You are still on mute, though, ma'am.
I'm going to try again. I'm going to try again. Okay, now? Okay, I apologize. Thank you. Worst part of this for me is the technology. Appreciate your patience. Anna Rotman, again, on behalf of Troy Parent Co. Mr. Throne, good afternoon.
Good afternoon.
You're a lawyer, correct?
I practiced law here for New Mexico for 45 years, but I've been on inactive status as indicated in my testimony and my resume since January of 2022.
And in those more than 40 years of practice as a lawyer, you've appeared before this commission many times as counsel, correct?
Yes, I've appeared as counsel and also, as indicated in my testimony and my resume, I've also been hired by the commission to assist the commission on a number of things.
You've never appeared before the commission as an expert, correct?
Not before this commission, correct.
And in your more than 40-year legal career, you have appeared in court proceedings against adverse to PNM many times, correct?
In court proceedings, many times. There've been, I know one, and specifically, I was in the Summit Properties case that's mentioned in my biography. I'm not sure. Many times I've been on appeals. In some cases, there are some cases that have gone up on appeal where I wasn't opposed, and there have also been cases where I've actually assisted PNM. But I have, the litigation. Trying to think of other than Summit Properties. That one went all the way up to the Supreme Court. But the other cases, when I was representing clients in front of the commission, there are occasions when my client, on behalf of a client, I opposed what PNM was doing, and then there were times when other people took positions and we didn't. We didn't oppose.
To be clear, in your entire career, you've never been engaged by PNM, right?
Not directly, although I did assist them when Facebook hired me to help develop PNM's first green energy tariff to allow the Los Lunas data center to allow New Mexico to win the competition and to get that approved. In that case, I was hired by them, and I worked with PNM on that. And also, when I was hired by them again by Facebook, subsequently worked with PNM and assisted them in the case involving the BB2 line extension that came before the commission.
Mr. Throne, my question again. You've never been engaged as an attorney by PNM, correct?
Yeah, they've never hired me, no.
Thank you. You've never served as a commissioner in New Mexico, correct?
Correct.
And you've never served as a commissioner anywhere, correct?
Correct.
And you, sir, didn't participate at all in the legislative hearings that related to the proposed Senate Bill 157, which amended 62-612 in 1989, correct?
Not that I can recall.
And you, sir, have no personal knowledge regarding the reasons that Blackstone or TXNM entered the financing transaction, correct?
Oh, I know what I've read, and that's what I addressed in my testimony.
Right, just what you read, no personal knowledge, right?
Yeah, I wasn't personally involved in any of those transactions, if that's your question.
Yeah, that's my question. Thank you for confirming. And prior to submitting your expert testimony, you did not review the entire application that's pending before the commission, correct?
I read quite a bit of it. My focus for that was the scope of the show cause hearing. So as I went through it, I was more focused on matters that addressed the pipe or what's been called the financing transaction that's at issue in this proceeding.
And you didn't read the entire thing in doing that, right?
No, I mean, I know enough. I've been in enough cases and know enough about PNM that, for instance, I knew I didn't have to read Mr. Monroy's testimony because that wasn't at issue, and I'm not addressing the merits, as I pointed out in my testimony.
You also didn't review all of Don Terry's February 12th, 2026 sworn deposition testimony, correct?
Well, I didn't review all of it when I prepared my testimony, but I did after I did. I read the whole thing just because I wanted to see if there was anything else in there in preparation for today's hearing. And so I
Thank you.
did.
My question was limited to if you had read it in preparing your testimony. And you have, correct?
I read the portions of it that I address in my testimony, and it's cited that way.
Thank you. One of the cases where you that you list in your report, where you appeared before the commission, was as counsel for the petitioner SWG, addressing a joint petition by SWG, and by the case number, it appears it started in 2014. Do you recall that representation?
Yeah, I mean, there are a lot of cases, so I'm happy to look at which one you're referring to.
Sure, we can just take a look in your testimony. I'm on page 7, line 8.
Okay, let me just get there. I'm using page 7, line 8. Right.
And just confirming that this is the representation of SWG that you were engaged on.
Yes, Southwest Generation, correct.
And do you recall, Mr. Throne, that in that matter, PNM filed a sanctions motion against your client, SWG, because PNM alleged your ex parte communications with a commissioner were improper?
Objection.
Basis.
Relevance.
This gets to his bias and qualifications. Yes, this gets to his qualifications to be an expert before the commission here.
How does it relate to his qualifications to be an expert?
Because as you'll see, as we go through this, you will see that he was found to have engaged in ex parte communications and admonished by the commission for that, for undermining the integrity of the commission, which he now appears before as a purported expert.
I'm going to overrule the objection and allow this to proceed.
Thank you.
Yeah, I'm familiar with that.
Great. So actually, why don't we just take a look at the order itself that I'm referring to? It's Joint Exhibit 8.
I have it.
Thank you. Appreciate it. And so I'll just, if you can go with me on Joint Exhibit 8 to page 3, it's paragraph 18.
Yep, I'm there.
Thank you. And so in this discussion in the order, according to the Commission's September 26, 2018 order on motions for sanctions, the email you sent to the commissioner, the ex parte email you sent to the commissioner, discussed the testimony of PNM witness Patrick J. O'Connell at an evidentiary hearing in that matter where you had cross-examined him. Is that correct?
Yes.
And if you would turn with me to page 27, paragraph 27 at page 4 of the opinion by the commission.
Yes.
The commission found your behavior should not be condoned by the commission. And your behavior that it's referring to was that at that time you communicated with the commissioners using blind copies and concerning a topic where the matters discussed are closely intertwined and relate to an ongoing adjudication. Is that correct?
Well, yes. I mean, you got to read the whole order. You're cherry picking certain parts of it, but if you read the whole order, you will see that what I was addressing there, that was an integrated resource planning case. And in that case, information came out regarding unrecovered cost of various San Juan assets. At the same time that was going on, there was proposed legislation. There was a bill had been SB 47 had been proposed in the last session, and it failed. And then there were ongoing discussions, including some commissioners, one of the commissioners involved here, about the next session about whether or not there would be stranded cost recovery. And so I did email two of the commissioners, who were the only two commissioners that were going to, whose terms weren't going to end at the end of that year. And I addressed in that information the legislation. And if you read the whole order, including, for instance, paragraph 25, you will see that the commission found that it was not my purpose to somehow influence the outcome of that proceeding, that integrated resource plan proceeding.
Mr. Throne, let's look at
but
what the
nevertheless,
commissioners actually
excuse
Ms.
me,
Rotman, Ms.
can I
Rotman,
finish my
please,
answer?
please don't speak over the witness. And I need you both to slow down slightly and take Ms. Gonzalez into account when you're going
Yes,
back and forth. And since
course.
you're already interrupted, I've seen 2 more emojis float across the screen. I suspect it's happening on accident, but I need you to please be conscientious of it. And if I see it again, I'm going to speak to the person who does it directly. Understood?
May I finish my answer, Ms.
Yes,
Madam Mayor?
please finish and then you may
Okay.
proceed.
So if you read paragraph 25 and 26 of that order, and if you also read, there's another paragraph of that order, paragraph 14, you will see that the commission found that even though it wasn't my purpose in sending that communication to somehow influence the outcome of that proceeding, to the commissioners, treated it as an ex parte communication. And, I didn't have control of that, but I accept that. And so they found that and they admonished me. And I certainly respected the right of the commission to protect against ex parte communication. So I have no problem with that, but I think you need to read the whole order to understand what happened in that situation.
Well, Mr. Throne, I have read the whole order. I'm going to direct the attention of the hearing examiners to the order section of that decision, which is on page 5B. And I would invite you to read into the record only the first 2 sentences of the order of the commission. Would you do that, please?
You're on page 5?
Correct. B, this is what the commission ordered.
You want me to read the whole thing?
No, the first 2 sentences, if you would.
It says Attorney Bruce Throne is admonished to avoid undisclosed communications with individual commissioners on legislative matters where such matters closely relate to a pending adjudication. Period. Mr. Throne is further admonished that his commentary on the good faith of opposing parties in a pending adjudication does constitute an ex parte communication which undermines the integrity of this commission.
Thank you. At this time, I'd like to seek admission of Joint Applicants Exhibit 8.
Any objection aside from the standing objection that has been noted to the admission of Exhibit 8?
Yes, New Energy Economy and Center for Biological Diversity oppose admission of this exhibit as irrelevant to the testimony of Mr. Throne in this matter.
I'm going to overrule that objection and allow its entry into the record as it goes to the credibility of the witness. So the exhibit is admitted.
Thank you. Mr. Throne, when were you retained by NEE as an expert in this show cause proceeding?
I first spoke to Ms. Manassi the evening of the March 30th, and she asked me, would I be willing to consider being a witness regarding a show cause motion that had been filed by Prosperity Works. I said, I was retired. I was kind of reluctant to do so, but I would take a look. And she sent me the next day. I said, can you send me what it is that you want me to look at? And she sent me on March 31st a copy of the Prosperity Works motion and the other pleadings and the orders that were filed, show cause orders by the issued by the hearing examiners. And after I looked through that and saw what the issues were, including the responses that have been filed by the joint applicants, I I agreed on the 31st to go ahead and if she would, send me any further documents that I needed to review, that's when I was retained.
Thank you. So a few weeks then before you were retained, you wrote an op-ed that was published in the Santa Fe New Mexican on March 7th, 2026, entitled, "There's a Reason to be Alarmed About Blackstone." Do you recall that?
Well, you're not correct about when I wrote it, but if you're talking about when it was published, yeah, I wrote it after you identified the exhibit, said you wanted to ask me about it. I wrote it on February 7th during the legislative session because that was my desire was to address it after I had come into some information about what had happened with Project Jupiter and some legislation that's addressed in that article.
Right. Okay. So March 7th is when it was published. And let's go ahead and take a look at it. It's Joint Exhibit 5, Joint Applicant Exhibit 5. Now, I will say, sir, that the formatting is very difficult. It's very small.
That's okay. I have my copy. I can read it. I know what's in it. Mm-hmm.
Okay. Thank you so much. Mm-hmm. So, in this op-ed that you published in the Santa Fe New Mexican, you raised concerns about the acquisition that's pending before the commission now, correct?
Well, that's not the main focus. I said there are legitimate concerns, but the main focus, if you read the article, is the fact that, and this goes back to information that was provided to me as a private citizen back in October of 2025, is I was very alarmed when I heard about Project Jupiter coming in, and it's going to be, all these going to be fully gas-fired, and the emissions that were going to result from it. I couldn't understand how it even was going to happen because I had been involved in the legislative session when the Energy Transition Act was passed, which was the governor's signature legislation on climate in New Mexico. And so I actually last fall inquired with the AG's office. I guess they call it the New Mexico Department of Justice. I actually went over there and met with them, and that's when I found out about this legislation that's addressed in the article, which was SB 170 and also the HB 93, I believe it is, which these two pieces of legislation, that's what I address in this article.
Right. And it's interesting because the article, exactly as you point out, it actually talks about a project called Project Jupiter, but Blackstone's not involved in that project, is it?
I don't know exactly who's involved in it because one of the things that's been a problem is that it's, there's all these LLCs and I keep reading about who the investors are. So I don't know about that. My concern, I think you're maybe conflating some things here in the article and kind of adding 1 and 1 and getting 3. My concern about private equity in general and the Blackstone was SB 170, which when I checked and I found out that bill, which I guess PNM has described in a filing with the commission last December, is described as the Build It and They Will Come legislation, which was described as allowing utilities to, in effect, before current customers need new plant to serve existing customers, they can actually, to attract new customers, including data centers, they can actually get pre-approved by the commission for capacity additions with no guardrails. And that was my concern. In fact, it's been my concern since even before the Energy Transition Act got passed is guardrails for customers when the utilities start to invest in data centers, which have huge power demands.
And Ms. Rotman, before you proceed, you had reserved 20 minutes for Mr. Throne, and your time is going to be up in just about a minute. So
thank you so much. And with that, actually, Mr. Throne, I would ask you respectfully to just answer my final 2 questions. The first one is just to confirm In this article, you started it by writing, New Mexicans have good reason to be alarmed about Blackstone's request for Public Regulation Commission approval to purchase the Public Service Company of New Mexico. There you're referring to the acquisition at issue here, correct?
We didn't read the rest of the sentence.
Sir, I just asked you if you're referring to the acquisition here.
Yeah. Yeah,
Are
it
you?
says, and the
Thank
current
you.
data center gold rush. That was the connection I was making with the whole SB 170.
Mr.
So,
Throne, you
yes.
are opposed to the acquisition pending before the commission, correct?
No. First of all, my testimony doesn't address the merits. Number two, I haven't studied the merits of this. I had a concern. I didn't write the title of this, by the way, but I said there's a good reason to be concerned. Now, does that mean at the end of the day that the commission says no? And by the way, this was all before I was asked to even look at this stock purchase agreement, this financing transaction, and the whole issue of whether or not there was compliance with 62.612. So I didn't even know anything about that before this. So you're absolutely wrong to say that I had made up my mind about this before. I said there was reason for concern, and that's what I addressed in the article.
Do you support the acquisition?
I don't, my testimony, you're asking me about outside the scope of my testimony. You want me to talk about my personal reaction? I don't think that's within the scope, if I understand it, of the hearing examiner's show cause order.
Thank you. I have no further questions.
Thank you, Ms. Rockman. Ms. Terwilliger, it looks like you've reserved 15 minutes with Mr. Throne.
Yes, hearing examiner. And since my title says witness, the benefit of the court reporter, I'm Debria Terwilliger on behalf of TXNM. Good afternoon, Mr. Throne.
Good afternoon.
Mr. Throne, have you prepared a proxy statement for a publicly traded company?
No.
What standards, I'm sorry, let me start the question again. Do you know what standards apply to the preparation of a proxy statement?
No, I just assume that the proxy statement is supposed to contain information that's material to whatever the subject matter is that's being addressed.
Can you cite sections of the Security Act or the Securities Act or rules that apply to preparing a proxy statement?
No.
No further questions.
Thank you, Ms. Terwilliger. Hearing examiner Schaefer, do you have any questions for Mr. Throne?
I do not. Thank you for your time, Mr. Throne.
And Mr. Throne, I also have no follow-on questions for you. Ms. Nanasi, do you have any redirect for your witness?
No, thank you.
No redirect. Wonderful. Okay, Mr. Throne, I believe that concludes your cross-examination, and you may be excused. Thank you for your time today.
Thank you.
And correct me if I'm wrong, hearing examiner Schaefer, but I believe that concludes the evidentiary portion of today's hearing.
That's correct.
So I'll give a brief explanation of how phase 2 of today's proceedings are going to proceed. We are going to take about an hour and host a Supreme Court style oral argument. As previously stated, the participation is limited to Prosperity Works and the joint applicants, as the motion of Prosperity Works is what prompted this investigation, and the joint applicants were the respondent. Each side will be given half an hour. Joint applicants, as the party that has the burden, is allowed to go first. And they may use all of their time for, can't remember what it's called, but direct, or they may reserve some time for rebuttal. Prosperity Works has half an hour, and they have no right to rebuttal. We discussed this earlier, and my understanding is the joint applicants would like two of their attorneys to participate, and that's fine. And I extended that same privilege to Prosperity Works if they would like to have more than one attorney. But I would just ask that there's not a lot of back and forth. It's just split. And also, as we previously clarified, before we went on the record, the attorney who is speaking is the one who needs to answer the questions. We can't refer to the attorney that's, well, we're not seated or standing, but you know what I mean, if we were in a courtroom. It has to be the attorney who's on their feet who answers the questions. Hearing examiner Schaefer and I will be asking questions. In addition, Ms. Lecoq, who is a member of our Office of General Counsel, will be asking questions, as this is a legal question, this is a legal proceeding, and therefore it's appropriate for her to participate since we're not asking fact questions of fact witnesses. If the parties would like, because we're just slightly ahead of schedule, we'll go ahead and take another 5-minute break just to get some water and prepare for the next segment. Why don't we plan to come back at around 3:47? Before we recess, are there any questions? Ms. Rotman, you're still muted.
Yes, we just unmuted me, I hope. The only question I have is, I have a demonstrative to assist in the argument potentially, and so I'd like to know if there's the capacity to share my screen during the closing.
We do have the capacity. Let me discuss with hearing examiner Schaefer and Ms. Lecoq if we're going to allow that during the oral argument, and I'll let you know. But we do have the capacity to do so if we decide that it's permissible.
Thank you.
Maybe I'll just ask in anticipation, Ms. Rotman, the nature of the demonstrative. Is it an org chart or a financial structure or something like that?
No, it's actually the language of the statute, and it is the language of the statute, and not to preview the argument, but somewhat rearranged, right?
Okay.
And then so the language of the statute with different parts that are being focused on. I think that would be the way to describe it. I don't consider it an advocacy piece. It's just to make sure we're all on the same page, since we've had a lot of A31s and that sort of thing.
Sure. Thank you.
Oh, sorry, hearing examiner. Mr. Michael, did you have a question?
Yeah, it can be off the record, though. I just wanted to say something procedurally that's unrelated.
Okay, why don't we, since we're going to do that, why don't we go off the record and we'll have our break go until 3:48, and when we're off the record, Mr. Michael, you can ask your question.
Okay, when we come back or right now?
No, you can ask right now, but Ms. Gonzalez, why don't we go off the
It
record?
wasn't a question. I think some of those emojis may have come from my computer, and I have no idea how that happened. And it wasn't, the emoji doesn't reflect anything that I was intending to say or wanted to say. So I'm sorry, I'm trying to keep my hands away from my computer, but I understand how inappropriate that is.
That's fine. I had a strong suspicion that that's what was happening. Thank you for letting us know. Why don't we go ahead? It's 3:44 now. Let's come back at 3:50 and we'll get started with this segment.
Thank you.
all. Right, Ms. Gonzalez, just let me know when you're ready to go back on the record.
All right.
Thank you, ma'am. Welcome back, everyone. We're back on the record. We've concluded the evidentiary portion of the day, and we are now going to take about an hour to explore the legal questions at issue. The joint applicants will speak first. And who is going to be speaking on behalf of joint applicants first?
Ms. Barrett, I'm speaking first on behalf of them, and Mr. Gifford is also here. We've divided the topics. And I can explain sort of what our division is, if it would be helpful. I intend to address the statute, the statutory arguments, and then any questions about the potential paths forward that we've proposed. And Mr. Gifford would address the factual conclusions from the testimony you heard today from Mr. Terry and Mr. Sherman, and how that fits into the Public Utility Act and what it seeks to accomplish.
Okay, and to be clear, you're going to have, for lack of better terminology, a chunk of time, and then Mr. Gifford will have a chunk. There's not going to be a back and forth.
Correct, exactly.
Okay.
So I'll go through my topics first, but of course, our purpose is to be helpful to you. So if you're sort of done with what I have to say, we're happy to move on, or vice versa. The other thing is I would like to reserve 5 minutes for rebuttal, if that's possible.
Perfect. That's going to be my next question. Okay, so 5 minutes will be reserved for rebuttal. I'm going to just go ahead and start a timer for 25 minutes, and then whenever it's time for you to switch with Mr. Gifford, just let me know and I'll pause it while you swap.
Thank you.
Madam Hearing Examiner, was that
Yes,
5 minutes for each of the presenters, or 5 minutes in total for the joint applicants?
5 minutes total.
Okay.
Thank you for the clarification. All right.
And as to my question, may I use the demonstrative?
So if I understand correctly, excuse me, it's just the language of the statute rearranged. There's no extra annotations.
So I admit that I have one that has the language of the statute with some additional language on it. The other is just a rearrangement. Shall I just use rearrangement?
Yes, please.
Okay.
And did you want to put that up now, or is that some point in your argument that you would like to start sharing your screen?
Why don't I why don't I just do it now, so that we can deal with any catastrophes at this point? Not that we expect them.
That's a good idea. And I am going to pull Hearing Examiner Schaefer in. Are you familiar? Oh, you've already started sharing your screen. Okay. Oh, perfect.
That's not what do you see my PowerPoint?
The screen is now showing what looks like a PowerPoint and a white page with highlighting on a section of the statute.
Correct. That's right. And let me see if I can do. Okay, there you go.
All right, shall I start your time?
Yes, please.
Okay, please proceed.
Thank you so much, Madam Hearing Examiner, Mr. Hearing Examiner. Thank you for the opportunity to appear before you. I'm going to start with statutory interpretation, and I would like to address 2 points. First, the specific language of the statute that we've been talking about, 62-612. And second, the word stock as it's used in that statute. So I've prepared this demonstrative to aid our discussion. Perhaps the place to start is just the original text of 62-612A, C3. And so if we're just looking at that, you have the prefatory language in A that sets forth the prior authorization requirement. We then have subpart 3 that identifies the regulated transaction, which is the acquisition of stock in a public utility. And then subpart 3C identifies who is regulated, a person associated, affiliated, or acting in concert, etc., and the qualifying condition for the regulation to apply, which is for the purposes of any acquisition subject to the provisions of this section. So just bear with me, because here in what you're seeing, I've reassembled those 3 components into a single sentence using only the statute's words in their original form without changing anything, but I've done it so that everyone can be on the same page. If you just read this provision without it being all separated, what does it say? And what it says is, for the purposes of any acquisition, subject to the provisions of this section, with the prior express authorization of the commission, but not otherwise, stock of a public utility or public utility holding company may be acquired by any person associated, etc. So for the purposes of any acquisition is the threshold question as to when you apply the statute, with the express authorization of the commission is getting to the regulatory requirement. Stock of a public utility or public utility holding company may be acquired by, that's the transaction that's what's regulated. And then we have the regulated person, any person associated, affiliated, or acting in concert. So I just want you to see it that way, because I think it's important to realize that when you see it this way, the threshold question to the applicability of 12A3C is the financing transaction and acquisition subject to the provisions of this section? Because the language says, for the purposes of any acquisition subject to provisions of this section, then you need to get prior express authorization. I actually think this is what Mr. Binns called the entry point into the statute. And if that's the threshold question, is the financing transaction and acquisition subject to provisions of this section? The answer to that question is no. The financing transaction closed, the funds and the shares changed hands, TXNM used the proceeds to pay off debt and send capital to its operating subsidiaries, but at that time, no acquisition of TXNM occurred, and Blackstone did not take control of TXNM. As you heard in the testimony today, Blackstone gained no voting control, no board representation, no right to appoint anyone to TXNM's board, no ability to direct TXNM's policy or management at the time that the financing transaction was entered into.
Counsel, I'm sorry. Are you saying that your definition of acquisition in this statute is the financing transaction? That's what you're saying is the acquisition?
No, I apologize. I'm saying that the threshold question as to whether the statute applies to the financing transaction is whether the financing transaction is an acquisition subject to the provisions of this section.
So you are equating the financing transaction to the word acquisition here?
No, it's just to be clear, the point is that the financing transaction is not an acquisition that's subject to the provisions of this section. We only apply the prior authorization requirement if the financing transaction falls within this language, this entry point into the regulation, which means we have to be in an acquisition that's subject to the provisions of this section.
And what would that be, counsel?
Well, it would actually be what's before the commission in the merger agreement. That is a transaction that is subject to the provisions of this section. And we know that because coming out of that transaction, Blackstone will take control over TXNM. I mean, acquisition isn't defined in the statute, but the statute, as you know, is entitled acquisition, consolidation, etc. And it's talking about these different variations of really a transaction that would change the ownership structure, a transformative transaction. And so we first need to ask whether the financing transaction qualifies as an acquisition subject to the provisions of this section. Perhaps I can, I just want to make sure, Ms. Lecoq, if I haven't answered your question, I really want to make sure I'm clear. May I take another stab at it?
Yes, please.
Okay, so if we're just looking at how 62612A3C is written, the first thing that you see here is the entry point into the statute. When does it apply? And it applies for the purposes of any acquisition subject to the provisions of this section. That's when it applies. So then the threshold question for the commission to consider is the financing transaction an acquisition that's subject to the provisions of this section? And it's not, because at the time that the financing transaction closed, Blackstone did not take control of TXNM. There was no acquisition of TXNM. The acquisition is in the form of the proposed merger, which is in front of this commission for approval. So this is not a case where the actual acquisition, subject to provisions of the section, isn't coming before the commission for approval. It is. The merger agreement is, of course, subject to the express regulatory approval of the commission. The issue with applying A3C to the financing transaction is that the financing transaction is not an acquisition subject to the provisions of this section. Now, if you're sort of turned around with this, I want to acknowledge that we have dug into the statute, we have briefed it, we have digested interveners' arguments. And so, like you, we have spent a lot of time grappling with the language of this statute. And what has struck us is that this prefatory language for the purposes of any acquisition is not it does not say for the purpose of any acquisition. That is to say that the statute isn't about a subjective intent motive, like what was my purpose, what was my intent. The statute is about whether the financing transaction itself was an acquisition subject to the provisions of this section. With that said, when we look at the purpose of the subjective intent of the parties in connection with this acquisition, there has been testimony that has come in that Blackstone and TXNM signed it as a separate merger, as two separate agreements, that they considered it to be two separate agreements. Certainly, the evidence is that if the merger agreement is canceled, the financing transaction survives, the 8 million shares are still Blackstone. Those two separate documents say that they are not a single transaction. I am not here to contest that or to argue that the financing transaction and the merger agreement were completely unrelated and uncontested and unconnected, but that is not the commission's inquiry. The commission's inquiry should be whether the financing transaction is an acquisition that was subject to the provisions of this section. With that, I can now turn to a discussion of the word stock as it's used, unless you would have any more questions on this point. And I'll also stop sharing. Oops, I apologize.
That was my only question. Yeah.
Okay, great. So I'd like now to discuss the word stock as it's used in 62.6.12.3. And so if the commission concludes that the financing transaction is somehow an acquisition, subject to the provisions of this section, the question becomes what the word stock in subpart 3 means. And on that question, Prosperity Works interpretation produces results that are so at odds with the statute structure and purpose that it respectfully cannot be correct. So again, if you look at the language of the statute, stock is undefined. So we need to read stock in context. And stock needs to be read consistently across all the subparts in A3. Subparts 1 and 2 regulate transactions that result in the formation of a new concern. These are transformative changes in ownership and control of regulated entities. One talks about any two or more public utilities may consolidate or merge with each other so as to form a new concern. And 2 is any person and a public utility or public utility holding company may consolidate or merge with each other so as to form a new concern. So then we get to subpart 3. The legislature included it on the same list because it regulates the same category of outcome, changes in ownership and control, but now achieved through a stock purchase. Now, Prosperity Works interpretation requires reading stock to mean any amount of stock, even a single share. But that severs subpart 3 from the structure of the statute, which is addressing these transformative changes in ownership and control. As you know, in the case law, statutes are to be read in a way to facilitate their operation and the achievement of their goals. So if we look, what is the purpose that the Public Utility Act is trying to accomplish here? As was discussed with Mr. Binns, is it lowering the cost of capital through regulatory devices, or is it increasing the cost of capital? Because if the commission adopts the interpretation the interveners want, the regulatory regime would increase the cost of capital with no commensurate
What are you relying on in your argument that the purpose of the Public Utility Act directly relates to an increase or decrease in the cost of capital? Can you walk me through that a little more slowly?
Sure. I mean, I'm just thinking about what the declaration of policy of the PUC is. So under 62.3.1, where it says that the declared policy of the state is that the public interest, the interest of consumers, the interest of investors require regulation and supervision, and it's to 2 ends. Reasonable and proper service shall be available at fair and just rates, and to the end that capital and investment may be encouraged and attracted. And so certainly in order to encourage and attract investment, it is important for for TXNM to be able to do that without increasing or without having a burden on the cost of raising that capital that is unnecessary.
Thank you.
And so that's one thing in terms of sort of how stock fits into the overall purpose of the statute. And then the commission also has to grapple with the fact that stock must mean the same thing for all subparts in A3. As we discussed today, the commission has never interpreted stock to cover non-controlling share purchases under any of the subparts of A3. And the case law does say, and I believe Mr. Binns agreed, that it's considered normal statutory construction to interpret identical words used in different parts of the act as having the same meaning. So then if we look at what ACA says, it would require prior authorization of the acquisition of even a single share of TXNM. If you read stock to be read as Prosperity Works interpretation requires.
Council, how does this definition square with this phrase in section A3A, which says any such stock or part thereof? Doesn't that imply that it doesn't have to be a controlling amount? That it said specifically in here that a part thereof?
So actually, I think that the conclusion that should be drawn from that language could be the opposite, because what 3 is referring to, just subsection 3, it talks about stock of a public utility or public utility holding company. And then when we get into A and we're talking about who can acquire it, we see that it's any person who prior to the acquisition of such stock or part thereof. Such stock is referring to stock as it's used in part 3, stock of a public utility. And it's acknowledging in the language of part A that such stock would mean all of it, because or part thereof must mean something smaller than all of it. So our position is that that's further support in 3A3A, that stock as it's used in 3 means all of the stock, such that when you get to A, they're talking about an acquisition of all of the stock or part thereof. If it didn't have that language or part there, or maybe I should say it this way. The fact that it includes the language or part thereof after referring to such stock, which again refers back to A3, would indicate that stock as it's referred to in A3 is the whole, and any part thereof in subpart 3A is less than the whole.
How do you explain the fact that, as we see in your arguments and in reading the statute, the legislature had every opportunity to include a clear-cut, they could have written into the statute what you are inferring from the language. And I'm curious your thoughts about why you think that is not included and what the purpose would be for leaving it out.
So I actually think that the A3C can help us understand perhaps why the legislature moved away from a hard and fast rule and instead went about this a different way. And that's because,
but to be clear, you're advocating for a reading into it as the 10% is a hard and fast rule or the controlling interest. So you're asking us to infer a hard and fast rule.
Well, I think that I don't know if I would say 10%, but I am asking you to infer control. That's correct.
Understood.
That's right. And I think perhaps a reason we can see why they may have decided not to have 10% is because if you look at what's going on in A3C, I think the concern that they're talking about there is if you are in the world of an acquisition that's subject to the provisions of this section, right? So it's for purposes of any acquisition subject to provisions of this section. We could imagine a world where that acquisition is being effectuated by multiple investors, each of whom buys several small pieces of the company. So perhaps you have 20 investors that are each buying 5%. None of them alone is going to get us to control, but an acquisition is actually occurring. And so they're saying that it's important in a scenario where those folks are acting in concert with each other to effectuate an acquisition that's covered by the section, that you get prior approval, even if each one is only getting 5%. And the hard and fast rule of 10% would make it difficult to cover that scenario. So I think they were broadening the scenarios in which control could effectively happen to make sure it included an acquisition with multiple investors who together are taking over TXNM. The other point I want to just briefly touch on is that the interpretation that's put forward by Prosperity Works, which would require prior authorization of even a single share of any entity that's affiliated with or is a public utility holding company in any jurisdiction, does lead to the absurd result that we spoke about today, where two of the largest shareholders of TXNM are classified as public utility holding companies in a jurisdiction. And so that reading would require the commission's approval over those purchases. Mr. Terry testified that if there's no... Yes, Mr. Schaefer.
Sorry to interrupt. Don't mean to interrupt your flow. But I just want to focus on that for a second, because this case that you're raising right now, isn't it distinct that those large shareholders in TXNM did not purchase those shares for purposes of the acquisition of TXNM?
I agree that they did not. Our statutory interpretation that we've suggested to the commission would have the threshold question again be whether the purchase of shares constituted an acquisition, because you only get into the prior approval where it is an acquisition subject to the provisions of this section. And so just like those transactions that occurred with Vanguard or with BlackRock, no commission approval was required because they did not effectuate or constitute an acquisition. And similarly, none should be required here. But if you were to potentially read the statute as as Prosperity Works suggest, then you could end up in a scenario, and I would say the scenario would be not under A3C, but under A3A, that any person prior to the acquisition of such stock is now required to get commission approval.
And let me just ask a follow-up, Ms. Rotman, if you would allow me. If I'm understanding your argument, is that you're attempting to say that the interpretation of stock here in this statute means controlling interest, correct?
Correct.
Or
I guess maybe I want to be a little more precise, that it is the acquisition of stock that confers control over the company. And I don't know, that might be distinction without a difference, but yeah, I'm with you. Control.
Okay.
And
well,
I don't mean to interrupt. We don't have an on-screen timer. You have about 3 minutes left of your 25.
Thank you. I'll just ask this last follow-up question. I'm just wondering, I mean, do you see this clause for the purpose of any acquisition pragmatically, or in a practical business context where the issue isn't whether the amount of stock is 1% or controlling or provides ownership, but that if those transactions are done so for the purpose of an acquisition, that it would require prior authorization?
Yes, I think if I'm understanding your question, I think if the acquisition of stock constitutes an acquisition, if that's what's happening at the time that the stock is acquired, then it requires commission approval.
Yeah, let me ask finally, just ask everybody's to indulge me in my question here briefly. I guess what I'm asking is, couldn't you foresee a scenario where an acquiring company and a company that is to be acquired could fashion a transaction to their needs and interests, such that they could exchange or purchase shares that might not result in control, but that it is part of a larger transaction to facilitate that acquisition?
Yes, I could imagine that.
Thank you.
If I may even briefly say, I don't think that the statute applies in that scenario. I don't think that we're looking at what might happen in the future or what future plans are, because I don't think the statute requires that. I think the statute that we have been focused on, A3C, first wants to know, are you in acquisition subject to any provision of this section? If that's what we're talking about with the transaction, regulatory prior approval, absolutely required. If it's not, it can move forward without approval. Thank you.
Thank you.
Mr. Gifford, there's 11 seconds left. Ms. Rock, very helpful. But would you still like to use that 5 minutes for rebuttal, sir, or would you like to take it now?
No, I think we'll hold our fire till the last 5 minutes.
Thank you, Ms. Rotman. That was quite helpful.
Thank you.
All right. And who is going to be speaking on behalf of Prosperity Works?
I'll be arguing on behalf of Prosperity Works.
Okay, just give me a moment to reset my timer. And again, apologies. I know when you're in court, you have everything in front of you to count your time down. And next time, hopefully, we'll have that technology.
Maybe you could have a 5-minute warning emoji floating around.
Good. Well said. All right, whenever you're ready, sir, I'll start your time.
Okay, thank you. Madam Hearing Examiner, Examiner Schaefer, thank you for taking the time to hear these arguments and your attention to this. Let me start by responding to some of the things Ms. Rotman said, and then I'll talk about the things that I wanted to talk about as well. I have to confess that in order to counter an argument, you have to understand it first. And I was not fully understanding the argument that was made, which I think in and of itself is an issue. I think the joint applicants are making this a whole lot more complicated than it is or than it needs to be. And this is really a pretty clear statute that's pretty easy to interpret, that doesn't need to go into different colors and different word orders and things like that to understand what it's trying to do. Let me start by, talking about the word stock. It's not vague. It's not ambiguous. It's like, I was thinking about this and, you're a parent and there's a bowl of candy on the table. You're getting ready to leave. You tell your kids, don't eat the candy without my permission. And you come back and some of the candy's gone. And you ask your kids about it and they say, well, you didn't tell us how much not to eat, so we just ate a little. That just doesn't fly. And that's kind of what's going on here. In regard to
Sir, can I just ask you before you go on then,
Sure.
how do you, if that's true, then what part of the statute then prevents the absurd results that Ms. Rotman and the joint applicants have been stating could
Sure.
happen? What keeps us from going there?
The one share purchase that triggers the commission to take up whether or not one share should be bought or not. I think it's the nature. So the way we read the statute is it's not a level of stock that triggers the commission's oversight. It's the nature of the participants in that transaction. Are they holding companies? Are they public utilities? Or are they working with holding companies and public utilities? And typically what you're dealing with are private offerings like this one, where a person is acquiring stock, working with a utility or is a utility or holding company, and in this case, for the purpose of an acquisition. That itself, as we've heard, is a very limited occurrence. This may be the first time in New Mexico that a potential acquirer of a company has purchased stock in advance during the course of a merger or an acquisition. And so I think the limiter there is one of practicality, that, a company like Blackstone is not going to come in, work with a public utility or a utility holding company and get a private offering for one share. That's just not going to happen. So I think that concern is way, way overstated. That's not the kind of thing the commission is going to be dealing with. As far as acquisition, I think the argument Rotman was making, I'm not sure, was that because there has not been an acquisition yet, this can't be a part of or for the purpose of an acquisition because the acquisition doesn't exist. And if I got that wrong, I apologize. But if that was the argument, I think it's misconstruing what an acquisition is. An acquisition is not just a single point in time. It is an effort over time to acquire a company. And we're in that time period where the joint applicants are in the process of acquiring TXNM or trying to acquire. They're getting various approvals. They're going through a variety of steps to do that. Ms. Roman or the joint applicants, presented this kind of word rearrangement of the statute to make a point that, well, this is the first step and this is the second step in determining whether the statute is triggered or not. Well, what I would say is word order makes a very big difference. And, I recall, an argument Abraham Lincoln made like 150 years ago in response to that type of argument. And what he alluded to was, hey, there's a big difference between a horse chestnut and a chestnut horse. Word order makes a big difference in what you're dealing with. And I think rearranging the words that, as the joint applicants have done, may allow them to make a different argument than they might otherwise make. The word order here is important. Let me just think if there, with regard to stock and the all or part thereof, I think, and we said this in our briefs, that the part thereof, again, contemplates that a person acquiring or purchasing stock may not do it all in one single tranche. There may be several tranches or several instances where that stock is being purchased over time. And I think that's what that language in the statute is referring to. So now I'm going to go to the argument that, that I had prepared beforehand with a discussion. And I'm not going to take a lot of time here repeating arguments we've already made. Mostly, I hope, I can answer any questions you may have. I think that's the most important thing. But I will take a few minutes to make just a couple of points. Whether 612 A3C has been contravened by virtue of the Topco stock purchase has been briefed and argued extensively, and I'm not sure there's much I can add to things we've already said. I would point out, though, that a control threshold, as the joint advocates are suggesting, would be much more subjective and uncertain than the plain language of the statute, which we think establishes a pretty clear demarcation for when pre-approval is required. And that's based, as I said, on the nature of the purchase participants, not on the amount of the purchase, which of course is going to be relevant in determining whether or not approval should be granted or not. But it can't be relevant in whether or not approval should be sought or not, because as Mr. Binns testified, if that's the case, you're never going to get the chance to evaluate whether there's been a change of control or any other potentially adverse consequence of what's being proposed. I would, though, like to highlight another issue here, which has been discussed a bit, and that's the separate basis to determine that the purchase is void and of no effect, and that's under 62612B. And all you need to do there is look at page 29 of the proxy statement, which is Exhibit D to RJB3. And it says the Topco purchase of 7.6% of the company's shares and the Zimmer purchase of 3.4% together amount to 11%. And those shares are pledged to vote on everything as the board of directors instructs. In other words, the TXNM board of directors has been given a controlling interest in TXNM. And if you want to use the definition of control in 6233, which we think is directed toward affiliates, but regardless of whether it is or not, that control statute would say that this particular combination of transactions, Zimmer and Topco, have vested control in the board of directors that was not there before, because they are controlling the votes of those voting shares.
So, counsel,
yes.
Can you clarify? So this is the part that says that the transaction shall be void and of no effect.
Yes.
We did hear some discussion about what that would look like, but I think one of the major concerns is if we were to, if the commission were to interpret this statute in the way Prosperity Works is asking the commission to, what happens? What are the legal ramifications of this if this is voided of no effect, and what, if any, is the remedy? And we heard some remedies from the joint applicants, but what is your thought on what happens here?
Yeah, so, and I was going to get to that to some extent, but let me try and answer your question directly. So and I guess what I would say is, the commission should do exactly what the statute instructs needs to be done, nothing more and nothing less. The statute, if there is indeed a contravention, my interpretation is that then, as a matter of law, that stock purchase is void and of no effect. And that is the outcome that we're talking about, I believe. And what we would suggest there is that void and of no effect means basically what I went through with Ms. Kelly earlier. It's of no effect. It's as if it never existed. And it's
But if that, we did also hear that if that's the case, then essentially the joint applicants stated that then Troy Top Company, whatever the company is, would essentially become a creditor then for TXNM, and then TXNM would have to pay it back. Is that harmful? Isn't that harmful ultimately to New Mexico? The commission has to take things like that into consideration.
well, it is, I think it's right that TX New Mexico would need to repay that $400 million. Presumably, they would go out and borrow the money to do that. Since they used the 400 million to some extent, maybe a large extent, to buy down debt in the first place, the level of debt they may have, it may be no more or very little more than they occurred originally. If the joint applicants choose to, they can go back and start over. It's not the end of, it's what we had kind of hoped they would have done as soon as we filed, was just say, okay, let us fix this, but that's not where we're at. So what does it mean? It means TXNM goes into the debt market and borrows the amount they need to pay back Topco. And at that point, the joint applicants, if they choose to, can figure out a plan B, which may be, okay, let's do this stock purchase, but let's come before the commission first and get approval before it closes. That's not a big deal. You put in the stock purchase agreement, this is subject to commission approval, which needs to be obtained by such and such date, and you're done. And, so what does that mean? That if that's the case, and that's the outcome and the process that the joint applicants use to remedy this, you're talking about them paying the carrying charge on that debt for however long it takes for them to renew and complete the transaction. Whether that'll happen or not, that's up to the joint applicants. I can't, and I don't know that the commission can dictate that they go back and do one type of business transaction for another. But that's certainly an option. I don't know that the commission can really micromanage what happens if the transaction is void and of no effect. I think at that point, the joint applicants need to work out how to deal with that and report to the commission. And as Mr. Bin suggested, and we agree with, if there is a harm associated with that or a cost associated with that, that needs to be borne by TXNM or the joint applicants. Ratepayers should not be held harmless, or they should be held harmless from the consequences of what we think was a pretty easy statute to interpret. A first-year law student could look at that statute and say, okay, I'm buying stock, I'm working with a holding company, I'm in the midst of an acquisition, and they've asked me to to purchase this stock as part of that. It's not rocket science. You look at the statute, and it's pretty obvious what you need to do. And even if it's not, it's at least obvious that you go to the commission and say, hey, please give us approval if we need it, or please tell us whether we need approval. I mean, all those things could have been done, and none of those things were done. Is that I'm not sure I answered your question. I tried to.
Yes, thank you, counsel.
Okay. So, as I said, our position is the commission should do what the law requires, not more, not less. And to Prosperity Works, that means two things. First, it must decide if the stock purchase contravenes 62-612. And that's been heavily briefed, and I'm not going to repeat all those arguments. But if you do that, then as a matter of law, that purchase is void and of no effect and should be treated as such. And then second, a finding of statutory contravention means that because the stock purchase was so intertwined with the merger and the merger agreement, and as Mr. Binns testified, the word stock purchase appears over 70 times in the joint application. It was part and parcel of this transaction, and this merger. And because of that, the application itself is unlawful and should be denied pursuant to 62-613. I don't think you can say that, well, just this one part was unlawful, so we can approve everything else. There's an application with a particular outcome here, and it includes a number of components. One of those components was the stock purchase. And because that stock purchase was unlawful, I think the merger application itself needs to be denied. Whether or not, the joint applicants come back with a new application, that can be dealt with if and when that happens. And I guess one other thing I would say is that, I certainly understand the importance of the public interest and considerations of that and what the implications of, different commission decisions may be. But it's also important to recognize that public interest is not a carte blanche to ignore statutory directives. And here we have very clear statutory directives. The legislature has said, if this contravenes this section, it's void and of no effect. It doesn't give the commission, in my mind, discretion to say, well, no, maybe we can approve it later, or maybe we can, declare it not void or come up with some other remedy. And I would caution against the commission, as I said, trying to micromanage what the outcome of that particular decision may be. It, in my mind, is going to work itself out. The joint applicants are very sophisticated. They know how to protect their businesses. And that is my guess as to what's going to happen. Now, as far as the remedies the joint applicants propose, we think they're both, one, illegal, and two, not in the public interest. As far as the non-pro-tunc or after the fact approval suggestion goes, not only does it render the prior express approval language of the statute meaningless, but it also misuses that tool. Non-pro-tunc is for clerical errors and the like. It's not to absolve substantive violations of law. The failure to seek and obtain approval before closing the purchase was a violation, and it cannot be cured by pretending something was done that was not done. With regard to the option exchange proposal, perhaps there is some way to fashion an alternative like that might comport with statutory requirements. The one that the joint applicants propose, though, does not. As Mr. Binns testified, claiming that an exchange option agreement is somehow different than a stock purchase, even though it has the exact same financial outcome, but for $800. And even to the point of assuring the dividend payments made by virtue of that stock purchase are preserved in the exchange option is simply condoning a fiction, and it's just bad policy. And if the result of this investigation is to find a violation and then to allow a remedy that accomplishes the exact same thing as the violation, I think it begs the question of why did we bother with all this? It doesn't serve anyone well in the long run, in our mind, customers, investors, or regulators to sanction this kind of scheme, and by that I'm referring to the option exchange agreement, is a way to undermine statutory obligations. And we'd encourage you not to go down that path. So in sum, for purposes of this proceeding, we think two issues need to be resolved. One is the stock purchase agreement contravening 62.612, and therefore void and of no effect. And then secondly, if that is the case and the stock purchase is unlawful, because it is so, we think it is so intertwined in this merger proposal, is the merger itself unlawful and therefore should be denied. Beyond that, we think it would be important.
I don't mean to interrupt, but walk me through how, one thing that does seem to be clear is that if the merger did not proceed, the stock transaction would not be void. So in that way, it's one of the questions before us is how they're related, but they're not contingent. So I guess walk me through how you get to the point where you would then declare the merger itself illegal and needing to be voided.
So the language of the statute is not for an acquisition, it's for the purpose of an acquisition. That's a statement of intent. And so here we have a merger proposal before the commission. That is a very real thing. It's not non-existent. The stock transaction, the joint applicants, Topco in particular, entered into that transaction because they were told to by TXNM. If you want to bid on this acquisition, you need to also agree to purchase $400 million of stock. And so that stock purchase was pretty clearly, in my mind, done for the purposes of an acquisition. Whether or not that acquisition is ultimately approved or denied, I don't think matters, because what you're looking at for purpose of acquisition is an intent issue, not a factual issue, if that makes sense. I think that gets to your question.
That's helpful. Thank you.
Okay.
So if the commission adopts Prosperity Works' interpretation of this statute, does that render prior stock transactions void as well? And I'm asking particularly about the ones that were discussed, the BlackRock and Vanguard. Does it have other ramifications aside from just here? And I'm asking part because it does seem like it's an automatic, it would be an automatic trigger in the statute that suddenly it's void and of no effect.
Well, I'd say a couple of things. One is, that hasn't been fully vetted in this case. This case has been related to a different transaction, but I understand the point of your question. And, one thing I would also say, and this is, regarding some of the questions Hearing Examiner Schaefer asked is, even under the joint applicant's interpretation of 62.612, those two entities have more than 10% of the voting shares of TXNM. So you're in that bucket no matter which way you interpret this statute, even if you accept joint applicants' interpretation. Is that an absurd result? For that particular, and I think we're talking about Section A there. Perhaps it is, and perhaps that needs to be interpreted in a different manner, but that's not before you right now. I understand, the need to think ahead. But to answer your question directly, I don't know how that would play out. Hopefully it would not be too disruptive, but I think, perhaps at some point, the commission should, develop some rules around that particular part of the statute to provide some guidance as to whether or not that applies to situations like Vanguard where, while they may be registered as a utility holding company, in essence, that's not their main line of business, and that's not essentially, the nature of that company. But that's, I think, decisions and processes for another day, I would say. Sorry,
Okay.
I can't give you a better answer.
No, that's helpful, Council. Thank you. I just want to just very quickly just clarify that Prosperity Works is saying that the statute only apply, this particular part of the statute only applies to these mergers and acquisition matters and not to any stock purchased by a utility or one affiliated with a utility. Is that correct?
Could you repeat, somebody was calling me and could you repeat the last part of that question?
Yes, I just want to make sure that the interpretation that you're asking us is, or you're asking the commission to adopt, is that the statute, this provision in the statute only applies to mergers and acquisitions, or is it any stock purchased by a utility or by one affiliated with a public utility?
No, as I was saying, what we're asking you to do, the commission to do here, is deal with the particular transaction that's the subject of our show cause motion, which is a purchase of stock by a person working in concert with a utility or utility holding company for purposes of an acquisition. While these, other side issues are, certainly, things to think about. I don't think those need to or should be decided in this case because, they haven't been fully vetted.
Okay, thank you, Council.
Sure.
Mr. Michael, you've got about 3 minutes left.
Okay, that should be enough. All I was going to say is the other things that we would ask the commission to do, if you do agree with Prosperity Works interpretation, is one, require the joint applicants to report how they intend to render the stock purchase void and of no effect, and recognizing that the exchange option agreement they've proposed does not do that. Second, open a further investigation into whether the Zimmer transaction is also void because it, along with the Topco purchase, created a controlling interest in TXNM's board of directors. And then third, order an independent audit to assure PNM customers are held harmless from the consequences of the statutory violation. And that's really all I have to say. Really appreciate your indulgence and your attention to this issue, which is really very important.
Thank you, Mr. Michael. All right, the joint applicants have 5 minutes for rebuttal, and is that going to be provided by Ms. Rotman or Mr. Gifford?
You're going to be stuck with me, Your Honor, and unlike with Ms. Rotman, who is a real lawyer, you're going to find out very quickly I'm something slightly less reputable, a regulatory lawyer who swims in the seas of the public interest as opposed to hardcore statutory construction.
All right.
I think we just learned.
Do you want me to start your time?
Please do.
All right, go ahead.
I think we just learned something quite significant from Mr. Michael during his argument, particularly that last discussion he had with Ms. Lecoq, where she asked him, how should we interpret these other parts of the statute? And if I heard him right, I think what I heard him say was sometimes you have to depart from the plain meaning of the statute when the repercussions of that interpretation cause problems or don't yield any discernible benefit. Now, one of the things that has troubled me since this issue first arose and just been a question in my mind is how is a low-income advocacy group harmed by the pipe? Now, to be sure, the law is the law, and all public utilities in New Mexico are bound to follow the law. And as I think you heard today from Mr. Terry, from Mr. Sherman, that we are endeavoring our best to follow the law by our lights and by our interpretation. And of course, if that interpretation is proven wrong, we are eager to find practical remedies to that. And so with that, I would offer kind of three prisms for the commission to close in thinking about this.
Wait, before you do that, I feel
Yes.
like you started to say something and didn't finish. What's the significance of the nature of the party who brought this to our attention?
Well,
and what they do?
what's interesting is what Mr. Michael has just told you, I think, is that he wants everything to start over, and his dominoes falling are, if the pipe violated the law, then the application needs to start over. And it gets to, I think, what the purpose of this was kind of a side door motion to dismiss 6 months after the application was filed. Now, that's fine. Every party has that right, and I'm not going to question that. What I do think we have here at this record now that we've developed today and you've heard about today is some opportunity to explore practical solutions to this issue. The first set of practical solutions come to us in things that are offered by the NMDOJ and staff. And NMDOJ, I think, has offered its thoughts on what might solve this problem and solve it. Staff has offered the precedent that this commission has looked to before when it confronts construction of 62-612. And when I read things like the Raton natural gas case, the water case, what I see is the commission looking for a practical solution to a real conundrum. I think the second place the commission can look at, and I think they now have a sufficient record to make this conclusion, is the factual conclusion that this pipe was not for the purposes of any acquisition. You heard from Mr. Terry, he had two goals in mind and had two separate agreements to effectuate those separate goals. You heard from Mr. Sherman the same thing. Does that mean they are not related? No, they may be related, but factually they were for separate purposes. One to finance the company, the other to effectuate the acquisition of the company.
Do you think a witness's subjective interpretation is more powerful than contemporaneous evidence in determining that?
But by no means, Your Honor. I think it's indicative, but certainly not dispositive. I think you have some other indicia that these were for separate purposes, among other things. If this merger were to fall apart for whatever reason, Blackstone still owns 8 million shares of PNM regardless. It's a standalone transaction and was signed as a standalone transaction. I know that to date that dog hasn't hunt for us, but I do think you now have a robust enough record. Finally, I would say, as I discussed with Mr. Binns, we interpret regulatory statutes to accomplish beneficial purposes of the Public Utility Act as a whole. I think if you do that and look at it through this lens, interpreting this statute through the lens of a plain language doesn't yield any benefit to the customers of New Mexico. It doesn't yield any benefit to the utilities of New Mexico. And it doesn't serve the regulatory ends this commission exists for. And with that, I think I'm over time because I did set an internal timer, but wanted to close with that and urge the commission that they have multiple off-ramps here. We are, as we've said, eager to find a practical solution to what has become a real conundrum for all of us and wish that hope the commission can find that path for us as well. Thank you.
Thank you, Mr. Gifford. Ms. Lecoq or Mr. Schaefer, do you have anything else you'd like to ask the attorneys while they're still in front of us?
No, just to express my thanks for their time and commitment to this proceeding.
Exactly the same. I don't have anything else. Thank you very much.
Yeah, and I'd like to express the same thing. We really appreciate the amount of time, effort, and thought. As I said a few days ago, this issue has been explored to within an inch of its life through briefing and testimony. And we have quite a bit of good information now that we can bring to the commissioners when we make our recommendation. We are just about at 5 o'clock, and we want to let Ms. Gonzalez go at 5 because she's had a long day. We will be issuing a briefing order. I don't know exactly the nature of that order. However, as was previously stated, both on and off the record, we do intend to allow parties who were not directly involved in the proceeding today to brief legal issues if they feel that that would be helpful to the commission, and as is their right to do so. Hearing examiner Schaefer and I will try to get a briefing order out with a timeline, any particular subjects we want explored, etc. to you, I think by mid next week, realistically. The joint applicants did graciously offer to pay for an expedited transcript, which means that Ms. Gonzalez will have it for us within 3 business days. And aside from that, I see Mr. Michael has raised his hand. Do you have a question, sir?
Yes, with regard to the post-hearing briefing, certainly it's your prerogative to fashion that however you like. It would be helpful to us as a party if the hearing examiners or commission have particular issues that they would like to see briefed. It'd be helpful to us because we briefed this a lot, as you know. So if there are issues that we can be particularly helpful to you, that would be helpful to us to fashion our brief to respond to those.
Sure, we'll keep that in mind. And as I think I also said off the record before we started today, normally, as you can see, this is a discussion that we have with the participants at the end of the day. Parties who are not directly participating right now are welcome to send any thoughts or ideas, such as what Mr. Michael just said, to the hearing examiners, as long as everybody is copied on that email, and we'll take anybody's thoughts into consideration as we draft the briefing order. Mr. DeSalen, do you have your hand up?
Yes, thank you, Madam Hearing Examiner. Just a similar question to Mr. Michael's question. Do you envision, and you may not be able to answer this yet, but do you envision that the briefing schedule is going to be on an expedited schedule or more along the lines of what the rules would require?
No, I'm not quite ready to answer that question right now. Like I said, we'll
Okay,
endeavor to get
understood.
the order out as soon as possible so that everybody has the maximum amount of time that they.
Okay, understood.
Hearing examiner Schaefer, is there anything else that I've missed before we adjourn for the day?
I don't think so. Just to reiterate on behalf of the commission and all parties, I wish to express our thanks for the time you all took to participate today.
Yes, I echo that. Thank you very much. I know that this has been a great deal of work for everybody involved, so thank you. And if there's nothing further, we will go ahead and adjourn and be off the record. Thank you all and have a good evening.
Thank you.
Thank you.